Happy birthday.
Sir, you're
You look
charged with
good.
especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their court.
The fireworks are not done.
Now we're getting commentary on the camera. Dahil mihi Anglican for you, service looking. I didn't ask you to interrupt.
Is that correct?
Literally not true. Oh, for Trump's sake.
Good morning, good morning, good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. It is absolutely great to be here this morning. I hope you're having a fabulous one. As I'm solo right now. My whole family's gone. It's just me chilling. Being the Amazon delivery guy that keeps dropping stuff off at the door. So apparently we ordered some things. So yeah, that happens. Welcome. Sorry for being just a little bit late. I have no excuse. I wish I could say, I had to help Mrs. Ari get out. No, she left at 5:30 or something, 6. She was out here way early this morning. I slept in, and it was beautiful. It was wonderful. How did the packing go? Mrs. Ari has packed all the clothing stuff. I'm still working on packing the rest of the stuff. But we've got a ton of stuff to pack before we're ready to go and ready to just hit the road and zip out. But that's going to be tomorrow. Today is today. We've got oh my goodness, I've got batteries charging everywhere. Like if the power guys are looking at who's using most electricity to try to find like indoor pot farms, they're going to like circle my house today. Because every outlet has something plugged in charging and drawing up to about 1,000 watts at a time. I'm pretty much cooking the electricity grid today. Greeners, congratulations. First in chat, my friend. The internet is all yours today, Greeners, but it's been all yours for a while. So this is no change for the rest of us. Just keep doing what you're doing. Thank you for being first in chat. You are once again the winner. And look at this. Oh, my goodness. Sheena, sober 80 days today. That is awesome. We get a... Oh, that was loud. Sorry, Sheena. That was super loud. What a wonderful day. Celebrating 80 days. I mean, of all the things to celebrate today.
Mike. What day is it, Mike? Guess what today is?
It's hump day.
Hump day! Welcome to Wednesday. I don't even have a kid here to celebrate with me. It's hump day. It's hump day. We made it halfway through the work week. Red Pen, you can unmute now. Thank you. Greeners. For those that are new, Kimby, we celebrate every milestone. Congratulations. Great 80 minutes. Thank you very much. Every milestone. All right. Sorry, Sean. Rest in peace, eardrums. That was a solid 9. Not bad. I'll take a 9 today. I really will. Samantha's like, dang, I have neighbors now. You got to keep it down. Sorry, but you knew it was coming. I mean, at this point, unless you're brand new here, you had to remove one earbud for that. Awesome. My left ear just left my head. It's hump day. It's Wednesday. We made it halfway through the work week. This is my Friday. We just lost 1,000 subscribers, says Josh. This is my Friday. I am going on a trip to Virginia to film a period reenactment. I've got everything ready. I've got my straw hat ready. Here's what I haven't done. I still need an extension cord. I need that fan. I need I have a list. Permethrin. I need to spray my clothes with permethrin, bathe in it basically, because ticks are a thing, and I don't play that game. And then just the small things. I need to install a bike rack on the car, install the satellite, the Starlink. Sorry, Elon, got it wrong. On the car, get everything wired and configured, get the seats taken out so I can actually sleep in the thing. Just small things that are going to be happening this afternoon or this evening, as the case may be. Greeners, I cannot even click on that. You are running for the line today already. Might be verdict day, but before we go to verdict day, we have to just say, before we go to court, which has not yet begun, we need to celebrate birthdays, and we need to celebrate everyone's birthdays who are now till Sunday, or if we miss you, we can sing on Monday. But that's all we can do. I need to plug that in. I'm missing some plugs.
Happy birthday. You look good.
Okay, as we're getting set, I'm just
There's nothing in the order that restrains you from talking to cats.
trying to pick up cords with my toes from the floor. There we go.
I'm not a cat.
All right, now we're not going to lose our batteries during the rest. So I will be in Virginia Thursday and Friday. So no live stream Thursday and Friday. That's why we've asked the court, sent a special note, said, can you just hurry and get the verdict in today? That would be great.
I'm not going to argue about semantics here.
I didn't get a response, honestly. No, we did not reach out to the court. We'll see. We'll see what happens. But anyway, I'm going to be gone. I'm going to be taking, I believe, last count, 1, 2, 3, 4, 5. I'm taking 6 cameras, including the drone. I'm going to be filming up in the boonies on some private property. And it's going to be great. It's going to go well. Everything I planned is going to work out. I've got my fingers crossed because I just can't handle the stress of the idea of something going wrong. I've got radios, everything. I've got everything set up. The radios are programmed so that everyone can talk to each other. We've got repeater issue things set up. It's good. Are you sure you have enough cables? I have not taken any cables yet. Believe it or not, I need to still pack cables. That's a small thing because I don't need many. I only need charging cables because I'm not doing anything really live. All right, let's do the birthdays because we're gonna run into court here really quickly if we don't. Do we have any birthdays today? Camilla, I've also petitioned the weatherman to just reroute any storms around Virginia. I could do with a 0% chance of rain for 3 days. That's all I ask. Just 3 days, no rain, and then that's good. Colleen, Itchy Withers, Horse Rescue. I will see what we can do. I don't know if I can get to it today. Don't forget batteries. I don't need any like Duracell batteries. So it's all. Let's see. BG says my son Scott is 30 today. We're going to add him to this list if that's all right. Thank you very much for this, Josh. I'm going to add. This is going to be a big one. Okay. Copy. I think I can do this, Josh. I'm on it, like Blue Bonnet. We're going to add Scott right here with 1 T. There we go. And I think I did this right. Maybe. I think I got everybody. All right, we need to sing. Here we go. All right, everyone, stand up, take your breath, shoulders back, project your voice to the room, back to the room, blend your voice with a neighbor. Warm up with me, if you will. La 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 la. Can we take a deep breath as well? Okay, we're all ready. Here we go. Oh, we've got a ton of names. 2 verses for sure. Happy birthday to you. Happy birthday to you. Happy birthday, dear Ann, Ashley R, Thomas P, Heather, Shaylin, New York, and Ruby Rose. Happy birthday to you. Well, that was Sheila in New York. I'm sorry, I said Shaylin in New York. Sheila in New York. Ann, Ashley R, Thomas P, Heather, Sheila in New York, Ruby Rose. Next, we're going to do Lily Rose, Little Lulu, Melissa K, and Alison Jones. Ooh. Happy birthday to you. Happy birthday to you. Happy birthday, dear Lily Rose, Little Lulu, Melissa Kay, and Alison Jones. Happy birthday to you. This verse I'm going to sit out just for a little bit because I need a breath. We only have a minute before court starts. Last one. Oh, this is the interlude. I probably should have sung that one. Go shorty, it's your birthday. Yeah, okay, here we go. Martine, Scott, and Cody. Happy birthday to you. Happy birthday to you. Happy birthday, dear Martine, Scott, and Cody. Happy birthday to you. There we go. Rocket the Dog is 8. Happy birthday, Rocket the Dog. Did I just hear 50 Cent? He chimed in briefly. To everyone who celebrated the birthday, thank you very much. I realize there are a million places you could be, a million people you could have celebrated with, but you chose to be here with us. The privilege, the pleasure, the honor is ours. Hopefully we can take the joy we get from you being with us and return that joy back to you, make your day a little more special, or help yourself to free pancakes at Denny's, IHOP, Village Inn, Waffle House, McDonald's, Tammy Dunlap's house, Andy's Grill, and Bob Evans, and possibly Cracker Barrel. Whew. All right, drum solo coming up. All right, we get the full drum set today. I do the snare with my left hand. Hi-hat on the right. And you bet my feet are going too. Beautiful, beautiful. All right, Judge, we're ready. You can begin now. Thank you for pausing just for us. Just go ahead and give the judge the knock on the door. Let her know. I heard her singing, so I figured she was here with us, at least in spirit. All right, let's see. Tally count. No, where's our time? Where's our timer? Did I lose my timer? No. Don't lose timer. Did I lose the timer? I did. I shut it down. Why did I do that? You're exactly right, Alison Jones. It was 12, 21, 12. That was where we were at with the timer. I cannot find it. I mean, it might be here somewhere, but it's not popping up for me. Oh, found it. Have no fear. Timer is here. Oh, that's so weird. It was not showing up in the menu bar at the bottom of the computer as an open tab, but it was in the background. So let's see if we can move it in the right position. That'll work. Look at that. Whew. That was close. You want the Jackery link? Yins, I will give you the Jackery link. I absolutely love the Jackery. I'm so excited to be able to use that this weekend. Let's see. Jackery is not a sponsor, by the way. There are two deals. Let me give you one. Let's see. Get a link for here. If you want the solar panel thing, that's a little more expensive. That is what I have. But if you just get the battery backup that charges from the wall, recharges from the wall, much cheaper. But it's all visible from this same link. So let me give this to you right here. There we go. This is the link will open up to the more expensive version, but when you go to that page, just as you scroll down, there's some options, little boxes like underneath the price, and just click E1000 V2, and that drops down to the $399 version. So great stuff. All right. I love my Jackery battery. It's great just for charging phones, etc. I bought it to heat our lunch boxes on the go. Husband has celiac. Okay. I'm using it to run a fan because for some reason I I may snore a little bit. Can we talk Corey Richens? Yes, Heather, we can. That's on the schedule today. We're just going to let the judge kick off court and tell us if there was a note at the last minute yesterday that she just decided not to read to us. But we are going to look at Corey Richens for sure. Let's see. Inside joke, don't forget your sleeping bag this time. Right. I don't know if I'll bring a sleeping bag. I might just bring, I've got it. Oh, the garbage man's here. That's cool. I might just really down start clock. Waiting for court to be called. I think they're going to bring the jury in before they do that. So we've got just a moment here. Any second now, actually. No verdict yet. Corey is cooked. I won't be surprised if he takes a plea. Bravo check. Everybody's doing it, apparently. Everyone takes pleas. Nobody wants to go to court anymore, except for the people who really shouldn't. Holy cow, what are they smashing our garbage cans? Or throwing them in our yard? It's making a lot of noise. I've got a 4-inch inflatable air mattress, which has one of those, it's got a little place on it. It's like got a sponge inside. You just step on it over and over, and it inflates itself. Hope she doesn't want to see the trial. I do as well. Of course, she has to do what's best for her, and it might be best for the victim if she takes a plea deal. But that's up to her. I'd like to see it go to trial because there's just so much we need to talk about and unpack, and I want to hear the scoop on so many things. I need to shop for one. Do you like yours? Magistrate, the thing I like about this is it's not like a pool floaty, like that plastic that just pops. It's not like the air mattress. It's more like a cloth material, and it's quite durable. I do like the one I have. I like it because I could either you can pump it up to be like full, and it can hold me. And I'm a big guy. Okay, I'm 6'2", and I weigh as much as 2 people my size. It holds me, and I can also deflate it down so I can just have it be the perfect amount of give. It's beautiful. I'm really liking it. I can send you the link to the one I got if you would like. Let me see which one did I get? It is Amazon Prime Day, so it's probably cheaper for you to buy it now than what I bought it for. Let's see. There it is. And yep, it's 20% off. Yay! You guys are all getting better deals on this than what I got. I pay full price for everything, apparently. So there's a little air mattress. It's not expensive. I mean, I've had expensive air mattresses that I like self-inflating thermarests and things like that. They're beautiful. They're amazing. If I were doing a lot of outdoor camping on rocks and things like that, I would get that. But whereas this is going to be used in the back of my car, I'm not worried about sticks and rocks quite so much. Heard about the walk the dog letter. Oh my goodness, Tracy, we will talk about that. Probably not today. We've done a live stream specifically talking about the walk the dog letter, going way back. It might be in a playlist for Corey Richens. I'll have to check. But we're going to talk about that again as we go forward. Amazon is not a sponsor. Nope. I think I sponsor Amazon, actually. Looking back at the credit card bill, I think I sponsor Amazon. Pug's mama says hi, listening to you from the dentist there. Say hi to the dentist. Share the channel. Be a friend. No, just kidding. Pug's mama. Glad we got something to distract you from the happenings of the day, but hope it all goes well. It's just a cleaning or something, or if you are there because you're in pain, hope they fix it and life can return to normal. Let's see. Jeff Bezos invited RA to his wedding as a thank you. Fact, greeners. Facts. He was going to gift me the boat, but I said, no, I don't have a place to park it, So that's why it's over in Paris right now. Corey's the one I've wanted to watch for a long time. So there's just so much she's done. I'm invested, but please, a plea would be easier for the family, and I can't be mad. Yeah, I can't be mad at anyone for the plea deal, but you've got to be listening to Josh from Courtroom Confidential. He just barely signed a deal with Fox News to be a a legal commentator for them. And the first big trial they were going to do was Courtroom Confidential. It was not Courtroom Confidential. It was Josh at Brian Koberger. Sorry. So they flew him up there because he took a plea. They were ready to go, and didn't happen. So it happens to the best of us. Why didn't RA go then, Greeners? Go where? We need a channel where we stream the best of RA when you're away and chat about it. I'm perfectly fine with that. There are many people that do restream or take clips from my live feed. I think it's great. If there are people who are just full on running my commentary to mock or make fun of me or just be mean, I'll ask them not to do it. But you do you. It's great. I'm going to do me and you do you. EDB's covered this already. We might be covering plowed ground then, but I do want to talk about this. Thank you, Samantha, for the link. That is the live stream where we talk about the Walk the Dog letter from Corey Richens, and it is wild. Oh, it's wild. Why are we not in court right now? Can anyone explain? They call you little man in the corner. I'm 6'2", yeah. But I'm small in the corner. So the reason they call me little man in the corner, Magistrate, just for a little background, is during the Melody Ferris trial, which was the burn pile murder. I think that was the right one. She was accused of shooting and killing and burning her husband. During that trial, we were following it live, and I was commentating, and there was a witness on the stand, and he was saying something about how, a family member owned certain firearms, and he breezed past one that was a .38 caliber, and I said, I know where they're going. They're going to say that the defendant stole the .38 Special from Martha Jane. And what I didn't know was Martha Jane, who was a witness but had not been told she couldn't watch court, was watching our channel, and she heard me say that, and she knew that her gun had gone missing when the defendant was at her house, and she had never told anyone. And the guilt of that, because the police did come and talk to her, but they never asked her about that gun, and so she never told them. The guilt of that prompted her to call the investigator and say, she says, I was watching court TV, with the little man in the corner with the headphones. And he said, Martha Jane, the gun's from Martha Jane's gun. She stole it. And I knew I had to call. And it was a thing in court. We were discussed a little bit. The defense was not happy. They took screenshots from my live stream with me in the corner going I don't know where they got that freeze frame from, but that's the shot that they held up in court. Are you aware that this little man in the corner is actually a man named, goes by the name Recovery Addict, and he talks about trials on YouTube and everything. And she's like, I thought it was court TV. So yeah, that if you go to that court file at the courthouse and ask to see the record, you'll open it up. You will actually see that we are entered in as evidence in that trial. And she called us the little man in the corner, and it sort of stuck. So that's where that story comes from. One of the, unfortunately, 3 times so far? Only 3. No, technically we were mentioned in that trial again by the judge because we were counting how many times he said But there have been a few times where we've been mentioned in court or played in court or something like that, or been in the papers. I don't like that particularly. That's not my goal. All right. Yep. Let's see. We've got I forgot the counter. So you work for Court TV? I didn't know it either. The only thing I've done for Court TV is they did contact me, and I shot video for a commercial for them for the O.J. Simpson anniversary coverage. They asked me if I'd provide some footage, and they used it in the commercial. So I've been in commercials for Court TV, but I've never been a commentator for them. They've been in our channel, and said hi. It's always fun when they drop by and say, hey, how's it going, and all that. But that's it. All right. Is anyone seeing anything that court just started or something? The best moment was when Judge Schroeder in open court watching your live stream. Yeah, the fireworks are not done. That was wild. Okay, let me get this over to my other computer. Over there. What's the origin of the Recovery Addict name? Crazy Cat, great question. It's got a couple stories that sort of converged, and that's why I chose the name. Originally, I chose the name Recovery Addict because I made this channel thinking I would love to be on YouTube and share one of my hobbies with the world, and that hobby is metal detecting. As you know, this is not a metal detecting channel anymore, but when it started out, it was, and I would go out and live stream or make videos of metal detecting and looking for rings and jewelry and coins and just bits of history in parks and fields and all that. And I learned very quickly that there is a very dedicated but very small audience who wants to watch metal detecting, and it just wouldn't work. And when I lost my job with the Department of Defense, and by lost my job, I mean I worked myself out of a job. So I worked to the last day, and they're like, all right, mission accomplished. Now you no longer have work here. I was looking for new work in the same field, which is IT related for the Department of Defense. Fun stuff, like top secret SCI level stuff, but it's really cool. And everything that was available wanted me to move to Florida or Washington, D.C. or Denver, and I wanted to be in North Carolina, where I'd been for about 3 years. And after about 7 months of looking for jobs and spending all my savings, I just in frustration and desperation and a little bit of just, I give up. Told my wife, I'm not going to look for jobs today. I'm just gonna live stream on YouTube. And we started live streaming. And 13 of you came, and it was one of the best days ever. I loved it. I can still remember how I felt that night as I'm laying in bed, wide awake, just loving the time I spent with 13 people I had never even heard of before on the internet talking about a court case. The next day, like 45 people came. The next day it was like 350 or 450. And the fourth day, there were about 13,000. And we've been live pretty much every weekday since. But Recovery Addict, the name, also pays tribute to the fact that I am myself a recovering addict, but my background is a little bit different than what you might assume. Obviously, there are addictions of many types, and my particular addiction involved gaming, computer gaming. And I just about lost everything because I just could not tear myself away from a game that was called World of Warcraft. It became my entire world. Just about lost, this was previous to working for the Department of Defense, just about lost family, job, and yes, I would even say my life because of that game. So we call ourselves Recovery Addict, and we are not trying to in any way mock or make fun of addicts at all. As a matter of fact, we celebrate everybody on their path to sobriety, wherever it is, and however long they've been sober, one day at a time. We love it here. So you'll often see somebody sharing their sobriety milestone, be it large or small, in chat, and we love every one of them. So that's the story. Leroy Jenkins, no more. Yes, thank you. I'm glad somebody gets the World of Warcraft reference. Do you remember the names of your first 13 viewers? I can tell you that about 10 of them are still here. I'd have to write them down. But when you look at the member milestone and see people that are in the upper 20s and 30s, that's the category they're in. Most of them became members. Some of them not all, but most of them have been here and stayed with us. Let's see. Samantha Terry, one of those. Yep. Okay, just 1 second. I've got to see why the judge has not come in yet. Did they start deliberating? I'm not seeing it at all. I'm going to start the timer. I think they've begun deliberating. The timer is not incredibly accurate. As a matter of fact, the court has a counter that's 3 hours slower than ours, or behind. Did you ever find anything of value with your metal detector? Come on, yes, we did. As a matter of fact, one of the first things I did on this channel was I did a giveaway. I think it was about 15 rings. I've never sold anything I found with a metal detector, but I do usually find jewelry, oftentimes a ring, usually about once every 2 hours while detecting. It seems like a lot, but people lose jewelry a ton, especially at beaches. So I gave away a rope full of rings, a few golds, mostly silver, a few tungsten carbide, to a viewer, and as a contest. And I've found gold rings during live streams. I've found returned a lot of rings. I found returned phones. I found some cool stuff. So the first trial we covered here on the channel was Darrell Brooks. I've been following court. You might have seen me in chat for the Amber Heard incident. I think possibly even Jodi Arias, going back that far. I mean, using that same account, but let's see. I remember that RA did roll call. I used to roll call. Let's see. Darrell Brooks was the beginning officially for the channel. I deleted most of my Darrell Brooks coverage because when I first applied to be monetized on YouTube, they denied me, saying that I had reused content, and I thought that I had done something wrong, and so I deleted everything. But it turns out that the video that was the problem was a video that I actually shot myself and had also shared on TikTok. And YouTube doesn't like seeing TikTok material on YouTube. The video had gone viral on TikTok. It got like 16 million views, which is great because that adds up to about 60 cents on TikTok. But that was the reason. So I deleted that one, waited a time period, reapplied, and got approved. All right. Stephanie, Judge Boyd has a jury trial today. She does. There are a couple things we want to do. Let me start. We're going to keep this in the corner. Let's see. Let's go. Super source. Is box 1 on? There's box 1. Let's put box 2 is going to be 4. Nope. Box 2 is going to be 3. Box 4 is going to be 2. Nope, 4. There we go. Okay, we're all figured out. Okay, so we have court up in the top left-hand corner. That is a live shot of court. We also have audio turned on for court. If anything happens in the state of Connecticut versus Raul Valle case, we are going to hear it, and we'll jump right to it. But in the meantime, we're going to also cover a few other things. We've got some Corey Richens documents that I really want to get into, if I can find them where I put them. I actually need them over here. Date added. And I didn't want to go. Let's try this again. MacBook Air. There it is. Oop. Bree is on the phone. Let me switch from charger to voice.
Call from Bree.
Bree, how are you doing?
Good morning. Good morning. How are you? I'm good.
I'm doing fabulous.
Are you?
Yeah.
Did you get to watch that video I sent you yesterday?
No, you sent it. I have not watched them yet. I've just been...
You're fine. Yeah, whenever you get a chance. Like I said, it was... So in New Mexico, in Albuquerque, they had a couple firefighters being tried for rape, and they said it was consensual, whatever. But after the state rested, the defense attorney stood up and said, there's not enough evidence to convict my client of this. And the judge agreed and threw out one of the, there's defendants that were being represented at the same trial and threw out one of the charges for one of the gentlemen. I've never actually seen a directive verdict actually get something thrown out.
Yeah.
Usually they always just do it, and the judge is like, "Nope, we're good." But I was sitting there and I was like, "That just really happened."
It is extremely rare to see a judgment of acquittal.
Yeah.
Granted, but occasionally it does, and it's generally, when it does, it's basically a slap in the face to the prosecution because they didn't do their job. That's what the judge is saying. You had one job, and it was to prove these elements, and you only have to do the tiniest bit of effort for each one. There just has to be a smidgen of evidence towards each one, and they didn't, and it gets thrown out.
It was really kind of, I don't say funny, but funny. Some of the attorneys that were representing the two firefighters were Hannah Gutierrez Reed's attorney, the bald gentleman, and then the girl that we saw that always had a unique fashion sense during the Hannah trial.
Nice.
They were both sitting there, and I was like, this is a blast from the past today. So
yeah, get to see them again. That's crazy.
Yeah.
I will have to watch that, Bree. I've just been so busy getting set for my thing this weekend that I just haven't been able to think straight.
Good luck with that this weekend.
Yeah.
Hopefully it doesn't rain on you too bad.
Hopefully it doesn't rain on me, period.
Yeah, that's well. I mean, if it's gonna rain, hopefully it's not like what's been going around everywhere else. So
share some positive thoughts weather-wise my direction. That would be great.
Exactly. Weather watch, help us out.
Yep. Thank you very much,
But
Bree.
okay, well,
sorry.
I just had to talk to everybody. I wanted to call and say hi, and then make sure you saw that and let you know that it was in there for you.
Awesome. Thank you so much. I appreciate that. We'll see you.
You're welcome. Bye, guys.
Bye. All right, we have a document I want to read. I'm not going to put it on the screen here because first of all it's not pretty. It's on a scribed, and it's a pain in the butt with ads all over the place. But this is in the Corey Richens trial. Let me give you a background on Corey Richens. First of all, that is the next. I think that's the biggest case we have, that we're looking forward to, and it's not going to happen currently until February of next year. This has been put off. It was actually supposed to happen before Brian Koberger, but it got put off. There were some appeals and things, some change of venue requests that were sought for and appealed and everything else, and it caused a delay. There has been a ton of drama in this case with bridges being burned, everybody being thrown under the bus by lawyers. I mean, the lawyers have been involved. And it's wild. It's wild. There's allegations of improper searches. There's allegations of witness tampering. Clearly, this is a murder case where the wife is being charged with the death of the husband. There's all sorts of financial stuff going on in this case that's going to throw back to Murdaugh type situations where we've got real estate being purchased and fought over and everything else. It's wild. It has everything in it. Plus, the defendant, after her husband passes away, writes a book for her kids, calls it "Are You Still With Me?" or something like that, about grieving their lost father, who it now comes out allegedly she killed. The defendant went on a book tour. She was on Good Day America or whatever it was, Good Morning America, talking about this book and a bunch of other TV channels, morning shows and stuff, selling this book on. It was a great book. Yeah, it's that crazy. And then of course the letter she's written from jail to her, to her mom, with instructions to her mom. The allegations is that she would write these letters and hold them up to the glass during visiting. And then her mom would read them and take notes if needed, and then she would take those and tear them up and flush them down the toilet. And one of those got found, and she claimed it was a transcript for a book she was writing, even though it has her lawyer's name and witnesses' names and everything else, and instructions on what to do and what to testify and what to say. And yeah, it's that wild. Well, that case is growing. I've been there for a couple of hearings. This is in Park City, Utah. It's a beautiful, beautiful part of the country. If you've ever been skiing in Park City, Utah, you know why Utah says they have the greatest snow on earth. It is beautiful up there. The Olympics were held up there. It's just nestled in the mountains. Just incredible setting. Anyway, fun place. I would like to actually be out there for this one. But it says the undersigned prosecutor states on information and belief that the defendant, either directly or as a party, committed the crimes of. So these are additional charges that are being filed. Mortgage fraud in violation of Utah Code, a second-degree felony, as to follows to wit, that on or about June 29th, 2021, in Summit County, state of Utah, the defendant did, with the intent to defraud, knowingly make any material misstatement, misrepresentation, or omission during the mortgage lending process, intending that it be relied upon by a mortgage lender, borrower, or any other party of mortgage lending process. The value of the property, money, or a thing obtained, sought to be obtained, is or exceeds $5,000. And that $5,000 is like, who buys property for less than $5,000? This is an old law in Utah. Okay. Back in the day when the law was written and the threshold was at $5,000, that was a lot of property. It just hasn't been updated. And so now basically anything you do fraud related to property is going to fall in this higher level, over $5,000. There's also another mortgage fraud. There's count 2 mortgage fraud, count 3 mortgage fraud, count 4 mortgage fraud, count 5 mortgage fraud. Count 6, forgery in violation of Utah Code 76-6-501 2BI, a third-degree felony that on or about June 29, 2021, in Summit County, state of Utah, the defendant did with the purpose to defraud someone, make, complete, execute, authenticate, or utter a writing so that the writing or the making, completion, execution, authentication, or utterance purports to be the act of another person, whether that person is existent or non-existent. You cannot sign somebody else's name, without a few exceptions, like a power of attorney and something like that. Count 7, forgery, another one. Count 8, forgery, another one. Count 9, forgery, another one. Count 10, forgery, another one. Count 11, issuing a bad check in violation of Utah Code that on or about August 28th, 2021, the defendant did issue or pass a check for the payment of money for the purpose of obtaining from any person, firm, partnership, or corporation any money, property, or other thing of value paying for any services, wages, salary, labor, or rent. The defendant knew the check would not be paid by the drawee. Payment was refused by the drawee. The check made or drawn in the state of Utah is or exceeds $1,500, but is less than $5,000. Count 12, issuing a bad check in violation of Utah Code 76. This is a different date, so this is going to be a different incident from the issuing a bad check from before. This is October 12th, 2021. Count 13, issuing a bad check. This is November 11th. Count 14, issuing a bad check. This is November 12th. Count 15, issuing a bad check, December 20th. Count 16, issuing a bad check, December 20th. Count 17, issuing a bad check, December 22nd. And the last two were over 5,000, as were one of the other. So 3 of those are over $5,000. Count 18, money laundering. In violation of Utah Code, a secondary felony, on or about August 27th or 28th, 2021, in Summit County, state of Utah, the defendant did conduct a transaction knowing that the property involved in the transaction represents the proceeds from some form of unlawful activity with the intent to promote the unlawful activity. Count 19, money laundering for October 12th through 14th. Count 20, money laundering from November 10th to November 16th. Count 21, money laundering, November 10th to November 16th. Count 22, money laundering, December 23rd. Count 23, money laundering, December 23rd and 24th. Christmas Eve, she was money laundering. And one more, count money laundering, December 24th. So just on Christmas Eve. Money laundering. Count 25, communications fraud in violations of Utah Code, a second-degree felony. On or about January 11th, the defendant did devise a scheme or artifice to defraud another or to obtain from another money by means of false or fraudulent pretenses, representations, promises, or material omissions, and communicated directly or indirectly with any person by any means for the purpose of executing or concealing the scheme or artifice. The value of the property, money, or thing obtained or sought to be obtained is or exceeds $5,000. And count 26. This is the 26th new charge, all felonies. Pattern of unlawful activity, a second-degree felony that on or about June 29th and March 3rd and 4th, the defendant did commit prohibited conduct concerning a pattern of unlawful activity by receiving proceeds derived, whether directly or indirectly, from a pattern of unlawful activity in which the defendant had participated as a principal. The information is supported by the following probable cause statement. Here's the story. The defendant met Eric Richens in 2009 while she was working as a cashier at Home Depot. They had a child in 2012 and married in 2013. At the time of the marriage, Eric Richens and his business partner owned a successful stone masonry business called C&E Stone Masonry, LLC, hereafter known as C&E. Eric Richens and the defendant entered into a premarital agreement known as the PMA, that's a prenup, whereby the defendant released and relinquished all right, claim, or interest in C&E Stone Masonry. The PMA, so she in the prenup says, I have no interest in your business. Like if we split up right now, I get no part of your business. That's not me. That's separate. The PMA, or the prenup, provides the following: that Richens' marriage to the defendant, C&E Stone Masonry LLC, shall nonetheless remain the sole property of Eric Richens. The PMA further provides that the defendant shall have no claim or no right or claim to the business, except that if, here's the big one, if Eric Richens should die prior to the defendant, while the two are lawfully married, Eric Richens' partnership interest in the business shall transfer to the defendant. So, she gets Eric's part if he dies while they're married. You can already see the wheels turning, right? In early 2019, the defendant used a power of attorney to obtain $250,000 home equity line of credit, known as the HELOC, on Eric Richens' premarital home without his knowledge. On April 26th, the defendant formed K. Richens Realty LLC for the purpose of selling and buying real estate. The defendant was the sole member of the company. The defendant issued the proceeds from the HELOC to initially fund K. Richens Realty and hard money loans to finance its ongoing operations. Do you know what a hard money loan is? Think of a check cashing store, right? Where you go down, they say, hey, you can write us a post-dated check and we'll cash it, and we'll only charge you 25% interest. This is a hard money loan. This is not a situation where you go in and you say, look, I've got excellent credit. I'm a good risk. I'm a responsible borrower. I deserve a low interest rate and a high credit limit. And you can count on me to pay it back. This is somebody who says, I'll give you this money, but it's only for 30 days, right? It's payday loans. It's the highest interest type loans you can get, and from the shadiest of people, I think. I'm sorry. If you're in the hard money loan business, I think it's a shady business. Anyway. Okay, so hard money loans. Eric Richens first learned of the HELOC in October 2022. The secret origination and continued existence of the HELOC was a source of tension between the defendant and Eric Richens. The defendant informed Eric Richens that she would repay the loan and led Eric Richens to believe that she had repaid it. The HELOC was not paid off on the day of Eric Richens' death, so she had not paid it back. On October 13th, 2020, Eric Richens consulted an estate planning lawyer. Eric Richens informed his lawyer that he wanted to protect himself in the short term from recently discovered and ongoing abuse and misuse of his finances by the defendant, and to protect his 3 children in the long term by ensuring that the defendant would never be able to manage his property after his death. On November 3rd, Eric Richens executed several estate planning instruments, including a health care directive, a durable power of attorney, pour-over will, and the Eric Richens Living Trust, known as the Trust. In each of these instruments, he appointed his sister, Katie Richens Benson, his agent, fiduciary, or trustee, to the intentional and purposeful exclusion of the defendant. So writes his wife out of the will, writes his sister in. He transferred his home and his interest in C&E to the trust. So now he no longer has his interest in C&E. So it can't pass. Okay. Eric Richens removed the defendant as the beneficiary of a $500,000 New York life insurance company policy on his life and designated the trust as the beneficiary. And the defendant did not understand this estate plan until after Eric Richens' death, meaning she thought she was still going to get his share of the company and $500,000 in life insurance. In the 5 months prior to Eric Richens' death, Corey Richens Realty realized $170,000 in revenue. That's the earned money, while its monthly debt service exceeded $250,000. Monthly debt service is the amount you have to pay back each month. Think about if you run up a credit card and say you charge $10,000 on the credit card and your bill is $350 for the month. The $350 is the debt service. Her monthly debt service was $250,000. It borrowed from over 25 lenders to support itself and service its debt obligations. This is robbing Peter to pay Paul, borrowing from one person to pay off another loan. Despite Corey Richens Realty existing debt and insufficient revenue, the defendant continued to use hard money loans to purchase 3 additional properties in November 2021. When the defendant closed on 3 properties on November 30th, 2021, she added $1.1 million in high-interest debt to her already staggering and unserviceable debt load. Think national debt levels, but on a personal level. It's one of those things, you can never pay this off, right? You're accruing interest faster than you're earning money. And she gets another $1.1 million in loans. High-interest loans. Whew. By that day, she had already defaulted on 1 loan and was delinquent on several others. She continued efforts to borrow from new high-interest lenders to meet her existing obligations. By the end of 2021, the defendant stood on the precipice of total financial collapse. On December 23rd, 2021, the defendant contracted to purchase an unfinished mansion in Midway, Utah, using $2.9 million in high-interest debt due in 6 months. This is, you get a $3 million loan, got to pay it back in 6 months. Holy freaking cow. Even though she lacked the financial ability to service the additional debt, refinance the debt, rehabilitate the property, or otherwise dispose of the property, this mansion was unfinished. It's a monstrosity. Eric hated it, would not allow her to buy it. And she bought it. I think she signed for it the day after he died. Yeah, that doesn't look fishy at all. Let's see. The defendant was scheduled to close on the property on March 4th, 2022, the day of Eric Richens' death. She ultimately closed on it the next day. On the day of Eric Richens' death, Corey Richens Realty owed hard money lenders at least $1.8 million, and the day after Eric Richens' death, it owed them nearly $5 million. I'm not sure who her financial planner was, but this is not a business plan that's tenable. At the time of Eric Richens' death, at least 3 insurance policies on Eric Richens' life existed, with aggregate death benefits of $1.35 million, and the defendant as the beneficiary. A 4th policy existed with a death penalty benefit of $500,000. The defendant mistakenly believed that she was the beneficiary of that policy as well. A 5th policy existed that paid approximately $168,000 towards the balance of Eric Richens' mortgage. At the time of his death, Eric Richens' estate was worth approximately $5 million. At the time of Eric Richens, the defendant, her family, Corey Richens Realty, and C&E, the masonry company, banked with America First Credit Union. We're going to call it America First. The defendant also had a personal checking account with Navy Federal Credit Union. We're going to call that Navy Federal, which included a $15,000 credit line. The defendant submitted a falsified bank statement to Iron Bridge Financial in support of a mortgage loan application. Iron Bridge Financial. This is what, a bridge loan? I don't know. On July 7th, 2021, the defendant, on behalf of Corey Richens Realty, entered a mortgage loan with the Iron Bridge Financial Company. On June 29th, in support of the loan application, the defendant submitted a purported America First statement for Corey Richens Realty dated May 31st, 2021, showing an account balance of $210,898.61. So she submits as supporting documents for her loan of, I don't know what the amount is yet. She submits, here's my bank statement showing I've got $210,000 cash in the bank. Corey Richens Realty actual America First statement dated May 31st, 2021 shows an account balance of $15,609.93. So it's over by about $195,000. Let's see. C&E's Okay, this is the husband's company. C&E's America First statement dated May 31st on that same date shows an account balance of, you heard it, $210,898.61, which means that she took C&E's bank statement, whited out their name, copied over her company's name, and supplied that as this is my current balance, when it was actually her husband's company's balance. The transaction descriptions listed the purported statement on the defendant submitted in their support of the mortgage loan application are identical to the transaction descriptions listed on C&E's statement. The purported statement the defendant submitted is comprised of the header of Corey Richens Realty actually statement and the body of C&E's statement. It was literally a clip, copy, and paste job. On July 2nd, while processing the mortgage loan, an Iron Bridge representative noted to the defendant, "When I ran your credit, it was lower than I expected. Looks like there are some delinquencies with regards to a few credit cards. I was just a bit surprised by that. I know you have a lot of money in the bank to cover expenses." 3 days later, the defendant explained, "I recently learned about all of this as well, LOL, and then my husband tried to explain to me that this was his doing a while ago. We're in the process of separation for one of many reasons, but this is one of them, to keep it short and sweet. LOL. It's been crazy to say the least. There is no evidence to suggest that this explanation is true," says the affidavit. The defense submitted a falsified bank statement to a Boomerang Finance. These names are terrible. In support of a mortgage loan application. On August 4th, the defendant, on behalf of Corey Richens Realty, entered a mortgage loan with Boomerang Finance. On August 7th, in support of the loan application, the defendant submitted a purported America First statement for Corey Richens Realty, showing an account balance of $702,831.96. As you guessed it, Corey Richens' actual balance at that time was only $15,000, and C&E, her husband's company, balance at that time was $702,000. The transaction descriptions listed on the purported statement show that it was a copy and paste job as well. The defendant submitted 3 falsified bank statements to Excel Financial Services in support of a mortgage loan application. This is August 2021. She submitted paperwork showing an account balance from America First for Corey Richens Realty of nearly $700,000. At the time, she had less than $2,000 in her account, and her husband had $694,000. So she's got a pattern of submitting her husband's bank statement with her company's header for mortgage loans. Excel's representative asked the defendant for a letter explaining her low credit rating. On September 12th, the defendant wrote that her low credit rating was because of a lady out of Seattle that had gotten a hold of her Social Security number. There was no evidence that this explanation is true. Why blame a lady out of Seattle? On October 13th, in further support of the loan application, the defendant submitted a purported America First statement for her personal account dated September 30th, showing an account balance of $169,000. The defendant's actual America First statement dated October 1st, 2021, shows an account balance of negative $4.01. Her husband's bank statement shows $169,000. The transaction descriptions match, once again, copy and paste. On November 23rd, in further support of the loan application, the defendant submitted a purported Corey Richens Realty America First statement dated October 31st, showing an account balance of $57,811. Corey Richens' account at that time was negative $1,700. Her husband's account had $57,000 in it. The transaction descriptions listed on the purported statement that the defendant submitted matched the husband's company. On August 28th, the defendant wrote a check, number 271, from her Navy Federal account to Corey Richens Realty for $2,100. At the time, Navy Federal account balance was $0, and the line of credit was negative $13,700. The defendant deposited the check into Corey Richens Realty America First account. At that time, America First account balance was $9,139.23. The defendant then transferred $2,500 from the America First account to her mother and $13,775 to several creditors before America First could draw back the $2,100. America First ultimately returns the check for insufficient funds. On October 12th, the defendant wrote check number 304 from her Navy Federal account to Corey Richens Realty. She's writing herself checks for $2,500. At the time, her balance in the Navy Federal account balance was $0, and her line of credit was negative $15,000. The defendant deposited the check into Corey Richens' Realty America First account. At the time, the America First account balance was $505. The defendant then transferred $2,518.10 from America First to several creditors before America First could draw back the $2,500. America First ultimately returned her check for insufficient funds. On November 11th, the defendant wrote check number 241 from her Navy Federal account to Corey Richens Realty for $3,000. At the time, her balance was $0, and her line of credit was negative $15,000. The defendant deposited the check into Corey Richens Realty America First account. At that time, America First account balance was negative $2,231. The defendant then transferred $1,000 from America First account to her mother and $2,000 to her personal account before America First could draw back the $3,000. America First ultimately returned the check for insufficient funds. America First, why don't you wake up to this? It's happening over and over and over. And it's not done. On November 12th, from Navy Federal, she wrote herself a check for $5,000. Her balance was negative $15,000. She deposited the check into America First. Her balance there was $575. She then transferred out $1,000 to her mom and $2,000 to her personal account before America First can draw back the $5,000. It was returned for insufficient funds. December 20th, defendant wrote a check from Navy Federal to herself for $4,000. Her balance at the time was negative $51 with $15,000 in the hole. The defendant deposited the check into her personal America First account. At that time, the America First account balance was negative $586. The defendant then transferred $2,215 from the America First account to her mother before America First could draw back the $4,000. America First ultimately returned the check for insufficient funds. On December 20th, the defendant wrote a check from Navy Federal to herself for $10,000. At the time, Navy Federal account balance was negative $51, and she owed $15,000. The defendant deposited the check into Corey Richens Realty America First account. At the time, she had in that account negative $1,100. The defendant then transferred $9,592 from Corey Richens Realty America First account to several creditors before America First could draw back the $10,000. America First ultimately returned the check for insufficient funds. On December 22nd, the defendant wrote check number 343 from Navy Federal to herself for another $10,000. At the time, she owed $15,000, had nothing in the bank. The defendant deposited the check to her personal America First account. At the time, her personal balance was $1,000. She then transferred $10,000 from her personal America First account to her family's America First account before America First could draw back the $10,000. America First ultimately returned the check for insufficient funds. We're just getting started. This is just the financial part, right? Remember Murdaugh? In late 2021, Corey Richens, this is the defendant, fraudulently extracted $45,000 from her best friend. Let's hear the details. In late 2021, Corey Richens Realty owned a home located in Heber City, which is near Park City, on which the defendant owed $456,500, so just shy of $500,000, in 4 short-term, high-interest, hard money loans. 3 of the 4 notes secured by this property matured on January 7th or 8th, 2022. Beginning in October 2021, the defendant unsuccessfully tried to refinance the home to a traditional 30-year mortgage. She planned to then sell or finance the property for her best friend. The best friend, her husband, and 3 small children moved into the home. The defendant and her best friend signed a residential lease agreement with option to purchase, wherein the best friend agreed to pay the defendant $2,900 per month in rent with an option to buy the home for $490,000. On January 11th, the defendant's best friend caused 2 wires totaling $45,000 to be transferred into Corey Richens Realty's account. Correspondence between the defendant and her best friend establishes that the defendant agreed to apply this money as a down payment on a long-term mortgage supposedly closing on January 19th, 2022. Immediately prior to the best friend's wires entering Corey Richens' account, the account balance was negative $2,000. As soon as the first wire entered the account and before the second wire entered the account, the defendant transferred $19,300 of her best friend's down payment to her personal America First Credit Union account to cover a wire transfer of exactly $19,300 to FundFi, an entity with which the defendant had taken out a high-interest accounts receivable loan unrelated to that property. By January 19th, the defendant had spent the remainder of her best friend's $45,000 down payment on expenses unrelated to that property. On January 19th, Corey Richens' account balance was $227. The property refinancing did not take place on January 22nd, 2022. The defendant was forced to enter into an extension agreement with the largest of the 4 hard money lenders on January 26, 2022. The 30-year mortgage lender revoked the proposed loan mid-February and offered less affordable terms. The defendant was thus forced to enter into another extension agreement with the largest hard money lender on February 16th. The unpaid principal balance on that date was $347,715. And the extension agreement extended to the repayment term to March 8th, 4 days after Eric Richens' death. Ultimately, one of the defendant's lenders foreclosed on the property and evicted the defendant's best friend and her family. The defendant submitted a falsified insurance application on Eric Richens' life. On January 29th, the defendant applied to TrueStage for an insurance policy on Eric Richens' life with a death benefit of $100,000, and the defendant named as the beneficiary. This life insurance policy became effective on February 4th, 10 days before the defendant's attempt on Eric Richens' life and 1 month before Eric Richens' death. Yes, she tried to kill him twice, allegedly. Once was successful. The defendant was able to apply for the policy because of her membership in PenFed Credit Union. Eric Richens had no affiliation with PenFed. The policy premiums were deducted from Corey Richens' Realty America First account. Eric Richens had no affiliation with this account. The address for Eric Richens provided on the application is a P.O. box solely belonging to the defendant. The phone number for Eric Richens provided on the application contained an incorrect digit. The signature on the application that purported to be Eric Richens' signature is a forgery. The defendant attempted to murder Eric Richens for pecuniary gain. The defendant occasionally employed Hayden Jeffs to assist her with renovating houses. On July 20th, 2022, the defendant text messaged Mr. Jeffs, "I did want to chat with you about something super random. Not now at kids stuff. I'll call tomorrow if that works." On January 21st at 7:24 p.m., the defendant text messaged Mr. Jeffs, "Hey, today snuck away from me. Can I give you a call in the morning around 11:30? On January 22nd at 11 o'clock, the defendant text messaged Mr. Jeffs, "Got a sec?" Mr. Jeffs told law enforcement that he spoke with the defendant on January 22nd and that the defendant asked him for fentanyl. The defendant told Mr. Jeffs that she wanted the fentanyl for a client who had back pain. Mr. Jeffs told the defendant he would not get her fentanyl, and the defendant hung up on Mr. Jeffs. On January 22nd at 5:35 p.m., the phone call in which Mr. Jeffs declined to get fentanyl for the defendant texted Mr. Jeffs, "Have another one for you. Call me if you get a sec." Mr. Jeffs told law enforcement that during the second phone call with the defendant on January 22nd, the defendant asked him for propofol. Mr. Jeffs told the defendant that he could not get her propofol. The text messages from January 22nd between the defendant and Mr. Jeffs were manually deleted from the defendant's phone. After that date, the defendant and Mr. Jeffs did not communicate ever again. The defendant and Mr. Jeffs had communicated regularly throughout the prior year. On May 31st, approximately 3 weeks after the defendant's arrest for the murder of Eric Richens, the defendant's mother text messaged the defendant, "Mr. Jeffs running his mouth." The defendant occasionally employed Carmen Lumber to clean houses. Carmen Lauber told law enforcement that sometime in early 2022, before Eric Richens' death, the defendant either called or texted to ask her that she procure some fentanyl for the defendant. Forensic analysis of Verizon's records for the defendant's cell phone show 746 SMS messages, 94 MMS messages, and 12 calls between the defendant's phone and Ms. Lauber's phone between January 1st and March 15th. These messages were manually deleted from the defendant's phone. The defendant's phone contained messages to and from Ms. Lauber before and after this time frame. Ms. Lauber told law enforcement that, pursuant to the defendant's request for fentanyl, she contacted Nicole Cummins for an introduction to someone that would sell her fentanyl. Ms. Cummins confirmed that Ms. Lauber asked her for an introduction to someone that would sell Ms. Lauber fentanyl. Ms. Cummins elaborated that Ms. Lauber messaged her through Facebook asking to speak with her and that she called Ms. Lauber shortly after. A Facebook message from Ms. Lauber to Ms. Cummins on February 5th asked, "Text me, I've got questions, won't do it on this." In response to Ms. Lauber's inquiry, Ms. Cummins provided Ms. Lauber with the phone number of a fentanyl dealer, Robert Crozier. Ms. Lauber's phone contains a contact from Mr. Crozier's phone number. The contact is labeled in a fashion that connects Miss Cummins with Mr. Crozier. Ms. Lauber told law enforcement that she contacted Mr. Crozier shortly after receiving his contact information from Ms. Cummins and asked to purchase fentanyl. Ms. Lauber's phone records established that he texted Mr. Crozier on February 10th at 8:52 p.m. Ms. Lauber told law enforcement that she met Mr. Crozier in the Maverick gas station in Draper on February 11th and purchased from him 15 to 30 round light green blue pills, which she understood to be fentanyl. Ms. Lauber's phone data shows that she called Mr. Crozier several times on February 11th between 5:19 and 6:52. Ms. Lauber stated that these calls were to coordinate the specific timing of the fentanyl purchase. Ms. Lauber's phone data also shows that she texted Mr. Crozier several times beginning at 7:18 p.m. while she was located at the Maverick. Ms. Lauber's phone data shows several text messages between the defendant and Ms. Lauber on February 11th, 2022. The messages began at 3:42 p.m., while Ms. Lauber was at her home in Heber and continued at 6:23 p.m. as she passed through Linden on her way to the Maverick gas station in Draper. The defendant and Ms. Lauber text messaged at 7:18 p.m., while Ms. Lauber was located at the Maverick and text messaging with Mr. Crozier. The messages contained at 8:20 p.m. as Ms. Lauber passed through Lehigh on her way back to her home in Heber concluded at 8:56 p.m. while Ms. Lauber was at her home in Heber. They have the entire breadcrumb trail with timestamps of this. Ms. Lauber told law enforcement that she delivered the pills that she purchased from Mr. Crozier to the defendant in a hand-to-hand transaction in the driveway of Ms. Lauber's home in February on either February 11th or February 12th. Ms. Lauber's phone data shows that in addition to the text messages the defendant and Ms. Lauber exchanged on February 11th, the defendant and Ms. Lauber exchanged text messages on February 12th. Ms. Lauber was located at her home in Heber during both exchanges. A certain diner in Camas, Utah, opens daily at 7 a.m. At 8:53 a.m. on February 14th, the defendant placed a 1-minute phone call to the diner. The defendant and Eric Richens' joint bank account statement shows a $41.29 purchase at the diner on this day. At 9:41 a.m., the defendant text message her paramour. Yes, we have a paramour. Headed that way. At 9:49 a.m., the defendant text messaged him a screenshot of a navigation application on her cell phone showing her current location on State Road 32 in Camas and her projected arrival at an unknown destination at 10:49. At 11:09, Eric Richens placed a 2-minute call to the defendant. At 11:27, Eric Richens text messaged a photograph to the defendant. The photograph has been deleted from both the defendant and Eric Richens' phones. At 11:33 a.m., Eric Richens text messaged the defendant, "I'm going to go lay down for a bit. And if I don't start getting better, I'm going to head to the hospital." 1 minute later, the defendant responded, "Geez, is it that bad? Need me to come home? Go take a nap and call me when you're up." 5 minutes later, at 11:39 a.m., activity recorded on Eric Richens' phone and associated devices ceased. Activity did not resume until nearly 2 hours later, at 1:32. At 1:43, Eric Richens texted the defendant and asked, "Are you home?" The defendant responded, "No, in Provo, waiting for my cabinet installer guy. Are you home?" At 1:45, Eric responded, "In the office. I've been sleeping out here." Eric Richens' office was a freestanding structure behind his home. At nearly 2 o'clock, Eric Richens called Cody White, a close friend. Mr. Wright could hear fear in Eric Richens' voice and tell that Eric Richens was scared. At 2:11 p.m., Eric Richens called Josh Kays, another close friend. Mr. Kays was struck by the tone of Eric Richens' voice and said that he seemed different, down, and somber. Opioids, including fentanyl, can cause allergic and pseudo-allergic reactions to include hives. Eric Richens did not have any food allergies. The defendant and Ms. Lauber exchanged 30 text messages on Valentine's Day 2022. On June 18th, 3.5 months after Eric Richens' death, the defendant text messaged her best friend about this incident. The defendant wrote, "It was Valentine's Day, and Eric and I were both working from home that day, and I ordered lunch from the diner. He never broke out in hives or used an EpiPen. I was effing with him, and he said the sandwich hurt his stomach and he was going to take a nap. No hives, no EpiPen." On August 22nd, nearly 4 months after the defendant was arrested for the murder of Eric Richens, the defendant discussed this incident in 2 phone calls. In a phone call with her mother, the defendant confirmed that she was the person who picked up the sandwiches from the diner on Valentine's Day. She said, "We ate in the office." In a phone call with her brother, the defendant discussed buying lunch at the diner that day. The defendant murdered Eric Richens for pecuniary why do I add an extra C there? Pecuniary gain. Ms. Lauber told law enforcement that in late February of 2022, the defendant told her that the fentanyl pills that she previously provided were not strong enough and asked that she procure some stronger fentanyl. Ms. Lauber initially stated that the defendant specifically asked for some of the Michael Jackson stuff during the second request for fentanyl, but subsequently conceded that the defendant may have referred to Michael Jackson during her earlier request for fentanyl. Michael Jackson died of a propofol overdose. On February 26th, Ms. Lauber sent Ms. Cummins a Facebook message asking that Ms. Cummins again provide her with Mr. Crozier's phone number. Later that day, Ms. Lauber contacted Mr. Crozier and arranged to purchase additional fentanyl from him at the same Maverick gas station in Draper. Ms. Lauber's phone data shows that on February 26th, beginning at 2:25, the defendant and Ms. Lauber exchanged several text messages. They continued the exchanges as she traveled to the gas station and back to her home. The phone data shows that she exchanged text messages with the defendant while she was located at Maverick. The defendant and Mr. Crozier while she was located at Maverick. At 3:21 a.m. on March 4th, the defendant called Summit County Dispatch and reported that her husband, Eric Richens, was not breathing. He's cold. He doesn't have a pulse. 10 minutes later, Summit County Emergency Medical Services personnel and sheriff's deputies arrived at Eric Richens' home. They found Eric Richens on the floor at the foot of his bed and performed life-saving measures, but ultimately declared him deceased at 4:58 a.m. EMS personnel thought that he'd been dead a while and noted that he was asystole the whole time. That's the heart rate thing. Not good. It's not conducive to life. A pathologist at the Office of Medical Examiner performed an autopsy on Eric Richens and concluded that his immediate cause of death was drug intoxication, fentanyl. The OME determined that the level of fentanyl in Eric Richens' blood was 15 nanograms per milliliter, which is approximately 5 times a lethal dose, and that his gastric fluid contained an additional 20,000 nanograms per milliliter of fentanyl. The OME determined that the byproducts of the fentanyl found in Eric Richens' gastric fluid were typical of illicit fentanyl, not medical-grade fentanyl. The OME determined that the fentanyl found in Eric Richens' body had been orally ingested. The OME also found 16,000 nanograms per milliliter of, I don't know my drugs, quetiapine, Quetiapine, in Eric Richens' gastric fluid. Quetiapine is an atypical antipsychotic medication used for treatment of schizophrenia, bipolar disorder, and major depressive disorder. It was widely used as a sleep aid due to its sedating effect. The defendant told law enforcement that at the time of Eric Richens' death, she had a prescription for quetiapine. On the night of Eric Richens' death, the defendant told law enforcement, "We eat gummies. Sometimes Eric will eat a gummy before he goes to bed. If he didn't, it didn't seem like he did, though." A year after Eric Richens' death, the defendant told law enforcement that she saw Eric Richens take a THC gummy in the bedroom after drinking a Moscow Mule. The defendant then clarified, "I didn't actually see him take it. He told me he took it. And then he had to have taken it while I was making the drinks. In explanation to law enforcement how the defendant thinks the fentanyl got into Eric Richens' body, the defendant said, "I honestly think it was one of those gummies, 100%. After the defendant was arrested for the murder of Eric Richens, the defendant's mother asked the defendant if she was sure the fentanyl came from a THC gummy. The defendant replied, "That is what I'm banking on, yes." The OME did not find any THC in Eric Richens' blood or gastric fluid. The state toxicology lab tested the THC gummies in Eric Richens' home at the time of his death and determined they did not come from fentanyl. They did not contain fentanyl. The defendant told law enforcement that she went to bed with Eric Richens in the bedroom at approximately 9:30 to 9:45 on March 3rd, and shortly thereafter went to one of their children's bedrooms to sleep with the children because the child was having nightmares. The defendant said she awoke in the child's bedroom at approximately 3 a.m. on March 4th and returned directly to the bedroom. The defendant said she was asleep in the child's bedroom the entire time. The defendant told law enforcement that when she left the bedroom at approximately 9:30 to 9:45 to go to the child's bedroom, she left her cell phone plugged in next to her bed and did not take it to the child's bedroom. The defendant told law enforcement that upon returning to their bedroom, she felt Eric Richens and he was cold to the touch and not breathing, and she immediately called 911. Summit County Dispatch received her call at 3:21 a.m. on March 4th, 21 minutes later. Forensic analysis of the defendant's cell phone shows that it was unlocked 6 times between 3:06 a.m. and 15 minutes later at 3:21 a.m. when the defendant called 911. This analysis shows that in the 13 minutes between 3:08 and 3:21, the defendant's phone or an associated device traveled approximately 378 feet. The defendant used several cell phones, including burners. The cell phones that the defendant primarily used leading up to and shortly after Eric Richens' death indicates that a significant amount of information was manually deleted from it, particularly between January and mid-March 2022. Forensic analysis of one of the defendant's cell phones shows that by April 16, 2022, 3 days after law enforcement first informed the defendant that Eric Richens died of a fentanyl overdose, the defendant's cell phone was used to access website articles with the following titles, among others: Utah State Prison, Timpanogos Women's Facility, What Happens to Deleted Messages, Cause of Death Usually Does Not Impact Life Insurance Payment, How Do Police and Forensic Analysts Recover Deleted Data from Phones, and Signs of Being Under Federal Investigation.
Did the defendant find out how the FBI finds people in this case?
Oh, she found out.
Okay. Yeah. You got to love that. You've got to love that. Forensic analysis of the same cell phone shows that by June 6, 2022, the defendant's phone was used to conduct the following internet searches, among others. Can you delete everything off an old iPhone without actually having it? Lots of spelling errors. It says, can you delete Evert given off an old iPhone without actually having ut? That's if you read it phonetically. She Googled women Utah prison. Can cops uncover deleted messages iPhone? Can cops force you to do lie detector test? If someone is poisoned, what does it go down on the death certificate as? How long does life insurance companies take to pay? And what is lethal dose of fentanyl? These are great. I'm sorry, these are going to play so well in court. On May 8th, the defendant was arrested for the murder of Eric Richens and received a copy of the charging document and probable cause statement. The probable cause statement referred to Miss Lauber by her initials and contained many of the facts presented above. On a jail call that day with her mother and brother, the defendant said, he, meaning Eric Richens, asked me to ask Miss Lauber for pain pills. The defendant never mentioned asking for pain pills for Eric Richens or from Miss Lauber during 3 hours of police interviews, and indeed insisted that Eric never took illicit drugs or pain medication other than occasional over-the-counter pain medication. The defendant fraudulently claimed insurance benefits from Eric Richens' death. The defendant was a beneficiary of 2 insurance policies on Eric's life issued by TrueStage with an aggregate death benefit of $350,000. One of the policies issued on May 12th, 2017, and the other on February 4th, 2022, 1 month prior to Eric Richens' death. On April 28th, 2022, the defendant submitted a claim against the policies. On June 7th, TrueStage learned that Eric Richens' cause of death was drug intoxication, fentanyl. On June 14th, TrueStage left a voicemail with the defendant requesting a copy of any prescription Eric Richens had for fentanyl. Later that same day, the defendant informed TrueStage that fentanyl was not prescribed and that she didn't have any idea how Eric Richens obtained the fentanyl. The next day, June 15th, the defendant reiterated to TrueStage that she really did not know where Eric Richens obtained the fentanyl. The pattern of unlawful conduct is predicated upon the offenses charged in counts 1 through 25 above, and herein uncharged insurance fraud, attempted aggravated murder, and attempted murder offenses. This was filed with the court on June 27th. Summit County Attorney, signed by Brad Bloodworth, Chief Prosecutor. Defendant's last known address, Summit County Jail. So Corey Richens is coming up in February. It is going to be a wild, wild case. And I can see her taking a plea. Honestly, I can. There's so much evidence against her. It's so bad. May I have a bougie prison penthouse suite? Yes, completely. Googling prison and how did feds find out if someone was poisoned on the same phone. It's not a good look, I can tell you that. Maybe it was research for her book. It could be a reason. All right, I have to thank a couple people. Kelly H. gifted a membership this morning. Thank you. Kim R. with the Dolphins gifted a membership as well. Emily Ahrens. The hump day yell actually made my cat look away from the birds outside. 10 out of 10. Kelly H. gifted another membership and then another. Legally Blonde says, I thought you were gone for the week already. I even whined in the RA Facebook group. I'm really living up to the blonde part in Legally Blonde. Still here. I've heard most of today, I think. We might stay here for... Mrs. R did so much packing for me. I might be able to stay the whole day. Megan Easton, member for 26 months, says, and that's how we became one big happy family. Thanks, RA mods and chat. Safe travels, RA. Y'all are loved. Thank you, Megan. It wouldn't be the same without you. OG. Speaking of OGs, Lynn in South Carolina. Almost an OG. You're an OG for sure. LOL. Love it here. Thank you, Lynn. Appreciate your support of the channel. You've been amazing. Laura 77, member for 19 months. I remember your first week, all right. It's been amazing to watch this channel evolve. Laura, thank you. Another OG. Crazy Cat Queen says, I get the feeling Corey Richens failed math. At least the part where they studied interest and interest rates. The creative bee, Debbie, I got to show off your plaques to somebody in my studio the other day, and they're like, "Oh, you got YouTube plaques?" And I do, and they're the best kind. Thank you. Saying hello from vacay in hot and sunny Florida. Miss you all, my pickle peeps. Thank you, Debbie. Appreciate that. Pantoufle says, "What a super sloppy criminal." Yes, terrible. Lar Watcher says, "Hoping for a verdict today. Wouldn't be a verdict watch without RA." Well, we are in verdict watch. We are sitting here, literally. Watching the wall, hoping that something happens. Let me, how do I turn off this one? There it is. Let's see, hoping for a verdict for sure. Pantoufle, and all she's missing is the Hoslong to die. She nearly got it. She nearly got it. Thomas is here, Weather Watch, member for 29 months, says first time here. Seems like a great group of folks. Thomas. Thank you very much. Yeah, new guy. Show him the ropes if you would, guys. Be kind to Thomas. Thank you. I do have to say we're terribly sad to be skipping the podcast tomorrow, but hopefully Thomas will get to do some fun things in the spare time where he's not live with us, and we hope to be back together for Thursday next week for renewing the festivities as they may be. Let's see, Thomas, by the way, OG, one of the originals. I wonder who has Corey's kids and how much does her mother know? Oh, okay. This gets into areas where we have to say allegedly a lot. There is the connection between Corey Richens and her mother is tight, and it connects at places where you wouldn't think it would connect, like things they have in common, like allegedly spouses passing away from poisoning. There's some crazy stuff. There's crazy stuff allegedly in this case. I must admit this has taken longer than I thought it would, says Joe Sherlock. The deliberation after 13 hours or so. Loved the wall better. Loved the wall better. Camilla, I missed that one. That's a reference. If it was a joke, it went over my head. We're addicted and hate the weekends. I'm sorry, Laura. If you leave before a verdict, where do we go for a Valle verdict watch? We'll send you somewhere to catch it. I'm going to Virginia tomorrow, Friday, and I'll be back Saturday night. I'll be filming. I'll be using all the batteries and all the cameras to film while I'm up there, and it's going to be wild. And I'm taking my e-bike, so it might be just amazing. It just might be loads of fun. I've been riding it to get some good calluses on the derriere, so that I'm not like limping around all weekend. I don't have to say allegedly she knew, says Ivan. Kelly, we'll figure out something for you. Like allegedly Paramore. Oh, yes, we get that's going to come out. We're going to have more details about that during court, about the Paramore. Trial Obsessed says, did I win a membership? If so, thank you so much to whoever donated one to me. Yay, you are a member right now, so you may have won one. When are you considered an OG? I've been here almost 17 months and never been called an OG. We originally said that anytime after you're here for 20 months, you're an OG. But a lot of people who have been here for longer than that and have not been members, but have been subscribers for that long. So we have a lot of OGs that just because their name isn't in green does not mean they're not an OG. So you'll know if you're an OG. And Josh, I think you're right about that point. Was looking forward to more taste testing tonight. Alas, we shall wait another week. Oh my goodness. I'm just hoping the food up there is good. I just don't want food poisoning. I can camp in some pretty rough conditions, but camping with food poisoning is not fun at all. Can't think of a better name. Was looking forward to more. Oh, sorry. I read that one twice. Yes. Good food only. Raina gifted 10 memberships. Raina, thank you. So generous on this channel. Thank you very much. From Canada, representing the true north, bold and free. What's your favorite vacation you took? Oh, Joe. Favorite vacation. I don't do a lot of vacations. I have done a lot of camping when I was involved with the scouting program as a scoutmaster. And I've got to say, this area around where Corey Richens was at, specifically the Uinta Mountains, these are high mountains. We're talking over 10,000 feet. Mirror Lake area, the Cubrant Lakes. Oh, my goodness. Cubrant Lakes is like a horseshoe-shaped valley way up in the tops of the mountains. So the mountaintops are just boulders. It's way above the tree line. Okay, so you're really up in the thin air. And it's a horseshoe-shaped valley with a cliff on the bottom and 5 lakes in there that you can hike around. And it's a couple miles across. I love that place. Took the scouts up there, even knowing that a previous scout group had gone up there and a scout with his dad had been at one lake and got his feet wet, right next to camp. And his dad said, oh, go back and change your shoes. He ran back to camp to change his shoes, and they never found him. He went missing. They never found his body. He just disappeared. Lots of speculation on that one. So when I went up there with my scouts, I kept a close eye on all of them. But that was wild. That's the first time I've ever run into naturalists swimming in a lake before. Like just full on. That was wild. The water's so cold. It's so cold. It's like glacier fed water. Roni, member for 17 months, just waiting for a pink courthouse, possibly, impatiently. It's coming. Let's see. Still deliberating? Yes, we are. And nothing. We haven't heard anything this morning. All right. The elevation is brutal. I was fairly fit because I had done a lot of hiking at the time when I went up there. But you do feel it. You're breathing more. Okay, so there's less air, so you're breathing more and getting less oxygen when you're up that high. But I didn't realize how thin the air was until I flew my drone up there. And I had flown my drone down, at the valley floor level, which is about 3,000 feet elevation, I think. I don't remember exactly what it was. And it flies great, and it can take off and everything. And I took it up in the mountains to try to fly it, and I had to throttle up those propellers to like almost full throttle to get the thing to lift off. It just could not get the lift. I mean, the air was too thin to provide the lift for the drone. It could fly, but it was just a very different machine up that high. It was just wild. Let's see. Is that Corey having a trial? Melvin, so far, yes. In February. That's when it's going to be held in Summit County. The change of venue was denied. She just got hit with 26 more charges, which we read through today. Those are on top of the murder and the financial crime charges she's already charged with, the fraud and everything else. She's got a lot she's facing. I would not be surprised if she takes a plea deal. They've got all the evidence. Who are you going to Virginia with? A couple of my boys, just 2 of them. Jen Joe, I'm not green, and I just learned that I've reached OG status. Jen Joe, it's wonderful. Let's see. Rebecca May Stone, remember for 8 months, RA got food poisoning from a dang Shoney's like in 2002 while camping in Cape Cod. Thanks for reminding me of my childhood trauma. I'm sorry. I had a child get, I'm not sure if it's altitude sickness or bad food or what, but a kid who was sick up in the Uintas. This was by Wall Lake. It's by the Mirror Lake Highway. Wall Lake is a short hike off the lake. I think it's like 5 miles or something. And just a beautiful, beautiful, beautiful place. But he got sick, and just all night long I was up. He's my boy, so I'm up with him and digging holes because, if it's food poisoning, there's 2 routes it can go. So, yeah, not fun all night long. Coral, welcome to the gallery. Thank you very much. The blue reflection on your glasses matches your blue courthouse beautifully. Thank you very much. Welcome. You're one of us now. You can never leave. Thank you. Let's see. Libby says, didn't pull the trigger on the GoPro. Going to test out the $50 Acaso. I'm going rock picking this weekend. I'll test it out. This sounds great. Yeah, GoPro is the brand name that they charge a lot for. I would recommend only buying them on a deal. But any type of camera that will do that will work. And if you're doing rock cutting, Libby, the main thing is you need it to be waterproof, right? Because your rock saw is going to be throwing rock juice. What do you call it? Water. Rock juice. So you need to be able to wash your camera. Heather from Texas, thank you. We love to catch up on Corey. We're going to be following that one. This is why all my vacations are at the beach. Short hike, 5 miles. It's an easy hike is what I'm saying. It's a well-worn trail with a gradual incline. It's flatter than most of your treadmills. Katie Moore, thank you very much for the super sticker. Love it. Thank you. Rock juice, trademark pending. Yes. I want, on my wish list, there are a couple tools that when I finally own a house that has like a man cave or garage or something like that, I want 2 things. I want a wood lathe like Rob, and I want a
call from Alison.
A rock saw.
To accept, press.
Like a big one. Allison, this is RA. How are you doing?
Can you hear me? I dropped my AirPods in the sink, and I don't know if they're working.
It sounds like I'm in the sink, but other than that, I sound great. No, I can hear you just fine. You're good.
Okay, great. So, I was watching the trial with you, and I really like the defense attorney. He's really good, and I had a few points I wanted to make. And,
yeah.
Let me get together. So, he's very good, and I was thinking, wow, I'm in Texas. I want to call him up if I have a problem. I mean, he's just really good. He's smooth. But one thing I was thinking chronologically, when they started, all the kids started with the don't recalls and don't recalls. I'm thinking, is the prosecutor regretting telling them to default to that answer? So it's everybody's saying it's almost backfiring that everybody can't recall. You know what I mean?
That might be something they regret a little bit, that they asked so many questions that were I don't recall, or that they had so many responses that were I don't recall. I think that was Mr. Smith did a great job in getting them all to show they had selective memory issues, and anything that involves their group was like, we don't know, don't remember. We did what? I don't know. I didn't see that happen. No, I don't know where he was. I don't know who was there. So,
with you calling out how many beers they had, so it's all I could remember because it's so frequent. It was like it stuck out.
Yeah.
But the other thing is, I'm not going to ponder on like the night and how it happened. I do favor self-defense because I think his failure to substituting the yard for a room, reading the room to stop, not knowing when things are settling down. It's almost like his timing. And I'm not excusing him, but I'm going to leave that to the jury because it is a little gray. But the prosecutor, other than trying to plea him out, totally overcharging him. I mean, what's obvious is they have video of other people they could charge with assault and battery. I mean, there's so many things. It's on tape, and they're admitting it, but it's hard to look at it like it's being fair because they just picked, the top guy and had tunnel vision, kind of like Proctor's text, cut and dry, so they can get like the win or put him away. And so it's hard, and maybe the jury, I do think it's mostly guilty and one's holding out because they're stubborn like me, because I'm very over-prosecuting. But,
Alison, I've got to say, I did like Mr. Smith a lot. I do have some criticism about him. I think there were some objections he should have made, and he just, I think we can count on one time the number of times he objected to something. And the prosecution, on the other hand, every time they could object, they did. And so I think that they weren't sort of on the level playing field that way. So I do have some criticisms from Mr. Smith. Obviously, I think some of the things he did really well was in his closing argument, just saying to the jury, look, some of you have said you've had to use self-defense before. Self-defense is messy. This is what it looks like. This is what self-defense is. I think that was very effective. That was a pretty strong argument.
Well, the one time he did not object and he let go, and it kind of reminded me of Alan Jackson kind of letting people go because it's worse when they just talk, is when I did not like at all. And there's no way he was genuine about the closing argument when he started talking about his son. I did not like that. It was too much.
And
there's no way that came off.
He should have objected, and he didn't. And now he can't.
Yeah, but
they can't
I think
appeal.
He didn't for a reason.
But they can't appeal now. That should have been an
Well,
appellate level complaint.
It was so sappy. It was so far that I think he didn't object for that reason. Like maybe he wanted to, but it was just too much. And I think to me, my viewpoint, it would have really just been like, come on, kind of like the don't recall. Just those things stuck out. But yeah, I mean, that's pretty much. I don't have a total cohesive thought, but I'll be watching the trial kind of thinking, this is why I like to watch it, because these things pop up, get you kind of going. Anyways, that's all I have.
Awesome. Allison, thanks for the call. Appreciate it.
Okay, bye.
We'll see you.
Thank you. Bye.
I heard a bird in the background with Allison. I would not be surprised or disappointed in a mixed verdict in this one. I have a hard time with there only being one bad guy in this scenario. I think a lot of people have some accountability, and with the deals that were given out, it left one person out to dry, where there should be responsibility, enough to go around. But let's see. We've got a call from overseas.
Call from Mattis.
Mattis, how are you doing, my friend?
Pretty good right now. Cuddling some very high quality cats.
I was thinking you were going to say beer
taking a break
or
from
something.
work.
Cats was not on my list. High quality.
No.
What makes a cat
Very
high
good
quality?
cat.
Is it the fur quality?
Well, these ones are very beautiful and loving and cuddly.
Awesome.
They purr very nicely. They love me. They're becoming more and more warm to visitors. They pose really well for pictures, things like that.
They're Instagram friendly. Well, Mattis, what is
the
on your
male
mind?
cat? Yeah. The male cat is a great hunter. Sometimes I get food moths from stuff where something sneaks in, and then you can tell that he has these really big pupils, and he looks up. You can see, there's something there, and then you go gadgetto extendo arm, and then you lift him up to the ceiling, and then he goes with his little mittens. And
he lets you pick him up upside down?
I think I have done that before. It's weirder for him, okay. But he's really we're a really good team at this point.
My cat will let you pet its back, but don't pet his sides or his stomach, or else he becomes the front feet become the hold you claws, and the back feet become the rabbit, and it's just he'll just tear you up in a heartbeat.
Yeah, I also sometimes get the claws, but I think they're just messing with me. they definitely know that they like being cuddled. In the belly as well. I got to send you some pictures sometime. Some of these days. I wanted to call because there's actually a rule. So for appeals, so you might recall that there's some things that get reviewed for abuse of discretion, which basically almost never happens. Which is basically the rule is that the judge, the court that reviews the trial record. The case file, or the court's case file. They ask, would any reasonable judge do this? And then it's not abuse of discretion, and you lose your appeal. And then the other standard is de novo, where you look at the situation from a blank slate. Just completely, you start over with the legal analysis. Just look at the law, and then of course you also have to apply it to the facts, but. De novo is a much easier bar to clear. And then there's something called plain error. I'm not sure if this is like a federal rule or if this is state level. I think in federal it's something like the 52B rule, but if that is the federal rules of criminal procedure, you might be able to look that up if you just look at Federal Rules of Criminal Procedure 52B. I don't know if that covers all state-level crimes, but I think it is generally applicable in U.S. criminal courts, where an appellate court can say, well, the judge got this wrong. So, for example, some errors there, it's like, is this harmless error? Did the judge get this wrong, but it doesn't matter?
Right.
And then there's the plain error rule, which basically is, well, that's just wrong. And it's just wrong. And
but
the plain error rule is for something like, the plain error rule is just, you can just, there's this, you might know these Latin terms that's like, so in America, you say prima facie. The Latin is closer to like prima facie, and then there's ex facie. Prima facie is when you look at, on first glance, when you look at the face.
I heard a lady yell that at her former husband one time.
Yes. Yes, they like the Latin.
Yes.
And the heavier one, that means you can just tell. You only need to look at the face and you see that it's just there.
Yeah.
And that's what the plain error rule is for.
On the surface,
There's some
on the face.
things that you look at this, and then you don't have to look deeper. You just see, well, that is just so wrong. It doesn't matter if you don't object at the time. You might recall that I think this is the...
Are you saying that...
The triple threat trial?
That him not
trial?
objecting...
Triple threat trial?
Vaguely.
Yeah, there's instances where you don't have to preserve the objection because it's just so stupid to have
so
that.
Wrong, it's obvious. I don't know.
Yeah,
I'd feel better if he had objected to the crying
I also
prosecutor.
would feel better if, for practical reasons, of course. But I think in something like prosecutor testifying and crying,
his own son. Yeah.
I would say that's just. I think an appellate court could look at that and say, well, that's just so wrong. That was so prejudicial that you need a new trial. Bad defense attorney, I guess.
Yeah. Let me ask
I
you
don't
this.
necessarily know the precedent, but I think that's the line.
I know you made a comment yesterday when the jury was rewatching some of the testimony or re-listening to the testimony. What's your thought? What do you read into what the jury was asking for when they said we'd like to hear the testimony related to where Raul was out in the street and what if or how he saw Travis?
It's
or was it
difficult to evaluate. I think you need to map out for yourself. I think we need to map out what are the possibilities. One is, well, was he? If he did see that, if he did walk past someone, you can always ask about like context. What else was going on at the time? Did he go past him because he needed to fend off more attackers and keep his, I don't know what the English expression is, keep his back free? be a rear guard so he can have a safe retreat, something along those lines. They could interpret it that way. They could, of course, also say, well, if he walked past his friend, he was then he was looking for a fight. That's different people can read the tea leaves in many ways. So it's very difficult. I'm inclined. So I'm personally, when I was reminded of that testimony, I think he was testifying in a very genuine way. I was surprised that they replayed the audio or video or whatever.
That was, yeah,
but
I've never seen it like that
hearing
before.
him testify again. Yeah. Hearing him testify again made me think he was very genuine, and he I think it's fair to say that he walked past and, hello, boy, you are on television. I think he walked past and he wanted to like clear the retreat, because it matters what's happening in the other seconds around that point in time. If if you walk past someone who's on the ground and being jumped, if there's 3 people using them as a bouncy castle, and then you fight someone that's trying to also get on the bouncy castle, I think that's reasonable if you walk past him, because you're not going to fight 3 people at once if there's a 4th guy coming at you from the back. So I don't know what the jury got from the videos, but there's certainly some readings of them wanting to revisit that testimony where they see it as self-defense evidence. But of course, you can never tell with a jury in a situation like that. It's very unclean.
Yeah. I will say that your analogy to a bouncy castle is quite appropriate. Just know that bouncy castles have age and weight limits, and I think everyone involved exceeded that. This was not age appropriate behavior. They should have known better.
They don't allow underage drinking in the bouncy castle.
Yeah, I hear you. All right, Mattis, thank you very much. You're making us think deeply about this, which is always good. Once again, I'll renew my petition to get you to apply for your bar card here in the United States, because you're smarter than most of us when it comes to the law.
Yeah, I have to add this state to my list. I have to pass the bar exam. We might want to look at what are the precedents for plain error, if this is a federal thing or a state level thing. I might have to look into that. Maybe Kurt knows that. There's certainly some interesting precedents for plain error and things like that.
Yeah.
So I got to look into that more.
Mattis, I'm not
sure.
I
also got work to do, and I will return to that shortly.
Okay. I'm not sure if you're willing or if you've ever shared what region of Germany you're from.
Near Frankfurt.
Near Frankfurt.
Hessen.
Okay. I know a lot of people are trying to guess the accent. I knew it was Germany, but I wasn't sure, which part you were from. But now I know. Not that I could tell the difference by, it's like, that.
You could never guess, the various local German dialects. You could not guess the dialect my grandmother speaks in. There's a lot of things going on in German regional dialect. So it might. I don't know what English media colored my accent most.
Mm-hmm.
But yeah.
Lar Watcher guessed it by your cat's accent. The meow gave it away. But
yeah.
Mattis, thank you very much. Give the cats a pet for us. And thank you, my friend. It's good to hear from you. We'll see you.
All right. Have a great day.
Bye.
Bye.
Let's see. Every time I hear Mattis, I think about Inventing Anna. I know I can't be alone. Inventing Anna? Is that a movie? I've not seen that one. Jamie C., member for 26 months, says, I didn't watch this trial. I had to detox after Karen Reed. What trial is next? Well, we're not starting the next trial till Monday, because I will be off tomorrow and Friday, and I hate to start something and then miss it. John Davenport says, I'm going to be camping in the Uintas up at the end of July for 2 weeks. So excited, and taking the Starlink so I can watch you. That is awesome. Edsel Dog, member for 26 months, 3 OGs in a row. I don't say much. I'm a lurker, but so happy to share my day with y'all. OG. That was awesome. Let's see. We have a couple options to go to. Our mods have done some great work digging up some great stuff. We do have that thing going down with Judge Boyd, which we could hop, skip, and jump through if you'd like. She has a trial. We saw a little bit of jury selection yesterday for her, which was always fun. The only downside of Judge Boyd's trial is you don't get to see the evidence unless you can see the reflection in the glass on the door on the back of the courthouse. There's not much there. I'm not sure what the case is, and obviously if it's a case that's got issues that we don't follow, we'd bail on it. But I want to poke my head down there, and we can skip through the breaks with her really quickly. She usually does pretty quick court cases. Does anyone know what type of trial Judge Boyd's handling right now before we commit to getting invested a little bit? Trial slated till next week mid. Whoa, it's a long one. It's a long one. Then we would be starting a case that we wouldn't finish till next week. Never seen a Judge Boyd trial. I'm used to watching your plea bargains. I've never seen something that lasts more than 2 days with Judge Boyd before. Anyone know what type of charges are involved in this one? Let's see. I'm gonna chance it. We're just gonna go there. Let's say sure. Let's see. We're gonna be box 4 will be 8.
Family violence. Good morning.
Good morning.
What? What did you just say?
It doesn't show that it's covered.
What did she just say there?
All right, so Cheeseman, is that family violence or criminal trial division?
Hi, Judge. It is, I believe it's family violence. Good morning.
Good morning.
It doesn't show that it's coded family violence, but I would believe that offense is family violence.
All right, Normie, could you have someone from family violence come down?
I think this is it should be for a trial.
So this is Cheeseman. She's requesting a travel permit.
Yes, Your Honor. She did request that. However, we kind of had a misunderstanding. She was told, I think by her, PO that she could travel, and that was for yesterday. She's present in the courtroom, but she canceled her plans because then we got notice that there was a hearing today.
1 second. It's on the wrong window.
All right. So I received a request for a travel permit, and the state is saying that they object to your traveling. Have you traveled before?
No.
All right. So they're saying they object to your traveling. And what I can tell you, defense, I always present these travel permits to the state to see if they have objections. If they don't have objections, usually I will sign them with, conditions that I want to impose. But are you going to have to travel again at any point in time?
There's a possibility.
All right, so let's go ahead and hear this and see what's going on.
Yes, Your Honor. Can I just, Your Honor, can I just have a minute to finish on the protective order docket? I'm closing out with a DA right now, and then I can be back in a couple of minutes.
Well, what I can tell you is in a couple of minutes, we're going to do a motion to suppress, and then we're going into a jury trial.
Okay. Ooh. I will be here. I'm here.
All right, thank you.
I'm going to be here.
So the court is calling NIMAC number 756623, State versus Tiana Cheeseman. Can I have parties announced for the record?
Ashley Jones for the state.
Terry Dye on behalf of Tiana Cheeseman.
And are you Ms. Cheeseman?
Yeah, from Tiana.
All right, so we're having a hearing with regards to the defendant's ability to travel. The court received a travel permit. The state was in objection to allowing the defendant to travel. I just have a few questions to ask you about the travel permit. Any objections to the court asking your client questions?
No, Your Honor.
All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Tiana Cheeseman.
All right, so with regards to your travel permit, what is the purpose of the travel?
It's a mental health conference. It's a postpartum support conference. This is from July 9th to July 13th, and it supports postpartum others with their perinatal mental disorders and so forth.
Okay, and Are there any other upcoming travel plans for you that you possibly see in the future?
There is one, I believe it's going to be in August.
Okay.
I'm not sure of the exact dates, but I think that's just going to be in Houston.
Okay.
That far.
All right, thank you. And here's my question. How long has this case been open? What's the offense date?
Your Honor, just permit me one moment to grab the computer.
And defense?
Yes, Your Honor.
With regards to this case, was CPS involved?
They've closed out their case.
I can skip ahead through this.
All right,
so
and can you tell me the placement of the child or children?
With my client.
All right.
Let me skip ahead just a wee bit.
And those children are the subject of this alleged offense?
One child, yes, Your Honor.
We're skipping ahead, sorry.
That's what I'm saying. Okay. All right, what date, Ms. Ferguson?
Set a date, and now they're done. Okay. Now she's got one more thing. She's got a evidence suppression motion and then trial. We're skipping ahead. Nothing, nothing, nothing. I just hit the wrong button. There we go.
It is. Who knew? But now I know. In the words of G.I. Joe, that's half the battle.
G.I. Joe. Bingo.
All right, we're going to go on the record in 2023 CR 10004, State versus Tyler Ashbaugh. Can I have parties announced, please?
Megan Galloway and Jason Garahan for the state.
Nathaniel Navy and William Salazar for Mr. Ashbaugh.
All right, and are you Mr. Ashbaugh?
Yes, ma'am.
All right. Just so attorneys know, you do not have to stand when you're addressing the court. It just makes it easy for the court reporter to hear. I don't take it as a sign of disrespect. I know in law school we were taught to always stand, and it's a hard habit to break. It was for me on the civil side until the judge on the civil side said, I'm going to fine everybody every time you stand. So I was like, all right, let me hold on to my seat.
So don't stand.
All right, so this is a motion to suppress, correct?
Yes, Judge, there's a number of pretrial matters, probably more expeditious to take up the motion to suppress, but there's also a motion requesting the state to elect which paragraph in count 3 that they are going to rely upon. But I can get into that argument later, and then various motions in limine.
Ooh, lemonade.
All right. I don't have copies of the motions. Do you have extra copies, or if you don't, I can have the clerks pull them?
I don't think I have extra copies, Judge.
Because how many motions do you have?
I'm sorry?
How many motions?
The motion to suppress, and then the one on the indictment, and then 2 motions in limine, Judge.
All right, so I have a defense first motion in limine and defendant's motion to suppress.
Okay. The one that's first motion in limine might be the first supplemental. There's just a motion in limine that was filed before that.
Okay. Let me see if there's anything else in the file.
This is Texas versus Tyler Ashwell.
Other motions. If you could let the clerk know what the motions are, or if you could make copies.
I can make copies. The only thing is some of them are marked up.
Okay.
But I can get with the clerk.
State, do you have copies of his motion?
I have a copy of the motion to suppress, but that's it, Judge.
All right.
I'm hoping
the defendant in this case is
we can pull those.
Is seated right up here in the middle. If you look, see the arrow in the middle of the screen at the bottom, just right above me, up there, right behind the lawyer who just walked by. That's the defendant. He's sitting on the side wearing the glasses. It's like the Harry Potter style glasses, Levi's, black shirt. Charged with aggravated assault of a police officer and deadly conduct, apparently. Just behind the defendant in the other window, you see the judge has a beautiful, beautiful DMB purse. This one looks like the Plumeria Suki crossbody. For those of you who are following along. Second DMB purse in a row. Selena K, can someone please let me know what type of purse she has today? There you go. Selena, as you were typing it, I was envisioning your question, and boom. Tyler Ashbaugh, age 22, was arrested and charged with 2 counts of aggravated assault with a deadly weapon against a peace officer. That doesn't go over very well in any state, and I think at least of all in Texas. So we're going to see how this goes. Can't help but notice there is a QR code on the wall behind the witness microphone. Don't think I can get that to scan. Do wonder what it says. Is it like the judge's social media? It's just a little too blurry. I can't get it to... Can't get it to work. This is the trial we heard the jury selection of yesterday. Everything is normal as far as resolution for me on this live stream, but I believe it's only provided in 720p. I can check really quickly.
And that's his original, and it wasn't too far.
All right.
I think I'll copy of the original.
Yes. Yes.
Yep, 720p. Lawyers getting dressed in the aisleway. Just pay no attention to that. We're going to skip ahead a bit. She's reading. Might be done. We're waiting for a document to be sent to her. Here we go.
All right. So then I have a motion to suppress. I have the first supplemental motion in limine. And the defense request for election. All right, so the motion to suppress.
You also have just the regular motion in limine, Judge.
All right. All right, so here's the thing. On the regular motion in limine, what is that specifically concerning? Because I don't have a copy of it.
Okay.
You can remain seated. Yeah.
It's such a habit.
I know.
Please don't find me like that.
No.
So the points in this, Judge, are any extraneous criminal arrests or misconduct. I believe those would be highly prejudicial and appropriate to limit this case to whether or not these alleged allegations occurred. Any of that could highly prejudice the jury against my client. And then there was discussion in his statement to Detective Tudor about Tyler engaging in drug distribution.
What?
That is not relevant to the case at all. There's no allegation that this involved drug dealing in any sort of way. It was more brought up when Tyler and Detective Tudor were discussing his finances and what he was doing to make ends meet. And so that would be highly prejudicial, Judge, if the jury were to hear that. I don't think it's probative at all to these allegations.
So your motion in limine is to request a motion in limine as it relates to extraneous offenses or conduct?
Yes, both of those. And then also to either mute or delete that portion of the statement if the state intends to offer that, of the statement that Detective Tudor took from Tyler, so that the jury does not hear that part. Then we have, I would request just that the state when Tyler is charged in front of the jury, not read the enhancement paragraph, as that only relates to punishment.
Oh, they're not going to read the enhancement paragraph.
And then also, we don't know if this is going to happen yet, Judge. We haven't made a decision. But if Tyler were to testify, he would not be able to be impeached with his juvenile adjudication. There's a specific rule in the rules of evidence that states it's not considered a criminal conviction or a felony conviction for purposes of impeachment. And the only purpose that it can be used in an adult criminal case is for purposes of enhancement after a conviction. It is not in any way considered a felony conviction. So if that were to happen, I would request that they obviously not mention it or not attempt to impeach him with that adjudication. Not even considered a conviction, it's just a juvenile adjudication. And then the last thing, Judge, is one of these search warrants, not for the real-time search, not for the real-time cell site information, but it was for his historic cell site information. You were the judge that actually reviewed that and signed that. I just request that that not be entered into evidence, as I don't want any juror misinterpreting that as a comment on the weight of the evidence from the court.
You mean the fact that I signed it?
Yes, Judge.
All right.
I'm just asking that it just, if they want to say a judge, but not be entered into evidence or not mention that the judge of this court signed this search warrant.
All right. So State, with regards to the motion, the defense motion in limine, I do see and understand the defense's argument that they would not want the jury to know that I'm the judge that signed the search warrant. So you want to address that as far as my signature being mentioned, or that it was this judge that signed that?
Well, just regarding that, I mean, they are specifically charged in the charge of the court that they are not to take any comment from the judge as giving weight to any evidence. And so that would just be my argument, that they're charged on that. I mean,
so are you intending on offering the actual warrant into evidence?
I don't have a yes or no, possibly. So
right.
I guess, I mean, at this point, regarding point one, the extraneous criminal arrest, I mean, I agree. If I believe that it becomes relevant at some point, I will approach the court and make my argument regarding that. Regarding point two, that's extraneous. I'll have a copy with that stuff redacted out and tender to defense for inspection prior to offering it. And then if I believe that that becomes relevant, I will approach before listening in testimony. Regarding point three, the enhancement paragraph, I agree to that. I would not read it for guilt innocent. And then point four is just the same thing about the criminal history 404.
All right. So with regards to any extraneous or conduct, if you feel that you're going to ask any questions or elicit any evidence to that, you all will need to approach and we can have a hearing outside the presence of the jury. I don't know anything about this case, so I don't know if it's relevant or not. I don't know if it should be admitted or not until I hear certain things. With regards to the warrant issue, if you are seeking to enter the warrant into evidence with my signature on it, then I'll address that issue at that time on whether or not it should be entered before the jury with my signature, or it should be stated that I'm the judge who signed it. So I'll address that at that time. All right. Does anyone want to address the next motion in limine is your spousal privilege motion? Or is there another?
Please give me a second to pull that up. Okay. So at the time that this allegation came about, Tyler, his girlfriend, Tatiana Martinez Escobar, they were dating, they were living together.
Tatiana.
They had a child together. Since then, they got married. They have a second child together, Judge. The state has subpoenaed Miss Martinez, Tyler's wife. Under Texas Rule of Evidence 504, the spousal testimony privilege, not the immunity, but the spousal testimony privilege, a spouse, and it does not matter when they were married. It doesn't matter if the marriage happened after the alleged offense, before, whenever it happened. It's just a rule that the state cannot call the spouse of an individual as a witness for the state. And there's no exception to that. There's a number of exceptions listed in that rule, but there is no applicable exception under Rule 504, Judge. And so this rule is, I believe, very clear cut, that the state just cannot call her as a witness for the state. Now, if she's not called for as a witness for the state, I would also argue that if they tried to address any statements she made, whether that would be
hearsay,
a typed statement in this case from her, it's not recorded or anything like that, but it's a typed statement, that would be hearsay.
But according to the rule, the person who claims the privilege is not your client. It would be the spouse who made the communication, correct?
Well, correct, but I don't believe it's not. It is the spouse, but the rule takes into account the spouse of the accused.
But no, it clearly states under 504 who may claim the privilege. The privilege may be claimed by the communicating spouse. So in this instance, I'm assuming you're stating that the communicating spouse is his wife.
Correct, Judge.
So it's not his privilege to claim, it would be the wife's privilege to claim.
No, yes, I misunderstand. Yes, you're exactly right on that. It is my understanding that she intends to claim that privilege.
Well, we'll cross that bridge when we come to it.
And I would part of that motion in limine is that if the state wants to call her as a witness, despite knowing this rule, I would ask that be done outside the presence of the jury. Courts have ruled that that is actual reversible error to call her as a witness in front of the jury and then have her invoke the privilege in front of the jury. That's prejudicial, and that would be a reversible error.
Well, here's the thing. Number one, she hasn't invoked spousal privilege. Number two, there are other steps into 504 under that rule that have not been met at this point in time. So there are different steps. One, whatever communication was, what was the communication? Number two, was that communication intended to be private by the person who's communicating it? So those are all steps that have to be gone through. And unless, somebody's going to testify and say, this is who these communications were made to. They were intended to be private, and this is how it was intended to be private. But my understanding of the case law is if there's a communication between spouses and it's not intended to be private, i.e., they're not the only person who is communicating the information to their spouse, they've communicated to the mother-in-law or whoever it may be, then 504 does not apply.
And Judge, I would disagree. There's two things. There's the spousal immunity, which I believe the court's referring to, and then there's the spousal privilege.
No, this is privilege. A communication is confidential if a person makes it privately to the person's spouse and does not intend its disclosure to any other person. A person has privilege to refuse the disclosure and to prevent any other person from disclosing a confidential communication made to the person's spouse while they are married. This privilege survives the termination of the marriage. So if the communication is not intended to be confidential, then the spousal privilege doesn't apply. For example, if Jane Doe were married to John Doe and they communicate something to them, and then that same communication that they communicated to their husband, they communicated to a third party, then that's not confidential. It's similar to if you have discussions with your client, that's confidential. But then if your client goes and discuss that with other people, then it's not confidential because the privilege, in this case, the privilege belongs to your client's spouse and the person who is communicating whatever they're communicating.
And Judge, if I could just differentiate, sure. I believe that 504, there's two parts. There's 504A, which is the confidential communication privilege. And I believe that's what the court is stating survives if the marriage ended and she wanted to testify, that's where Tyler could claim this was intended to be private and bar that as long as there were no exceptions from being entered into evidence. We are relying on 504B, privilege to not testify in a criminal case, where it says the general rule is in a criminal case, an accused spouse has a privilege not to be called to testify for the state.
And who may claim the privilege? The privilege not to testify may be claimed by the accused spouse, not by the accused. So you need to have whoever the communication is supposed to be from, that person needs to come in and claim privilege, and they probably need an attorney. So does that person have an attorney?
That person does not have an attorney, Judge.
Does that person need an attorney appointed?
I have no reason to believe that person needs an attorney. I don't think there's any allegation that the state believes there's any criminal activity that was
I have no idea.
That was committed by this person. So I do not believe she needs an attorney.
Regarding her testimony, it's not anything that she could be charged with, to my knowledge.
And so obviously I don't know who the state is going to call.
All right, everybody is using terms of I believe and to my knowledge. So it's up to whoever the witness is. If that witness feels they need an attorney, they can't afford an attorney, the court will have an attorney appointed to them. Now, so with regards to that, I'll need to hear from that witness whether or not they're claiming privilege. So let's move on to the motion to suppress.
And then Judge, I'm sorry, just one last point on that. If we're waiting,
sit down.
If we are waiting to make a decision on that, I would request that the state refrain from mentioning any statements made by that spouse, because the court hasn't ruled on this.
Statements made by the spouse when?
Any of the statements made by the
spouse. No,
spouse.
I mean, when are you objecting to them presenting that?
In opening and at any time before she testifies.
All right. So
I would argue she cannot testify, but for the state, but if they are attempting to, and the court rules against me, I would object to them mentioning any statement she made, whether that's text or the type statement, at opening or at any point before they attempt to call her as their own witness.
All right. With regards to opening statements, the court is not going to allow the defense to preclude the state from making their opening statements. Opening statements are not evidence. Parties are required, although I see some people don't do it, parties are required to let the jury know this is what we expect the evidence to show. And if the evidence doesn't show what they expect it to show, then it doesn't show it. All right, let's move on to the motion to suppress.
Could look bad on the prosecution to say his wife's going to say this.
Counsel, what are you seeking to suppress?
Give me 1 second to get to that, Judge. So we are seeking to suppress the fruits of the search of Tyler's apartment complex and his statement given to Detective Tudor.
Oh, wow.
Okay.
Everything you found in the search and what you said to police.
Apartment complex. And when you say the search of the apartment complex, do you mean his specific apartment?
Only his specific unit, Judge, yes.
All right.
He wants to stand every time the judge talks to him.
So the search of his apartment.
Yes. And everything that was discovered and seized as part of that.
All right. And then also you say the statement.
Yes, his statement, his reported statement to Detective Tudor that was taken immediately thereafter, where he was arrested and taken to Bexar County downtown to give that statement. Judge.
All right. And was this done under warrant or not?
There was no warrant. No, there was. So how they discovered Tyler's location was they tracked his cell phone in real time without a warrant. And so our argument is there's two reasons why this was illegal.
No. I mean, I just want to know what are you seeking to suppress, and then we can call witnesses, or you can call witnesses and we'll see where we go.
I understand, Judge.
All right. And state, do you stipulate that there was no warrant?
Regarding the phone pinging, yes, I stipulate that there was no warrant.
All right. And are the witnesses here?
Yes, no.
All right. Who's the first witness?
And Judge, I believe that because it's warrantless, the burden shifts to the state now.
All right.
It's on the state.
Yes, I mean it does.
Okay.
All right.
It's a good lawyer.
It calls Chad Tudor.
So now the state's trying to prove that it was done legally and they didn't need a warrant. Is that what we're getting right here? You're still in the motion to suppress. Trial hasn't started. We haven't had the opening statements yet. Welcome, Chad. Come sit down in front of the Alamo.
Good morning. All right, do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand and have a seat. There should be a square microphone. If you could put that on your lapel or somewhere, it's for the court reporter to hear.
This way.
Yes. And just remember to take it off before you leave.
Oh, yeah.
All right.
Forget.
All right, if you'll state your name for the record.
A square
Good
microphone.
morning. My name is Detective Chad, Chad Tudor. T is in Tango, U, D is in Delta, OR.
All right, you may proceed.
Good morning, Detective Cheater. How are you currently employed?
I'm assigned to the San Antonio Police Department Homicide Unit.
And are you a certified peace officer?
Yes,
How long have you been with the San Antonio Police Department?
14 years.
And how long have you been with the homicide unit specifically?
The last 4 years.
What are your duties as a detective with the homicide unit?
I'm currently assigned to the murder detail. So I investigate
murders,
suspicious deaths, suicides, accidental deaths, overdoses, homicides, and even officer-involved shootings.
Okay. Back in June of 2022, were you assigned to the homicide unit?
Yes, I was assigned to the aggravated assault detail.
Okay. And under the aggravated assault detail, were your duties to investigate the same offenses?
It was different. It was misdemeanors, including assault bodily injury, and then I also had felonies, including aggravated assaults with deadly weapon. And in this particular case, I was asked to investigate this officer-involved shooting.
Okay. Do you recall the SAPD case number associated with this case?
I do not.
Did you write a report that reflected your investigation at the time that you were conducting your investigation?
Yes.
And would it help you to refresh your memory if you have a copy of that?
Yes.
Okay, so we'll have his report. Give him some light reading material.
So I'm showing you, is that an accurate, fair and accurate copy of your report?
Yes.
And was that authored by you?
Yes.
Okay. And just know that you can use it to refresh your memory, but please don't read it. Okay?
Yes.
Okay, so what is the SAPD case number associated with this investigation?
It's SAPD 22108-229.
It's the San Antonio Police Department.
Now, do you recall how you were assigned to this investigation?
I was told the details of this incident when I arrived at the headquarters that morning. My duty hours that day were 7:45 to 17:45, and I was briefed on the details of this incident because it happened in the early morning hours while I was at home.
Okay. And so the incident occurred prior to your duty hours, is that correct?
Yes.
Okay, so when you arrive at the homicide office, you're briefed as to details, is that correct?
Yes.
All right, and so there had been some investigation conducted prior to your involvement, is that correct?
Correct.
All right, and so at the time that you received the case, were you starting to develop a suspect?
Yes, fairly quickly. The details were that officers were parked at a church, working on reports. A white SUV drove through the parking lot, and the officers reported that the vehicle shot at them. One of the officers was able to exit from his vehicle and return fire. I was told that patrol officers were in the area and located a vehicle in a neighborhood not far from the church. And they made contact with an elderly person that was there that said, you know, my son or stepson or grandson, I can't remember the relation. Tyler has been driving this vehicle, and that's kind of where, you know, I kind of took off with everything.
Okay. And so after you received that suspect information, there were other reports in the database that linked the defendant to the car and the home, is that fair to say?
I believe so.
And when I say the home, I mean the location at Buckmore.
Can you repeat that part? I'm sorry.
So when I said linking the defendant to that home, I was referring to the Buckmore location where the elderly man was. Is that correct?
I believe there were reports. I can't remember. Can I look through here real quick just to see if I notated that?
Yes, go ahead.
Pretty crazy. The cops are just sitting in their car working on reports, and suspect allegedly drives by and shoots at them. They return fire. Am I hearing this right? That was the start of the incident?
I'm not finding anything right now.
Okay. I'll just move on from that question. So once you received the suspect information, what were the next steps? Well, I guess let me look that. When you received the case, you spoke with somebody by the name of Joseph Gonzalez, is that correct? If you want to flip to page 4, please.
Flip the page. Hello, welcome, Broken Bakers.
Joseph Gonzalez.
Yes, at 10:27 hours.
We're still in a holding pattern for the Raul Valle verdict. Jury's deliberating.
You said page 4?
Page 4 at 10:47 hours.
Does this officer even remember this happening?
I don't.
Judge does have a new purse every day. Most of them have been purchased by her mother for her, but I believe she has hundreds of purses.
Sean.
Okay, yes, at 10:47 hours, I called phone number 210-854-6117. This number was given to me by Joseph Gonzalez, parent of Tyler Ashball. And Joseph told me this phone number was a phone number for Tatiana, Tatiana's father's phone number. Tatiana was in a relationship with Tyler.
Okay. And so were you able to make contact with someone at that 210-854-6117 phone number?
Yes.
Do you recall who you made contact with at that phone number?
The father of Tatiana, and his name is Daniel Martinez Escobar.
Okay. Were you equipped with a body-worn camera at the time that this conversation took place?
Yes.
Okay.
Okay, if this guy did what he's allegedly charged with doing, just rolled up on a couple cops sitting in a church parking lot and opened fire.
All right, I'm showing you what has been marked as State Exhibit R1.
Like next level dumb
can you tell me
criminal
what that
stuff.
is?
It's a copy of my body-worn camera.
And how do you recognize it?
No jury yet.
I've
This is a
initialed it
pretrial motion.
and put my name or my initial CT in badge 2841.
And have you previously reviewed it?
Yes.
And is it a fair and accurate depiction of the events as they occurred when they occurred?
Yes.
This time, tender's defense for inspection and offering states R1.
No objection.
And what is the state's exhibit number, please? R1? All right, then state's exhibit R1 is admitted for purposes of this hearing.
Permission to publish, Your Honor.
Granted.
We usually don't get to see these. It's a pretrial motion. The defense is trying to keep some evidence out, specifically his wife's comments, his own statements. We can see that it's playing, but that's it. It's up in the corner. We'll have to just make up a video in our head for what's happening. What was the weapon of choice mentioned? I don't know. I'm guessing probably a pistol if someone was driving. Let's just...
My name is Detective Tudor with the Cellphone Police Department Homicide Unit. I was trying to reach a Mr. Daniel Escobar. Hi, sir. I got your phone number in regards to an active investigation that I'm on. I'm trying to locate an individual named Tyler Ashfall.
Okay. Oh my God.
And so I was given information that you are Tatiana's dad.
That is correct.
Yes. So it's nothing right now that involving her, I don't believe.
Oh my God. Don't scare me, man.
Yeah, no, I'm not trying. I wanted to just come out and say it's nothing right now with her, but he was, we believe, involved in an incident last night. And I'm trying to find him. And yeah, that's how I got your phone number because of this kind of incident. There was an officer involved shooting.
Oh God. Oh, are you serious?
Yes.
Oh my God. We got a child together, man. Come on.
Yeah.
What the heck is wrong with these kids, man?
So Daniel, so what I'm trying to do is just, I'm trying to make sure that, she's okay. I don't believe, I don't even have enough to know that if she was with him when this happened. There's just a lot of info that I don't know. But I do believe that he was possibly involved in this. And it was over off O'Connor Road.
Oh my God.
Do you have any idea?
What else can you tell me about this? I mean, it can't be that she was with him. Come on.
I don't know. I don't know anything. I'm trying to find him.
You're trying to find him?
Mm-hmm.
Shoot, off my mind, I can't tell you the areas. I know how to get there.
Well, I know that, I guess they have an apartment somewhere like Oak Valley.
Correct.
Okay.
Okay, so I'm pausing the state's exhibit at this point in your conversation with Mr. Martinez Escobar. He confirmed that the defendant was living at the Oak Valley apartments. Is that correct?
Yes. Do you have a good phone number for her?
Yes.
I have 854
867-5309.
Hang on. What number do you have?
867-5309.
Okay.
Are you okay?
That's what I'm trying to figure out. Like, I'm trying to, make sure Tyler's not hurt.
Yeah, that's the reason for his call.
What has happened and why?
That's what I'm trying to figure. That's what I'm trying to figure out. Officers are sitting in a parking lot and start getting shot at, And then we find this vehicle with bullet holes, busted out windows, and it's parked over at Tyler's grandpa's house. Over off Buckmore.
I don't believe it's his grandpa. I believe it's like his stepdad.
Okay. Yeah, it's one of those relatives.
Yeah, it's
So, yeah, and so I'm trying to make sure, one, Tyler's okay, and that, this, nothing else is gonna
I have to
happen.
call my daughter.
Yeah, I need to find her because I don't know how
I need to
he's.
call her right now.
Can you?
She's got my granddaughter.
Okay. When was the last time you spoke to her?
And my wife, I think, spoke to her yesterday.
Okay. This all happened at like 2 this morning.
Oh. What is this kid involved?
Yeah, and I'm just trying to make sure that
part of the shooting is.
that's what I'm trying to figure out. I mean, there's a car that that grandpa or whatever, we don't know that relation, stepdad or whatever, said that Tyler's been driving this car for the past week. So I don't know where Tyler is. I've got a car with bullet holes on it, and officers, telling their side of the story.
Okay.
So I don't know if was she in this car with him? Is she okay?
I need to call her.
Yeah. Can you get my write down my information and call me right back?
Can you hold on the line? I'll call her.
Yeah, absolutely. Absolutely.
Okay.
And then Daniel? I was trying to call Dad's trying to call.
You didn't know anything about it?
So yeah, I just figured that. Make sure she's okay. She was in his phone.
Why would somebody just drive by the cops, just start shooting?
Do you have the apartment number? What?
This is all preliminary trial stuff, so.
I think there's detectives over there right now. I do understand. Can you call them?
Can you call them? Can you? I need to figure out what the apartment number is.
Can you try and call her first?
I just did.
What did it do?
It went straight to voicemail.
What the state's trying to prove right now is they had reason to take her phone without a warrant.
How does she typically get around?
Usually, either I go pick her up or I'll bring some over.
Does she work or?
She's staying at home with the baby.
Okay. The grandfather, step grandfather, he gave Sonia Esteban, I guess your wife's info too. Since I made contact with you, I guess, is she there too, or does she know?
She's at work.
Okay.
And she might know the apartment number. Do you want me to call her?
Yeah, I can stay on hold.
Okay.
He's gonna call his wife to confirm the apartment number.
We're gonna give you the link of where to watch this when I'm gone, so you guys can stay up to date on this.
Do they know
Okay, so at this point, while he has confirmed the apartment complex, has he been able to confirm an apartment number?
No.
And did you advise him that you believed detectives were already at that apartment complex in general?
Yes. Yeah, something. Valle. Valle apartments.
Okay, and pausing the state exhibit, what are you currently doing on your phone?
I think I was trying to verify an address for Oak Valley, so I was doing like a Google search, I believe.
Okay. And I guess, did you ever make the location of the Oak Valley apartments, or did you send a different unit out there?
No, so the person that I'm talking to, kind of like having a sidebar with in the vehicle, is a sergeant.
A sidebar in the vehicle.
He's actually my current sergeant on the murder detail as well, Sergeant Marfin. So he was on the phone, kind of helping me out, relaying information to detectives with our covert unit, plainclothes detectives that were actively looking for Tyler.
Okay. Thanks.
You have a light bar on a vehicle. You can't have a sidebar on a vehicle, though. It's just not allowed.
Yeah, oh god, 12/6. Yeah, he's pretty good. He's been pretty good. He's going to take the bolts now. I don't know any payment issues.
So the wife might claim spousal privilege and not testify against the husband.
Yo, you still there?
Hello?
Yes, sir. Camera?
Okay, she doesn't know the apartment number either.
Okay, it should be.
There's officers there. There's a compactor. Across from the compactor, the first building on the right. There's a hallway. It's the first apartment on the left.
Okay, it should be.
Okay, and so at this point, did Mr. Martinez Escobar give you specific instructions as to where the location is?
Yes, he's describing the apartment location.
Okay, and so I guess, do you recall what floor he said that the apartment was located on?
I believe he said first.
Okay, and he said that it was across from the compactor, is that correct?
Yes. 607 Judson. I think that's what it is.
Oh, I can't believe it. I know how to get there, but I don't talk to you. I'm sorry.
No, you're fine. You're fine. Do you have a?
Need to get on over there. I want to make sure that my daughter's okay.
Yeah, I do understand your concern as a parent. I'm a parent as well.
That my wife wasn't about to clock out and go over there. I told her not to.
Yeah, because I think there's plainclothes detectives over there trying to do some surveillance, and I just don't know where he is, what kind of mindset Tyler's in.
Okay. Is that car there?
No, we have the car. We have the white SUV.
Okay. Well, I'll keep trying to call my daughter. It's a good number.
Yes. Well, I don't know what pops up on it. Can you have a pen? I'll give you. I'll give you all my info.
Just as wireless caller, give me a second.
Yeah.
I'm feeling like throwing up
No,
now because my granddaughter is with her.
Is there anybody else any other family that they, where she might be, or do you have any other information that might help me find?
It'd be there or here.
I gotcha.
Okay, what's your number, sir?
Yes. So my name is Detective Tudor. T is in Tango, U, D is in Delta, O-R. And my phone is
867-5309 for a good time call.
210-37.
867-5309.
And my badge number is 2841. Yeah, I mean, there's more questions than answers right now, and I'm just trying to,
I just want to make sure that my granddaughter and my daughter are okay. So if you hear anything, could you please let me know?
Yeah, absolutely. And if you guys hear anything, can you please?
You need me to stay away.
Please let me know.
I can't go over there.
No, I would stay away from that location for now. Continue to try to reach out to her.
Okay. With my wife, hang on.
Okay.
Are you telling me I can't go?
What's up?
He wants to go over there. Yeah, this detective is going to ruin your son-in-law's day, is what's going to happen when you call him.
And the person that we just saw walking on the right side of the vehicle, is that Sergeant Marvin?
Yes.
We didn't see that part.
There.
Who's they? Both of them? Who's telling you this?
His wife is telling me that Tatiana just called her back now.
What is she?
This wouldn't be a prank or anything like that.
Sir, no, this is not. I can give you the case number. I'm
I believe you. I mean, I'm seeing your phone number. I work for this.
okay. What is Tatiana?
Supposedly enter in the apartment, and my daughter said that she didn't see anybody out there.
What did Tatiana tell your wife specifically?
Okay, you want me to call her back?
Can I? Is this the 85? Is she 85461?
Wait. Don't. Easy there with the numbers.
Yeah,
over there.
No, let me call her real quick.
Same reason, so.
Let me call her real quick.
Okay.
All right, thank you, sir. Hey, Mr. Escobar, what's a date of birth for you?
Nothing.
Well, my birthday? That's none of your business. It's Nunya.
419.
Nunya.
Okay, I appreciate it. I'm gonna call Sonia real quick.
Yes.
Okay, and so up until this point, Mr. Martinez de Escobar made contact with his wife. Is that your understanding?
Yes.
Okay, and so what he's relayed to you at this point is that both the defendant and Tatiana Martinez Escobar were in the apartment at the Oak Valley location. Is that correct?
Yes.
Hello?
Hi, Ms. Escobar. This is Detective Suter with the San Antonio Police Department.
Yes, sir.
I'm sorry to startle you and Daniel. I'm trying to locate a Tyler Ashbaugh and make sure he's okay. And then I don't know if Tatiana was with him early this morning when all this happened. It's a shooting that I'm investigating. But I'm trying to.
She's not surprised.
There's a lot more questions than answers right now. Is Tatiana saying that she's over there off Oakview or at Judson at the apartment?
Yes.
What's the apartment number?
I don't know the apartment number. I was trying to get in.
Did she say who was with her?
No, she said Tyler and the baby are there.
She said Tyler and the baby?
Are there with them.
Okay. Okay.
And
Okay, and so the female that you're speaking with at this point, who is that?
The Daniel Escobar's wife, and it should be Tatiana's mom, Sonia.
Okay, and who did she tell you that was inside of the apartment?
She said that Tatiana, Tyler, and their baby were all at their apartment.
Okay.
I asked her if she was okay. And she said, why? I said, well, because supposedly something happened over there at the dad's house. My was at that's okay. My husband told me. So
She told you, she said Heather is right there at that office.
yes.
Do you know the apartment number?
I don't know.
Okay, let me call you right back.
Okay.
She said she just spoke to her. She's at the apartment and Heather was in there. It's on Judson. No one knows the apartment number.
They said they figured it out because he's on the video.
Okay, so what did Sergeant Marvin just tell you right then?
He's telling me that they figured it out. When he's saying they, I know he's talking about the covert detectives. He said that something about a water bill.
That the defendant was on a water bill at the location, correct?
Yes.
Okay.
They went through her mail?
He's saying the baby's in there. It's a 2 or 3 year old, and that Tyler's in there. And she's like, what's going on? She's like, she doesn't know. Just got
Can't just go through somebody's mail without a warrant. That's a felony, right?
Okay.
This is, we are almost live. We're about an hour behind on this case.
Information to.
I don't know if it was in direct contact with one of the covert detectives or the covert supervisor.
Okay.
It was someone with covert.
All right. And then eventually the defendant is taken into custody. Were you able to conduct an interview with him?
Yes.
And was this interview recorded?
Yes.
Okay.
Okay. Hold, please.
I'm showing you what's been marked as State's Exhibit R2. Do you recognize that?
I think garbage is fair game.
What is it?
This is an initial copy by myself of the interview, the recorded interview with Tyler Ashball.
Okay. And have you reviewed it?
Yes.
Is it a fair and accurate depiction of the events as they occurred on the date?
Yes.
And was this interview conducted while the defendant was in custody?
Yes, he was arrested on a traffic ticket warrant.
Okay, and did you read him his rights in compliance with 3822 of the Texas Code of Procedure, Criminal Procedure?
Yes, at 13:58 hours, I read Tyler his Miranda rights, and he acknowledged that he understood his rights.
He was
I'm
Mirandized.
tendering to defense for inspection and offering State's Exhibit R2.
No objections.
All right, State's Exhibit R2 is admitted for purposes of this hearing.
Permission to publish, Your Honor.
Granted.
If they don't get his statement thrown out, I bet he changes his plea. Let's see what happens here. We're waiting. So he has a traffic ticket, gets a warrant on the traffic ticket, and then he opens fire on police that are doing paperwork in a church parking lot. That's like the sequence of events as the state set them out. I still haven't got to the part where they used a live search warrant for his girlfriend's phone to find out where he is. Seems like they used a water bill of some sort. Could have been from the garbage, which might be legal. If it was from the mailbox, that would not be, I think, without a search warrant.
Yes, sir. Very good.
I'm the secretary. You all right?
Okay, yeah.
So that you might have to go to the bathroom or something.
Yeah, let's get this done first.
I'm looking, there's two sides to every story, so I'm trying to figure out, I was asleep at 2 a.m. when all this apparently happened, right? So I'm trying to figure out what happened. Before I talk to you, I have to read your rights, okay? Before you're asking any questions, it is my duty as a police officer to advise you of your rights and to warn you of the consequences of waiving these rights. You have the right to remain silent. You do not have to make any statement, oral or written, to anyone. Any statement that you make will be used in evidence against you in a court of law or at your trial. You have a right to have a lawyer present to advise you before and during any questioning by police officers or attorneys representing the state. You may have your own lawyer present, or if you're unable to employ a lawyer, the court will appoint a lawyer for you free of charge now or any other time. If you decide to talk with anyone, you can, and you can stop talking to them anytime you want. The above rights are continuing rights, which can be yours by you at any stage of the proceedings. You understand these rights?
Yes, sir.
Before
you read them.
Okay, and so what we just saw
Slurred them a little, but
R2 is you reading the statutory warnings to the defendant and him acknowledging them and waiving them, agreeing to speak with you. Is that correct?
Correct.
Maybe
have the witness on.
All right, just give me 2 minutes.
maybe he was mad that the ticket wasn't dropped to impeding traffic. There's now 3 sides to every story. All right, Judge. Just need a quick break. Where'd you go? This is a pre-trial motion. The jury is waiting. They're in the courtroom waiting. Not in the courtroom, in the courthouse. They have not heard this. This is a motion where the defense is asking that evidence be thrown out because of an illegal, according to them, illegal seizure of the girlfriend's phone, which the state stipulates that they took it without a warrant. There are some situations where they would be allowed to do that. So the burden has now fallen on the state to prove that situation exists. So we have evidence to counter that claim that the search was illegal of the phone.
Proceed with your question?
Yes, Judge.
All right, you may proceed.
Good morning, Detective Tudor.
Good morning.
As you stated, you were assigned as the lead detective to investigate what you described as an officer-involved shooting, correct?
Yes.
Okay. And this took, you stated that you believed that officers were fired upon by an individual, correct?
Yes.
Okay. And through your investigation, you identified a possible suspect as Tyler Ashbaugh.
Yes.
And what we were seeing in this video is you were attempting to locate Tyler, correct?
The prior video? Yes.
Yes, sir.
Yes.
Okay, you were trying to locate Tyler. You did not know exactly where he was at the beginning, correct?
No, I was trying to find him.
Okay. And you spoke with Tyler's father, correct?
Yes.
Okay, Joseph Gonzalez?
Yes.
And he was unable to provide you where Tyler could have been, correct?
Yes, he made confirmation by a name of the Oak Valley. He never provided me with an apartment number or address.
Okay, so he could not provide you with an apartment number, correct? Okay, just the name Oak Valley Apartments. And he was able to provide you, though, with Tyler's girlfriend's father's number, Daniel.
Yes.
Okay. And we saw you speaking with Daniel Escobar.
Correct.
And in that video, we saw that Daniel was also not able to provide you with the specific apartment number that Tyler was in. Is that correct?
Correct.
I think he confirmed that it was also Oak Valley, but didn't know the unit number, correct?
That's correct.
Okay. And in your report, you state that when you were talking to Daniel, you did not have enough information to know what happened.
Today,
correct?
just no questions today yet.
Correct. It was a very active investigation.
And he told you that Tyler lives with Tyler's daughter and Tatiana.
Yes.
Daniel.
Yes. Yes.
Okay. But as we stated, Daniel didn't know the exact number.
Correct.
Correct. And so Daniel called his wife Sonia in an effort to provide you with more information, correct?
Yes.
Okay. He was trying to be helpful in your investigation.
Yes.
And after he called her, they were still only able to provide the apartment complex and not the unit number, correct?
Yes.
Okay.
They were pretty much providing the same info, and then one kind of described the trash bin and first floor, but they relatively the same information.
Okay. Did you speak with Sonia?
Yes.
Okay. And in your conversation with Sonia, she was also not able to provide you with the unit number.
Correct.
Okay. And then at some point, you state that you informed the covert detectives of the information you've been given, but at that point, they already told you that they've already located the apartment number.
Yes, and this is all getting relayed to me through my sergeant that's talking with them.
I understand. So at this time, you are trying to relay everything that you know, which is the unit and possibly some directions, but not an apartment number, correct?
Correct.
And when you do that, you are informed that we've already located the unit number.
Yes, I put at 11:03, and he said, I think they figured it out. And then at 11:08, I was told that they had a visual of Tyler opening the door to the apartment.
Okay. And you would agree with me that in your report, there's no mention of a water bill being used to locate Tyler's apartment, correct?
No.
Okay. And you're aware that other detectives state that they were able to locate Tyler through his real-time cell phone tracking.
Sorry, I don't understand that question.
Are you aware that other detectives state that the reason that they were able to locate Tyler was through his real-time cell site data information?
I don't recall those specific details.
Did anybody inform you of that, or you just not recall?
I don't recall.
Okay. And did you know that that was done without a warrant?
I don't recall.
Okay. So you had no involvement in real-time cell site location information?
Correct.
Okay. And detectives shortly thereafter, confirming that they find the apartment unit that Tyler is in, take him into custody.
Yes.
Okay.
I've notated 12:06. While I was canvassing for video, I was notified that Tyler was in custody on the active municipal court traffic warrant.
Okay. So he was taken into custody for a traffic warrant.
Correct.
There was no arrest warrant for aggravated assault on a public servant at that time.
No.
There was no warrant for deadly conduct with a firearm at that time.
No.
Okay. It was just because he had an existing traffic warrant that he was arrested and taken in.
Yes. And obviously come down to hopefully find out more about this incident.
Okay. So he was arrested on the traffic warrant with the hopes that you would find out more about this incident.
Correct.
Fair to say it wasn't because you guys were interested in some traffic warrants, right?
No, he had an arrest warrant, so that's a way to bring him to headquarters and see if he'll talk.
It was a way to get to the point of talking with him without having that arrest warrant for that specific offense yet.
Correct.
Of aggravated assault with a public servant or deadly conduct.
Correct.
Okay.
Okay, where are you going, defense attorney?
And after he's arrested, he is immediately taken to SAPD headquarters so that you can talk to him, correct?
Immediately, I'm not sure. It was shortly after that. I think it was 1:00 was when I started talking to him. And he was in custody a little after 12, so fairly quickly.
Fair to say that was the next place he went.
Correct.
Was to SAPD headquarters right after he's arrested.
Correct.
And that was the next phase of the investigation, was to get a statement, correct?
Correct.
There wasn't anything that happened between the statement and his arrest that was part of an investigation into Tyler.
No, when he was brought down, while he was being brought down, we were also executing a search warrant for the apartment.
I understand, but I guess I mean in relation to just Tyler. There was nothing taken from him. There was no swabs or DNA done. The next thing that happened to Tyler after he's arrested, you talked to him at headquarters, correct?
Yes.
Okay. About the witness.
No further questions.
All right, thank you. You may step down. I'll move the microphone.
Thank you.
Okay, state.
And if you'll leave the exhibit with the court reporter, please.
Yes. RARFIN. It was in November. Sorry.
He likes that chair. No, you can't take it with you. Just leave, sir. Just there you go. All right, state. Who's next? Kinnick did get reassigned. He's
next
in the
witness,
field
please.
The state calls Joe Rios.
Look this one over.
Paging another witness, Joe.
And then after, is this the last witness?
There's 2 more, Judge.
Okay.
I don't think they should last very long, Judge.
All right. And then after this happens, I'll make a ruling on your spousal privilege.
How can you make a ruling on spousal privilege if the spouse doesn't get up and claim it?
No. No, this is all I have.
We're still on verdict watch for the Valle.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, thank you. You can have a seat. If you put that square microphone on your lapel or somewhere, it's for the court reporter to hear. And if you'll state your name for the record.
Joe Heriberto Rios.
All right, state, you may proceed.
This is the girlfriend's dad.
Detective Rios, how are you currently employed?
I'm a investigator with the Texas Board of Criminal Justice, Office of the Inspector General.
Are you a certified peace officer?
I am.
How long have you been a certified peace officer?
Since 1999, approximately 26 years.
Okay.
Is he undercover?
Did you previously work for the San Antonio Police Department?
I did from December of 2000 through September of 2023.
Okay. And in the year 2022, did you work with the San Antonio Police Department?
Yes, I was assigned to the rapid response team in the repeat offender program.
Okay. And as a detective with that unit, what were your duties?
Our primary task in the rapid response unit was to locate violent fugitive offenders.
Okay. Do you recall the SAPD case number associated with the call that we're here for today?
Yes, ma'am.
Do you recall the SAPD number?
Oh, the case, no, I can't, sorry.
Okay. Did you write a report at the time of your investigation?
I did.
Would it help you refresh your memory if you were able to have a copy of that?
Yes.
Can you take a look at that for me?
Okay.
Does that appear to be your report?
Yes, it's the supplement report I wrote on the date.
And it's authored by you?
Yes, it is.
And you recognize it to be true and accurate?
Yes.
Okay, so you can use it to refresh your memory, just please don't read it.
Yes.
So what was the SAPD case number associated with the call?
The SAPD case number, SAPD 22108229.
Okay. And do you recall how you were enlisted to help in this investigation?
Yes, ma'am. My lieutenant at the time, Justin Good, called me up on the weekend. I was one of the lead investigators. A unit was newly created around that time. Was one of the senior guys in the unit. He called me up, said they had an incident involving a couple of SAPD officers that had been shot at. They had some information on a suspect and they needed help locating him.
Okay. And so did you have suspect information at that time?
Yes.
Do you recall who this suspect's name was?
The name I was given was Tyler Atlaw. I don't know if I'm saying that correctly, the last name.
Okay. And so can you walk us through some steps that you took to conduct your investigation and learn the location of the defendant?
At the time, they were getting information. The vehicle had already been recovered. Different officers or detectives, I'm not sure, things were getting added to the call. Well, we call it the key card, but the incident detail report. There was a previously known vehicle that he had been ticketed in the year prior. There was a cell phone that a number that was provided that was supposed to be his. During the conversation I had with the lieutenant, I told them because of what had transpired, the officers returning fire, the suspect still being at large, that there was exigency to go up on the phone to locate him, whether for the safety of other officers or the general public, or if he had been shot during the course of the exchange, he needed medical attention.
Okay.
We were worried about him.
Regarding, I guess let's start with the vehicle information that you obtained from the key. What did you do with that information?
That information was put into a system called Vigilant. It's a license plate reader system. All that does, it uses, there's different tow truck companies or private companies that do vehicle recoveries, whether it's for apartment complexes or car dealerships. These different, you'll kind of see them riding around on the tow trucks. They look like little square or rectangle lights. They read license plates in and around an area, so San Antonio. The license plate that he was ticketed in the year prior had popped up at an apartment complex 74 times. So that was likely a location that he resided at or stayed at frequently.
Okay. I'm going to show you what's been marked as State's Exhibit P3.
I don't like the collection of this data.
Yes, this is the Vigilant analysis report that was returned back on the vehicle.
Okay, and you're the one that received that, is that correct?
Yes.
Okay, and it's a fair and accurate depiction of the information that you received?
Yes, it is.
Okay, and that was used in your investigation, is that correct?
Yes, it was.
Tendering to defense for inspection at this time, offering State's Exhibit P3.
No objection.
And what is the exhibit number?
It is all legal.
All right, P3 is admitted without objection for purposes of this hearing.
It's public information gathered from
permission to publish your own.
Granted.
Driving on a public road.
All right. Can you see that up there, detectives?
Yes, I can.
Okay. If you have trouble, you can turn around and look at the big screen. But I guess so. What was the license plate that was entered into the system?
The license plate was N as in Nancy, Y as in Yankee, X as in X-ray, 3837.
Okay, and that's the same license plate that was obtained from the plea card, is that correct?
Yes, it was.
Okay. And if we take a look down here in the location summary, can you please explain that first line and what that means?
Yes, so this analysis report gets put together and it gives you likely locations of that vehicle. And the most popular, the way it's worded, most popular sighting location was 1206 Judson Road, San Antonio, Texas, 78233. Last LPR, which is license plate reader or reading, was 5/20 of 2022, and it was seen at that location 74 times.
Okay. And
they can just look for a car and go back in history and see where it was.
Do you
It's
recall
amazing
what time you
technology.
received this information?
Approximately 9:40 in the morning.
Okay. And then
Yes, that's still the motion hearing. Defense is trying to suppress some evidence. And state has to prove that they had exigent circumstances to allow them to search the phone or do a live ping search of the phone.
And then you said that you came into knowledge that the defendant, regarding the phone number that the defendant was associated with, is that correct?
Yes.
Okay. And so then, did you obtain a search warrant to ping the phone or no?
When I was speaking with the lieutenant, at that time, I didn't have, there's certain officers that can claim exigency. They have to go to specific classes. I'm able to obtain regular phone warrants. Exigent warrants are a little bit different. So I told the lieutenant there was enough to go exigent. I don't know who actually did the warrant or when it was obtained. I started receiving emails. They put me on the return. Like I said, I can't recall who did the warrant at the time or if there was a warrant or a phone call was made to do the exigency, but I started receiving emails at about 9:48 that morning.
Okay, and so with the exigency, what were the circumstances that led you to believe that you could do an exigent circumstances search on the phone?
The unprovoked attack of the officers, the offender got away, so if he was looking for, if the person was looking for other targets to go after, first responders or the general public, or because of the exchange of gunfire, that the suspect needed medical attention.
I think that may meet the legal requirement.
So I'm showing you what's been marked as P4. Can you take a look at that and tell me if you recognize that?
I don't know how they're going to get his
these
statement
are
through.
the emails from AT&T on the updates that we were receiving at the time for the phone.
Okay. And you're the one that received that information, is that correct?
Yes.
And is it a fair and accurate depiction of the information that you received?
Yes.
Okay. I'm going to show you P5 was previously entered into evidence as P3, but this has an additional page. Can you just confirm whether this is a fair and accurate copy of, or what it is, and if it's a fair and accurate copy?
Yes, it is. It's the same license from the Vigilant Plate Search location analysis report that I received via email.
Okay. And then I'm going to show you P6. Do you recognize what that is?
It's an aerial of the, it's the overhead of the apartment complex,
Okay.
the surrounding area.
Okay. You're familiar with what's depicted in State's Exhibit number 6, P6?
Yes.
Okay. And it's a fair and accurate copy?
Yes, it is.
Okay.
It was the girlfriend's
this time,
phone.
State offers, well, tendering to defense for inspection, P5 through P6 inclusive, and offering the same.
I don't know why this officer testified that he believed it was the defendant's phone when I think everything we heard was it was the girlfriend's phone number. I don't think the police had any information that it was his phone. Imagine the defense is going to focus on that on their questioning if what I heard was correct. You can't just say, hey, someone is a known associate of this person, exigent circumstances, we're going to surveil them. Hey, well, what were you saying? You say some bad words somewhere?
No objections.
All right, P4, 5, and 6 are admitted for purposes of this hearing.
Permission to publish, Your Honor.
Granted.
Oh my
goodness. Okay, Detective Rios. So I'm going to start with P5, which was previously entered as P3.
You can't delete
so you
your own.
confirm, just for the record, it's the same record. However, what is this that I'm displaying in addition to what was offered and entered in P3?
It was an email I received from Deputy U.S. Marshal Stephen Caballero.
Okay, and at what time did you receive that?
At 9:40 a.m.
Okay, and I'm going to publish State's Exhibit P4. If we can take a look at that, can you tell me what we're looking at here?
That's the return for the exigent file number for the device that was for the exigency. And that return was time-stamped at 9:48.
Okay. And have you previously done pings for phone prior to this using exigent circumstances?
I'm not sure how to answer that, only because when I was on the Marshall Task Force before, I was covered under TUI. So I don't know if any of that is.
Okay, I'll just move on. I guess
we just did it under the Marshals.
Previously pinged phones.
Again, I was assigned to the U.S. Marshal Task Force previously from July of 2017 through May of 2018, or I'm sorry, I was full-time from July of 2017 through May of 2018, and then I was part-time until 2020, so there's investigative techniques that I'm not allowed to testify to.
There you go. There's the answer we all want.
All right, moving on. If you could take a look at State's Exhibit P6, what were the latitude and longitude associated with the Oak Valley apartments?
The longitude numbers?
Yes.
You want to read them
Not
out?
allowed
Okay,
to testify.
sorry.
I can't tell you under oath.
293314.19 north. Well, I'm sorry, 29 degrees, 14.19 north, 98 degrees, 2136.4 west.
Okay. In this case, now I'm going to publish P4. And just at what time did you receive State Exhibit P4?
At 9:48.
And so that would be after you received the information on the plate reader, is that correct?
Yes, ma'am.
All right. And just can you explain to the court how the pinging works? Does it give you a specific location, or what is the area that's covered when you receive that information?
Different returns come back. Usually they're spread apart every 15 minutes unless there's need for almost live tracking. In this case, every time there was an update, we would get information. Sometimes it would be 122 meters, sometimes it would be 600, 700 meters. So every return would come back with a different, what we call a margin of error. So there was, I don't believe there was anything under 100 meters that I can recall.
Okay. And so if we take a look at State Exhibit P4, starting on the first page, what time did you receive that at?
That one came in at 9:50 a.m.
Okay, and the latitude, longitude that is on this page, is that the latitude, longitude of the apartment complex in P6?
No, it's not.
Okay. Moving on, what time did you receive this information?
That one's at the same time. I think that's the same.
Okay, moving to the first page, what time is that?
That one's at 9:50.
Second page, what time is that?
I'm sorry, 9:52.
Okay.
Sorry.
Is the latitude and longitude associated with the Oak Valley apartments?
No, it is not.
Moving on to the next page, what time did you receive that?
At 10:08 a.m.
And is that latitude, longitude associated with the Oak Valley apartments?
No, it is not.
Moving on to the next page. What time did you receive that communication?
10:23.
Is that latitude and longitude associated with the Oak Valley apartments?
No, it's not.
Next page, what time did you receive that communication?
That one's also 10:38, or I'm sorry, 10:38.
Is that latitude, longitude associated with the Oak Valley apartments?
No, it's not.
Next page, what time did you receive that communication?
10:40.
Is that latitude, longitude associated with the Oak Valley apartments?
No, it is not.
Next page, what time did you receive that communication?
10:55.
Is that latitude or longitude associated with the apartment complex?
No, it's not.
Next page, what time did you receive that communication?
11:10.
Is that associated with the apartment complex?
No, it is not.
Next page, what time did you receive that communication?
At 11:25.
Is that latitude, longitude associated with the apartment complex?
No, it's not.
Next page, what time did you receive the communication?
11:40.
Is that latitude, longitude associated with the apartment complex?
No, it's not.
Next page, what time did you receive that communication?
At 12:10.
And is that latitude, longitude associated with the location?
No, it's not.
Next page, what time did you receive that communication?
At 12:41.
Is that latitude, longitude associated with the apartment complex?
No, it is not.
Next page, what time did you receive that communication?
12:56.
And is that latitude or longitude associated with the apartment complex?
No, it's not.
Next page, what time did you receive that communication?
At 1:11?
Is that latitude, longitude associated with the location?
No, it is not.
Next page, what time did you receive that communication?
At 1:26?
Is the latitude, longitude associated with the apartment complex?
No, it is not.
Next page, what time did you receive that communication?
1:41?
Is that latitude or longitude associated with the apartment complex?
No, it is not.
Next page, what time did you receive that communication?
I'm sure the judge is
1:56?
listening.
Is that latitude, longitude associated with the apartment complex?
No, it is not.
Next page, what time did you receive that communication?
2:11?
Is that latitude or longitude associated with the apartment complex?
No, it is not.
Next page, what time did you receive that communication?
At 2:27?
Is that latitude, longitude associated with the apartment complex?
No, it is not.
Next page, what time did you receive that communication?
At 2:42?
And is that latitude, longitude associated with the apartment complex?
No, it is not.
Next page, what time did you receive that communication?
2:57?
Is that latitude or longitude associated with the apartment complex?
It is not.
Next page, what time did you receive that communication?
3:12?
Is that latitude, longitude associated with the apartment complex?
No, it is not.
Next page, what time did you receive that communication?
3:27?
Is that latitude or longitude associated with the apartment complex?
No, it is not.
Next page, what time did you receive that communication?
3:42?
Is that latitude or longitude associated with the apartment complex?
It is not.
I'm seeing a pattern
Next
here.
page, what time did you receive that communication?
3:57?
Is that latitude or longitude associated with the apartment complex?
It is not.
Next page, what time did you receive that communication?
At 4:12?
And is that latitude, longitude associated with the apartment complex?
It is not.
And finally,
last one.
What time did you receive that communication?
4:28?
Is that latitude or longitude associated with the apartment complex?
It is not.
Regarding the information that I just questioned you on contained in Exhibit C4, were any of those locations associated with the defendant's apartment specifically?
No.
Would a phone ping be able to provide you that information as to a specific apartment number associated with someone?
No.
Okay, and because when you receive the phone pings, what is it giving you? Is it giving you a specific location or an area?
In this case, it was only giving us, I believe one of the returns I saw a 99-meter margin of error. So that's a football field. In the past, I've seen them down to 7 or 8 meters, but dealing with apartment complexes, you have units that are stacked on top of each other. So it will never give you a true exact location.
Okay. And in your report, if you can take a look at it, towards the end, it says the tracking information led us to the listed location where covert surveillance was established. So when you're referring to the tracking information, what are you referring to?
I'm referring to the way we got there through the vigilant records. Once we were at the location, the only thing that the phone provided was an area. But tracking included the vehicle tracking as well as the phone tracking.
Okay, but we've established that the phone tracking didn't put you at the
Oh, I'm
golf
sorry.
background.
Yes, specifically for that apartment, the vehicle tracking led us there.
Okay. And what is covert surveillance?
Clandestine surveillance. We use the unit I was in at the time. We use regular civilian looking vehicles. We monitor giving information. We relay information to marked units. So we lay in wait and we either look for individuals that we're looking for or call out threats for approaching officers.
Okay. Do you recall who else you were working with on that day?
That day, I believe Detective Matt Robles, John Helly, Jason Reno, or Detective Jason Reno.
Are we naming all the undercovers?
Those are who I could recall that were actually out there with us.
Okay. Do you recall where you were situated when the surveillance was occurring?
I was, I would say, on the south side of the building. When you come into the apartment complex, the building is almost immediately to your, you come in and there's a building facing parallel near a trash compactor or like a dumpster. It was right to the right of that. So I parked behind the building under one of the carports.
Okay. And so did you have direct eyes on the apartment complex or no?
Not on the door, or the doors were facing breezeways, so I couldn't see any doors.
Okay. Did the defendant eventually exit the apartment complex?
He did.
Okay. Was he taken into custody at that time?
Yes, he was.
Okay. And to your knowledge, was a search warrant obtained for the location?
Yes.
Okay. We pass the witness.
You may proceed.
Thank you, Judge. And
All right,
I'm sorry, I
defense.
didn't catch your title. Was it detective?
Well, it's the new agency I'm at is Sergeant Investigator, but Joe's fine.
No, that's all right. I'll just call you sir. So, sir, you were assigned to assist in locating a possible suspect in this case, correct?
Yes, sir.
That was more or less the extent of your involvement in this case, was
Yes, sir.
locating the suspect.
Yes, sir.
Okay. And you wrote a report in this case, correct?
Yes, sir.
And in your report, you state, through field interviews and investigative research, a phone number associated with the defendant was developed that was in his possession, correct?
Yes.
The purge.
Were
The
these
purge
your
is
field
happening.
interviews?
No, those were the cumulative effort of patrolmen on the streets, detectives.
Okay. And in your report, you state that that you conducted emergency tracking of Tyler Ashbaugh's phone, correct?
Yes.
Okay. And you were the one that initiated that, correct?
I'm not sure who did. I knew I was receiving the emails, but like I said, I know I told the lieutenant we had exigency.
And when you state that you were receiving the emails, the emails were addressed to you that contained all the vigilant license plate reader information.
Oh, no,
correct?
sir. I'm sorry. Are you talking about the vehicle or the phone? There's two different things going on there.
Okay. Let's start with the license plate.
Okay.
That was still addressed to you, correct?
Yes, sir.
Okay. And in the state's exhibit that was entered regarding the real-time phone location data,
yes, sir.
Those are also all addressed to you, correct?
Yes, sir.
Okay. Now, you stated after a question to the state that there was an exigent warrant that was obtained. Is that correct?
No, I don't. I said, okay, as far as, are we talking about the phone or the car? Because the car, there was no exigency on the car. There's no warrant required. Vehicles are driving around in a public area. So the license plate reader systems that we get access to take pictures in public areas. So there's
of private property.
And I understand that, sir. It was a poorly worded question. I mean, in regard to the phone records.
Yes, sir.
Okay.
There was the phone. So whenever there's exigency on a phone, there's not an order obtained immediately, correct? There's supposed to be obtained within 48 hours. In this case, I don't know who did the follow-up exigent warrant. I just know that there was exigency for the threat to the public or to help the individual get, at the time, they weren't sure if they hit him or not.
Okay. Were you the one that applied for the phone records?
I was receiving the phone records.
But were you the one that applied to get the phone records?
I'm not, like I said, I can't recall when everything was happening, whose name was put on the request on.
Okay. And you would agree with me that out of all the exhibits that the state entered, there was no warrant entered in any of those exhibits, correct?
No, sir.
Okay. There
I'm
was
sorry,
no,
yes, I would agree with you, yes.
you would agree with me. Okay, fair enough. There was no, I assume that there is some sort of permission process that needs to take place or some sort of application with the phone carrier before they approve real-time phone tracking, correct?
I know some phone companies operate off a phone call, some want a fax, some want an email. There's just different.
Fax. You have to send a fax to the phone company.
But each one has some sort of application process. In other words, you can't just decide, well, I want the real-time records on this phone number without permission, correct?
Yes, sir. Like I said, I don't know that that's at a dispatch level process. There's times that people call 911, phone hangs up, they go up exigent on the phone. Or there's suicidal persons that call in, and then dispatch calls somebody, and then within 2 or 3 minutes, officers start getting information. So some of those happen fairly quickly.
But you would agree with me that there's some sort of permission required that can be either accepted or denied by the phone carrier before they give you the real-time data, correct? Where the phone company can actually accept and give you this data as they did in this case, correct?
Yes, sir.
Or they can deny it, correct?
I've never experienced them saying no. So like I said, I don't know.
Okay. You've never experienced them saying no, but it's not just an automatic, correct? You need the permission from the phone carrier.
Yes, sir.
Correct. And out of the exhibits that the state entered, there was no paperwork or application for these records, correct?
No, sir. Not that I saw. No, sir.
It's only documents of you receiving this location data.
Yes, sir.
Okay. And only you receiving this license plate reader information, correct?
Yes, sir.
Okay. So did you fill out the paperwork, or you don't know if you filled out paperwork?
I know I didn't. I'm not sure.
I know I didn't.
Who filled out the paperwork?
Okay.
Was that a mix-up?
And just to, if I may, the only reason I'm not sure is because my emails were recovered. I had already left the agency when these records were obtained, so I'm not sure how much was recovered from my emails.
Okay. And so if we don't have that today, we don't know.
Exactly.
Okay.
He keeps glancing at prosecution when he answers that question.
And so when the tracking was approved, you had access to Tyler's real-time cell site location information, correct?
Yes, but I had already received the location for the vehicle information came in 8 minutes prior, and we were on the way to that apartment complex already.
Okay. And in your report, you would agree with me that you don't mention anything about license plate reader information.
No, sir.
You don't mention vigilant at all, correct?
No, sir.
And you would agree with me that you have extensive law enforcement training.
Yes, sir.
You're trained to write accurate reports.
Yes, sir.
And include all the relevant details.
Yes, sir.
And in this report, you do not state that license plate records are what helped you determine Tyler's location, correct?
Not in this report, no, sir.
Okay. In this report, you state that you conducted emergency tracking of Tyler's phone, P1's phone, correct?
I said it was determined. I could just
refresh your recollection. Don't read from it.
Yeah, it says it was determined to conduct tracking, yes, sir, of the phone.
Okay. And there's nowhere else in this report that it says tracking of anything else, correct?
No, sir.
And then 2 sentences later, the report states the tracking information led us to the listed location where covert surveillance was established, correct?
Yes, sir. And
the listed location in this report is 12607 Judson Road.
Addresses.
78233, correct?
Yes, sir. This report was written after when we arrested him and had the apartment number, so it's going to auto-populate whatever the arrest location ended up being. So it didn't take me specifically to that apartment number, just the apartment complex.
And you went over all the locations of the pings with the state, just no correct?
And specifically for that apartment, just off the top of my head, we were nowhere near 600 or 700 meters with the phone information. The vehicle license plate return put us at that apartment complex.
Would you agree with me that there were 27 pings sent to you with his location information?
There was a lot. I'm not sure the exact number, but
Okay. There was a lot, more than 10?
you said with exact?
Yeah.
No, sir. 100 and I think 100 and the closest meter hit was 99 meters, which is a football field.
And if I may approach with that.
We're about, this is a pretrial motion for a trial that's about to begin with Judge Boyd here today.
And sir, if you could just count the time of the phone pings and let us know how many phone pings occurred.
It might be a bit, 27 or so. The defendant, who's on the far right in the middle of the screen on the top left-hand picture, is accused of pulling up to cops who are working on reports in a church parking lot and open firing at the vehicle. Cops returned fire. Defendant gets away. And they were searching for him later on, within that same day, because it happened early in the morning. And they got the girlfriend's phone number, did an exigent search on the ping of the phone without a
All right,
warrant.
off the record for a moment. Counsel, do you know how many pings it was?
By my count, 27, but
all right,
I can't testify.
You want to ask him if it was 27 pings? He's on cross.
He wasn't sure.
All right.
Judge is trying to speed things up because we do have a jury waiting in the other room. These are motions just filed today to suppress evidence. When this is done, the judge will make a ruling on whether or not the defendant's wife
There's 27 total, yes. And there was only 11
can testify, or they can use her
from
comments.
the time that we got the records till he was in custody.
I understand. So after he was in custody, his phone was continued.
It was on.
Pinging of his
It
phone.
was on.
How did that end? Did somebody have to say, "Hey, we're done," or does it just end at a certain point?
No, somebody would have had to notify the carrier.
And also in your report, you state that Tyler Ashbaugh was taken into custody for a municipal court warrant, correct?
Yes, sir.
Right. Past witness.
All right, any further questions?
No, Your Honor.
All right, thank you. If you'll be sure to leave the microphone. All right, so just so both parties know, I've let the jury be excused till 1:30. And we're going to take a brief break. Let me take up, Mr. Chumling, let me take up your case.
Okay, well, we're going to fast
And
forward
is your
through
client Mr. Guillory?
Yes, sir.
Right, thank you. Cindy, Mr. Guillory, come down. Cindy, are you okay to switch over? All right.
No, if he's got.
All right.
Sorry.
We're going to fast forward through this part because we are catching up. This is happening today, but we're behind.
Guilty of testimony and
Lots of talking. You reviewed the same. There we
and counsel, with regards to spousal privilege, I want this issue addressed with the court.
Let me back up. Here we go. All right,
everyone. We're going to take a 5-minute break so the court reporter can take a break, and we will be right back. And counsel, with regards to spousal privilege, I want this issue addressed with the court. And it's underprivileged not to testify because that's where you wanted me to go. It says the exceptions. This privilege does not apply to A, certain criminal proceedings, in which the spouse is charged with a crime against the other spouse, bigamy, and then they have section B in bold print, matters that occurred before the marriage, if the spouse is called to testify about matters that occurred before the marriage. So if it's the court's understanding of the law, and you all can do your research, that if there were conversations that were had with his spouse before they were married, then that's an exception to the privilege not to testify in a criminal case. And if y'all both want to look at it, it's Rule 504 B.
So getting
B.
married doesn't quiet a witness.
And it's the last section under B. And it's entitled Matters That Occurred Before the Marriage. All right, so we'll take a short recess.
Okay, while they take a short recess, we're going to skip ahead. I'm not sure how many minutes that was. Loading. Defendant puts his head down on the desk. I think he might have been surprised by that. That was our reporter right here coming back. See her with the purse. She's well rested now, maybe. Just waiting for the judge now. Who was that? No, that's her again. Maybe that was somebody else. Maybe that was a lawyer. Defendant's here. Just waiting on the judge still.
Dan?
Yes, Judge.
All right, State, you can call your next witness.
The state called Detective Matt Robles.
We're missing
Okay, sure. All right, but could you go ahead and just have him on the stand?
Yes,
recently appointed to Judge. Recently.
All right. Oh, I see what the charge is. Give me a 30-day reset.
I can do April. August 11th.
All
I
right.
just saw Charles.
All right. Hi, Charles. So in this case, my understanding, I see that you were sort of recently appointed. So we are setting it for discovery August 11th. Is that good for you?
August 11th? Yes, that's
All
good
right.
for me.
All right. And do you know what discovery is outstanding?
I don't yet.
Okay. All right. We'll set it for August 11th. And your client has already been sent back. Did you need to speak
No,
with him?
I'll talk to him on Zoom.
All right.
Okay,
Thank
all right,
you.
Thank you, Judge.
You're welcome.
Robles.
All right. State, call your next witness.
The state calls Detective Matt Robles.
All right. Could you raise your right hand for me, please? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right. You can lower your hand if you'll state your name for the record, please.
My name is Detective Matt Robles.
All right. State, you may proceed.
Detective Robles, how are you currently employed?
I'm currently employed with the City of San Antonio Police Department, and I'm assigned to the covert response unit.
Are you a certified peace officer?
Yes, ma'am.
How long have you been with the San Antonio Police Department?
16 years.
And I guess what are your duties as a detective with the covert unit?
Currently, I'm assigned with the covert unit, and my duties are to conduct surveillance. We seek out wanted fugitive individuals and narcotics investigations.
Okay. Back in May of 2022, were you assigned to the covert unit?
Yes.
Do you recall the SCPD case number associated with the call that we're here for today?
I don't have the case number by memory.
Did you create a report at the time of your investigation?
Yes, ma'am.
Would it help you refresh your memory if you had a copy of that?
Yes, ma'am.
All right, can you take a look at that for me?
Okay.
Do you recognize that?
Yes, ma'am.
Is it a fair and accurate depiction of the report that you created at the time of the investigation?
Yes, ma'am.
And would it help you refresh your memory if you were able to review it?
Yes, ma'am.
Okay, so you can not read from it, just refresh memory. What was the SAPD case number associated with the call?
The SAPD case number was 22108229.
All right, and so what were your duties, or how did you become involved in the investigation in that case number?
I received a phone call the morning of that, the day of that incident, and was advised if I could come in and help conduct surveillance at different locations.
Okay, And at that time, back in May of 2022, were you assigned to the repeat offenders program?
Yes, ma'am.
Okay, and the repeat offenders program, is that under the covert unit?
Yeah, it's still the same duties, just a different name.
Okay, and so you would still be operating in plain clothes and unmarked vehicles, is that correct?
Yes, ma'am.
All right. And when you were called in, what were you assigned to assist with?
We were assigned to assist with trying to track down an individual who we believe may have been involved in an incident overnight.
Okay. When you say we, who else were you working with?
Other covert detectives.
Okay. Was Detective Joe Rios one of the other detectives you were working with?
Yes, ma'am.
Okay. Can you kind of describe to us the process, if you know, of checking locations where the suspect may have been staying?
There's different ways that sometimes we obtain information, whether it be old reports, traffic citations they may receive, vehicle registrations, things of that sort, to try to find the most recent address maybe somebody might be staying in.
Okay. In this case, were you in charge of obtaining any license plate record or any records relating to the pinging of the defendant's phone?
No.
Okay, and so did you have any knowledge of the findings of that information if someone else did it?
No.
Okay, and so how did you end up at the 12607 Judson Road, San Antonio, Texas 78233 location?
So I received information via the radio from one of my team members, Detective Joe Rios, that the address on Judson Road was address of interest, and that we should probably go get eyes on that location.
Okay. Would you have considered yourself the lead, like, eye in this case?
Yeah. So once I made the location, I took what we call in our unit the eye on a location that we thought potentially that the target of our investigation or our surveillance might be at. So I took the lead on that position, the eye, and coordinated the other detectives and patrol officers that day.
Okay. Do you recall where your vehicle was positioned in relation to the specific apartment?
Yes.
Where was that?
So I had backed into a spot. I don't know if you have a map I could show you, but sure.
This has been entered into evidence. Obviously, exhibit P6. It's a very zoomed out version.
And if it's easier for the witness to step down, the court is fine with that.
Can you see that, or do you need to
Yes,
step down?
yes, ma'am. I'm familiar with it now that I can see it.
Okay. And on state exhibit P6, are you able to see where you parked or no?
I cannot see the individual spots, but I can point at the area where I had positioned my vehicle.
All right, that would be fine. Go ahead and step down to some point.
Okay. Okay, so this is the location of the apartments. This is would be Judson Road. So as I entered into the complex, the first building on the right, there is a trash compactor on the south end of this parking lot. I took a position probably maybe 2 spots north of that trash compactor,
And like I mentioned earlier, I backed into that spot so that I could observe the breezeway and the general vicinity of that apartment building and that breezeway.
Thank you. You can take this. All right. And so while you were conducting surveillance at that location, what did you observe?
I observed, people coming and going. I could see an apartment directly in front of me with a balcony on the first floor. I don't recall the second or third floor or how many floors there were. I think the information that we had received, or I had received from Detective Rios or on the radio, that our interest should be that apartment or that breezeway.
Okay. And did you observe the defendant exit that apartment?
Yes. So that day I observed him come out to the balcony, but not outside the front door. And a few moments or minutes later, I observed him come out of the door into the breezeway. And then he attempted to go back into the apartment. And I think he might have been accidentally locked out, or he had a knock on the door to go back in. And then subsequently later, he ended up coming out to the parking lot away from that specific unit, far enough away where we could safely try to detain him.
Okay. And so when you felt that he was safe enough distance away for detention, then what did you do?
So typically we wait for the person to get away from the door, just in case if he wants to run, or sometimes we have family members that will come out. So we want to get him away and use the element of surprise so that it's safe for him and it's safe for us. So we don't get into a situation where it could turn into something bad.
Okay. Then once you had eyes on him, was this relayed to the other detectives that you were working with?
Yes, I was advising them that I had a positive ID on him based on some photos that I had received. And I was confident that this was the target that we were looking for.
Okay. And then once you called it out, what happened?
So what I was doing is I was positioning officers on the back end of the apartment complex, or I'm sorry, I misspoke, the building that I pointed out in the picture. So whenever he came away from that door and into the parking lot, when we approached him, they would cut off the doorway. That way he couldn't run back to the door, and had them approach from that way. So when he came out to the parking lot, I took the opportunity to have the marked patrol units pull in, and they're in fully marked uniforms and patrol cars, to take him into custody there in the parking lot.
Okay, so he was taken into custody?
Yes.
And was he further identified once he was taken into custody?
Yes.
Okay. Were you equipped with a body worn camera during this time?
Yes, ma'am.
And were you confident to operate it?
Yes, ma'am.
I'm showing you what's been marked as State's Exhibit R7. Do you recognize that?
Yes, ma'am.
What is it?
It's a CD with my name on it. I initialed and wrote my badge number on there.
Have you reviewed it?
Yes, I have.
Was it a fair and accurate depiction of the events as they unfolded on the date?
Yes, ma'am.
At this time, state tenders State Exhibit R7 to defense for inspection and offers.
I got distracted. I was on a call with another content creator.
All right, and that's R7. All right, R7 is admitted for this hearing without objection.
No news from Connecticut yet.
Granted.
Still deliberating. What did I miss here? What did he testify to? Element of surprise. I haven't heard the defense guy yet, so that's the one I'm going to hear on this more than the state. Hey, well, yeah, the evidence in this one looks really bad for the defendant. If they can get something suppressed and kept out, it's going to be a big win. Amber. Can I message you real quick, Amber? Are you out there?
All right, and so at this time,
For myself and Manny can come out to the door right now.
Z exhibit R7, that is, what time did your body worn camera start?
It looks like approximately 11:13.
And were you able to see where you were positioned at this time?
I can see inside my vehicle. Are you talking about what I'm observing throughout the windshield, to the front of my windshield?
Let me just ask a different question.
Sure.
Are you able to tell, were you in that reverse position that you previously explained?
Yes.
Okay.
And Heather, F3, go ahead. Cameras.
Hold on, guys. Hold on. He's walking back, guys. Hold what you got.
Who's the SWAT?
All right, we're rolling Ayden back with the uniforms. Roll back is going to call. He's in the best spot.
He's back in the door, guys. Back in the door.
Red polo shirt. Red polo shirt. Maybe sitting back with the uniforms. We're on the way.
Okay, I'm going to fast forward to 20 minutes and 14 seconds. And so you're conducting surveillance for this entire time that you're in the vehicle, is that correct?
Yes, ma'am.
All right, I have eyes on the female. She is on the balcony. She's looking around.
I think that's their lunch ends at 2.
She's wearing a black shirt, gray shorts. Back inside the apartment.
And I'm going to pause you to give it R7. The female that you're referring to, is she associated with the apartment that the defendant was staying at?
Yes, ma'am.
I fast forwarded Stacey to R7 to 53 minutes in front. And so
White Mitsubishi SUV.
this entire time, have you been conducting surveillance at the location?
Yes.
Just pulling up with a handicap plate.
Maybe heard that?
Possibly. All right, guys, he's coming out. He's coming out. All right, street crimes, let's go.
I love this behind the scenes audio.
No weapons, sir.
And does that show the apprehension of the defendant?
Yes.
We have to witness him.
All right, defense.
No question.
All right, thank you. If you'll leave the microphone. State, call your next witness.
The state calls Detective Scott.
Detective Scott. Sorry, I haven't updated these. Kim, you would be able to hear Raul. The audio from Connecticut court is live right now. As soon as the judge says something, you will hear it. That audio is patched through live. And the video in the top corner that you see that says Connecticut, that is live video. That's not a still image. You would see and hear what's happening. We're watching both at the same time.
All right, if you can raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right,
Love
you
those
can lower your
badge
hand.
holders.
And if you'll place that square microphone on your lapel or somewhere, it's for the court reporter to hear.
Yes, ma'am.
Thank you. You may be seated.
Thank you, ma'am.
All right, state.
Detective Scott, how are you currently employed?
Yes, ma'am. I'm a detective with the San Antonio Police Department on the Fusion Unit.
And are you certified peace officer?
Yes, ma'am.
How long have you been employed with the San Antonio Police Department?
13 going on 14 years, ma'am.
And what are your duties as a detective with Fusion?
Right now is going to be intelligence, gathering, disseminating information. Also, we also have a lot of different partners that we work from federal to state agencies, and we just do a lot of sharing of information, collaborative work, and also a lot of task force, just oversight and monitoring and managing certain individuals that are a part of those initiatives.
Back in May of 2022, were you employed with the San Antonio Police Department?
Yes, ma'am.
Were you a detective at that time?
Yes, ma'am.
And what unit were you in?
Homicide unit.
And what were your duties with the homicide unit?
It's going to be investigating cases, dealing with our case responsibilities of felony and misdemeanor cases involving guns or sometimes assaults.
Okay. Do you recall the SAPD case number that was associated with the case that we're here for today?
Yes, ma'am. I do recall the case, but not the case number itself.
Okay. Did you write a report at the time of your involvement in the case?
Yes, ma'am, I did.
And would it help you to refresh your memory if you were able to review a copy of that?
Yes, ma'am. Thank you.
Can you take a look at that?
Yes, ma'am.
Do you recognize that?
Yes, ma'am. This is my police report.
Okay. And you authored it?
Yes, ma'am.
And it's a very accurate depiction of your report?
Yes, ma'am.
All right. What is the SAPD case number that was associated with the case that was reported to me?
Yes, ma'am. It's going to be SAPD 2210-8229.
Do you recall how you were assigned to assist in the investigation?
Yes, ma'am. Normally a detective will say, hey, I got a hot case coming in. Can someone assist? Or they have a case that happens over the night that we get assigned to, and pretty much ask around the office, hey, can anybody assist me with warrants or this or that, whatever the request might be. This one here was a request to write a search warrant, and that was my dealing in this case.
How did you receive the address of interest, if you recall?
I was, on this case, I believe I was given the given the address by the handling investigator.
Did you ever prior to writing the search warrant, did you ever make the scene, the location of 12607 Judson Road, apartment 1101?
No, ma'am, I did not make the location before writing the search warrant.
Okay. And so in the process of completing the search warrant, did you receive information from detectives that were on scene and the handling detective?
I received information from officers on scene and not the handling investigator.
Okay. Did you conduct any additional research for the substance of the warrant?
Yes, ma'am. Using open source information, just Google Maps, Google Earth, and just trying to get a depict of the location, and also confirming those details with officers on scene of the location.
At the time that you wrote the search warrant, did you have any knowledge of any investigators obtaining real-time cell phone tracking location data or license plate reader data?
I had no details of the case besides the offense and the needing of a search warrant, so I had no information of ALPR or the cell phone information.
Okay. And so it's fair to say you did not rely on that information when drafting the search warrant, is that correct?
That is correct.
And so did you complete the search warrant and obtain a signature from a judge?
That is correct.
And it was this judge.
Showing you what has been marked as State Exhibit R8. Can you take a look at that and tell me if you recognize it?
Yes, ma'am. This is the search warrant that I would have wrote that day and got signed by the judge.
Okay, and that's a fair and accurate copy of the document.
Yes, ma'am.
At this time, the state offers State Exhibit R8 and tendering the defense for inspection.
No declaration.
All right, State's Exhibit R8 is admitted without objection for the purposes of this hearing.
We pass the witness, Your Honor.
All right, defense.
Morning, Detective Scott.
Good morning, sir.
So you were assigned to an investigation on May 22nd, 2022, correct?
I was assigned to assist.
To assist. And
Yes, sir.
it's fair to say that your role was limited to essentially drafting this affidavit for the search warrant and getting the search warrant signed by a judge.
That is correct, sir.
Okay. And the investigation was for an officer involved, correct?
Yes, sir.
Okay. And Tyler Ashwell was identified as a suspect.
I did not even see the suspect, so I guess that's the case. Yes, sir. I just got the search warrant.
So Tyler Ashwell doesn't ring a bell to you?
As far as the name, only because of the reports, yes, sir. But as far as any other details, I was just tasked with the search warrant, sir.
Have you had a chance to review your affidavit for the search warrant?
Just today, yes, sir.
Okay. And you wrote in that affidavit that the actor's identity was provided to officers and his known address is the one listed above, correct?
Yes, sir.
And you listed the address as 12607 Judson Road, apartment.
Oops.
Number 1, San Antonio, Texas 78233.
I believe so, yes, sir.
Okay. And is it fair to say that that's the only line in the affidavit that relates to how this apartment unit was identified?
For the search warrant, yes, sir.
Yes, just that it was his known address. And there's no other details to say how this became known as his address.
In my original report, I believe the person told me that I guess there was a vehicle that was ran and that I guess the person who was driving the vehicle was, I guess, the defendant in this case. But as far as in the search warrant, that's what I put, yes, sir.
Okay, so there's no other information in the search warrant that states how this specific apartment unit was identified as the address to be searched, correct? Just that it says his known address.
His known address, yes, sir.
Okay. And so you didn't conduct an investigation to say this is his known address. This was information that was provided to you, correct?
Based on the handling investigators' research, yes, sir.
Okay. And so is that all that was provided to you? Was that they just said this is his known address?
Based on their research, based on their investigative actions, yes, sir. They told me that information, and also I put a little, I guess, a couple lines in my report on how they were able to get to that information of using the vehicle registration and going over to, I believe, the parent's address and verifying some details and going that route. And that's how it became known that that was the defendant's address.
You stated speaking with other individuals to determine the address. Is that what you said? That the officers spoke with other individuals?
I believe they spoke with other individuals. I may have misspoken, but I believe, not trying to read off my report, but I believe they actually made the location and talked to people and did a little field work to be able to determine that was the, I guess, vehicle being used by the defendant.
Say made the location and talked to people.
Yes,
what
sir.
location are you talking about?
Can I use my report to refresh my memory? Thank you, sir.
Well, he does that. I'm not shopping for purses. I'm working with Josh Ritter on an upcoming case. We've been texting back and forth and calling. So that's all. Just Josh is amazing, by the way. If you don't follow Courtroom Confidential, please give them a follow.
Feel free to read the entire report.
Yes, sir.
All right. Thank you so much.
On my report, it doesn't have that address, sir, of what locations detectives made to do their field investigative work, sir.
Your report states that you were provided the address of 12607 Judson Road Park, 1101, correct?
Yes, sir. That's the address that I was provided for the warrant. Yes, sir.
But it does not state how they located that apartment, correct?
No, sir, not in my report. I don't know how they got those
Okay.
details.
So you don't know how they got that location, it was just provided to you first.
That's correct, sir.
So I know that you testified a little bit earlier that there may have been some other information about how this address was located. Are you correcting that prior statement now and saying that there was no other information provided to you as far as how that location was hidden?
So I can be clear, they did investigative work where they went to one address, but I don't know those different addresses. That's based on their research and their information gathering that led them to this location or getting the information for this location. And that's the location that I was provided to do the search warrant for. I don't know how they got the links, but I got the address from the handling investigator who assigned me to do just the task of handling the search warrant.
So they provided you with this address,
Yes, sir.
but you don't know how they identified that address.
No, sir.
Okay.
No further questions.
All right. You need to step down. Make sure you leave the microphone
Yes, ma'am.
behind. The square microphone.
Yes, ma'am. I got you.
Thank you.
Absolutely.
State, call your next witness.
State rest.
Oh, is it? Yes, ma'am.
All right, defense, any witnesses?
That's rest.
All right, court will hear argument.
This is why the judge didn't need to pay attention.
Sure.
Because the argument gets summed up and she will then reflect on what she heard while she was doing Minesweeper. Working on other things.
Judge, I guess if it's defense's motion, I believe that their argument goes.
Yes.
That's fine, Judge. Okay. Judge, as I stated earlier, we're seeking to exclude all the fruits and all the evidence that was located based on the search of Tyler Ashwell's apartment unit. Also that, and that the attenuation of the taint from that illegal search was not great enough from when he was actually taken into custody and then immediately transported to the San Antonio Police Department to give that statement. And so, as you heard, Judge.
Well, let me ask you this, with regards to the statement that you're saying that he gave.
Yes.
Was he not taken into custody because he had some sort of outstanding traffic warrant or some type of warrant?
Well, so yes, if you let me start from the beginning, I can kind of work my way
All right.
to that one as the last point. I think hopefully it'll make sense.
Okay.
So obviously, I believe that it's undisputed. There was no warrant in this case. The state could not produce a warrant. There was no warrant used to get Tyler's real-time cell site location information. And so this search is illegal for two reasons, Judge. Because they should have gotten a warrant and they did not get a warrant. That's under the Sims case, Texas Court of Criminal Appeals. It states that you decide if, on a case-by-case basis, when real-time cell site location information is obtained without a warrant, and you're deciding if there was enough that was obtained to where Mr. Ashbaugh actually had a reasonable expectation of privacy in his real-time movements, which I would argue he does, especially when he's in his apartment complex at the place he lives. If they're tracking him where he lives, I don't know how anybody wouldn't have a reasonable expectation of privacy from this. And that's also based on the Carpenter case, Judge, Supreme Court case. And that looked at historical cell site location information, but they ruled that the third party doctrine does not apply, where, okay, a cell carrier just obtains your data, therefore you have no reasonable expectation because a cell carrier has it anyways and you're giving it to them. They stated that it's essentially a tracking device, and then if you get enough information, it amounts to a search. You have a reasonable expectation of privacy in your movements, and you're not just giving that up because a third party obtains that data. And the same idea, it says, applies to this. But and by this I mean real-time cell site location information. So you're deciding on a case-by-case basis, does the amount of data that they receive violate his Fourth Amendment,
The defendant's yawning.
constitutional rights because they obtain
He's bored.
an amount of data and yet reasonable expectation of privacy in his real-time movements, Judge. And in Sims, this was a case where Texas Court of Criminal Appeals, where a suspect was tracked from Texas to Oklahoma, but they only pinged his, and I believe it was Oklahoma police that eventually took him into custody. But he was only pinged 5 times. You heard in this case that Tyler was pinged 27 times. Once again, they should have done that with a warrant. Alternatively, they did not even have probable cause to do the real-time cell site location information. You heard from Detective Tudor in his statement, in his testimony today, that he told Mr. Escobar, Tatiana's father, that he didn't have enough information to know what was going on. Every witness agreed that Tyler was taken into custody due to his municipal court traffic warrant.
Tyler's openly
There was
yawning.
no arrest warrant for aggravated assault on a public servant. He was taken into custody on that so that they could continue investigating. If they had probable cause, they could have gotten an arrest warrant for Tyler. But all of those statements and all of that indicates that they did not feel at this point that they even had probable cause to arrest Tyler. So they had to do it the strategic way of trying to take him in on a municipal court warrant and then interview him. And then also, Judge, in relation to the automatic license plate reader information, if you look on that exhibit, the amount of automatic license plate reader data that they received was over a year's worth of tracking data. It says
overly
first
broad.
seen February 2nd, 2021, last seen May 13th, 2022. So they had gathered so much data on these automatic license plate reader. I think this is an relatively undeveloped area of case law, but I would argue that the same reasoning in Sims and in Carpenter apply to this. What you're doing is you're not just giving up your reasonable expectation of privacy because you're driving your vehicle. You can't expect that somebody's just going to be tracking your location at all times. And that maybe if they had done a little bit of license plate reader data, that might have been okay. But they got over a year's worth of license plate data, also without a warrant, to track him to this location. And Detective Rios' statement, Judge, he only lists the cell site location information. He doesn't even mention this license plate reader data. And now he comes in here, and this contradicts what his report is saying, is that, oh, actually, with the license plate reader data, that we used to locate his information. Whereas he states in his report, we got his real-time cell phone tracking information, and the tracking information is what led us to the apartment. Detective Tudor was trying to obtain this apartment unit by calling individuals. He knew that these people, the relatives of Tyler, were telling him that all they knew was the apartment complex. Nobody could provide the specific unit. By the time he tries to inform the other detectives, hey, this is the unit, well, they're already like 3 steps ahead of him. They already know the unit that Tyler is in because they've utilized ALPR records and this cell site location information. And we were not even produced any application documents that were required to do this. Mr. Rios, I forgot his title, but Mr. Rios, he stated that this is a process where you can need to get permission from the cell carrier. It's not just something that's automatic, even though he's never been denied, but you don't just get to do it at any time you want. There is a process for applying. There are no documents on that. He's the one that all of this is given to. His email is the address that's in all of these documents. And then furthermore, Judge, now we're getting to, okay, that is the only reason that they were able to locate his apartment warrant. Detective Tudor doesn't have anything in his report regarding any water bill or anything like this. Nobody has anything like that. The only reason that anybody stated in any report that they located it is because they did the cell site information, and then based on that, they knew that this is the location of the warrant, and then they do covert surveillance, took Tyler into custody. And a magistrate was prevented from knowing that this is a factor that was used in apprehending Tyler. All the magistrate had to go off of is that this is his known address. And Judge, that is at the minimum, a reckless disregard for the truth, which under Franks v. Delaware, that part of the warrant should be excluded. I'd appreciate counsel not laughing at during my arguments. I can hear that.
I did not do that.
Well, you scoffed. So.
I was clearing my throat, sir.
Okay.
Clear my throat. An apology from you now.
Okay.
Okay.
No.
No.
And so,
Children.
Judge.
Children.
This apartment search warrant was based on information that was not included in the warrant. This is at a bare minimum a reckless disregard for the truth. And that means that if there's any false information or information that's a reckless disregard for the truth, that portion of the warrant is excluded. And so we have his apartment unit. That is the only, if that is taken out, the identity of the apartment, then none of this warrant stands. There is no warrant because that is the only reason that they say this is located. They say this is his known apartment. Not one single witness said this is his apartment. And so the case law states that a search warrant that is based on that is based on an illegal search is also illegal. And so you have it for that reason. You also have it under the Franks v. Delaware. That doctrine, Judge.
Okay. Hold. Something's going on. Something's going on in the case. Obviously, we've got some movement in court a little bit. And let's jump here for just a second. The courtroom is packed. Kathy Russin has said everybody is there, but there's been no indication that it's a verdict. This could mean that they're hung, and they're coming back and saying they're hung. But my understanding is they haven't yet given their version of the Allen charge yet. The 2 preceding instructions were not that version. And so they still have that availability, which would indicate it would be a verdict. So we're sort of waiting here. If anybody has seen, there are tons of deputies. I just don't know. I don't want to play the verdict music incorrectly until we can get some confirmation. Has anyone seen this on any other? Yeah, we're looking for Chip Smith. Allen charge. Yeah, the clock stopped. Well, I turned my clock off At least I took it off the screen. I can put it back if you want. Box source 4 will be 2. Take super source there. There we go. It's back. Turn off camera 1. All I see is what Kathy wrote. I don't see anything other than Kathy. Play the music, better to ask forgiveness than permission. Didn't we get burned last time where we had a verdict and then didn't have a verdict? And yeah, I mean, it ended up being a verdict, but let's see. Lots of deputies. Trial junkies said it, but they normally signal us the verdict. That was 7 minutes ago. Trying to see if anybody else. It looks like a verdict is in, says Trial Junkie. We don't have verification. Unfortunately, we might get a verdict without verdict music, which means either we pause it or we let the judge speak to. It'll be an abbreviated one. Who's CT Insider? Let's see. I'm not seeing a post on Twitter from them. Where are you seeing it? This is one of the fun things about news gathering, having worked in the news industry. You need confirmation. It'd be very easy to just play the music and then say, oops, no accountability. But I have a higher standard for myself. Let's see, PJ. Thank you. That's from News 12. I'm not seeing it. I see speculation, people saying they don't know what's up, but that's why we need verdict music and just jury wasted another day music. I will tell you that it has every indication of a decision being reached, more so than this, just the jury has another note. Typically, when all the parties are present, they've been notified of something, but we're not hearing what, if anything, they've been notified by. It could be that they just were present because they expected the judge to go back on the record at 2 o'clock with an update, and she hasn't. Let's see, Josh. I will say the courts are usually pretty good about putting out a notification to media, and it's not out. It's not out. It does smell like a verdict, and it looks like a verdict, and it walks like a verdict, but we're not sure if it is a verdict. We're live with the feed. We've put a pause on Judge Boyd for now. We'll return to that one if nothing happens here, but I'm going to give it probably till the bottom of the hour, a few minutes past, about 2:30. Josh, that's a new one that you just sent me. I haven't seen that. Sending me excerpts from posts. Okay, Record Journal. That might be the closest one. Hang on. The Record Journal is the only news outlet that seems to indicate there is a verdict. Yes, 3 people on X. People on X. FFL. Get up. I know I'm not trying to be first on this because Court TV says, or Law and Crime says something will happen soon. Not seen. Yeah. Fairfield Citizen is from Fairfield, Connecticut. I know we've got a couple very small accounts that I just don't I don't trust as authoritative. I don't know if they're in the courtroom, is what I'm saying. I don't recognize them as basically live tweeting the proceedings as they went on, tracking everything. They might just be looking at one person and assuming that it's a verdict. Record Journal is the only one I've seen that says it is. Internet never lies. All right, CT Insider, Courtroom Insider just did. Do we do it? Do we do it? Hours, 34 minutes and 4 seconds by my clock. Other clocks may reflect different numbers, but Raul Valle has been sitting in court as the jury deliberates, and over they've come to the judge and say, we are hung, we cannot decide on this, we're split, we can't reach an agreement. But the indicators now are saying that the jury has reached an agreement in this case. Raul Valle is charged in the death of Jimmy McGrath and the assault, the knives, the stabbings of 3 other high schoolers. This is a high school party gone wrong that ended tragically for one student, and there is blame to be passed around on all sides here. It's a terrible case where decisions hours before this event could have prevented this from happening. The first one, underage drinking. Underage drinking seems to have fueled a lot of the conflict that led to this. But Raul Valle has claimed this was self-defense, that he was in fear for his life, that he had no intent to harm anyone and only used a knife when he felt that he himself would not survive unless he did so. The big question lies in the death of Jimmy McGrath. Raul Valle, having been freed from the fight, being away at the car, could have hopped in to drive away. Instead, turned and went back to the fight, he says, because his friend was still being beat up. Everyone else says that his friend was also free at that time and he could have left. It was only after that time that Jimmy McGrath was stabbed. The jury has to decide if that was self-defense or if Raul Valle is going to be convicted as a murderer. Whew. Just in case court finds me for recklessly playing the verdict music, there it is. We do not know when. We know the courtroom is packed. People are here, but we do not know. We don't know if or when they're going to come back. This court has not been very good at letting the media know when the questions are asked, and the jury is going to be brought back out. So we're still in a little holding pattern and waiting. But 11-1. 11-1 was the count at one point. At one point, there was one holdout that prevented this from being a unanimous verdict, one way or another. We don't know which way that was. We do know that after 2 requests by the judge to continue deliberating and keep working on this process, the jury went to work. Only then, after the second time, asking for a readback of Raul's testimony about that night, particularly the moments that led up to Jimmy McGrath being stabbed. So they did get a readback. They had it in live audio form. They played the tape, which I've never seen before. It was not a transcript that was read back from the court reporter. They got to hear Raul in his own voice answering questions by his own attorney on direct and cross-examination from the prosecutor. And whatever decision is made here by the jury, the truth is that there were a lot of losers in this case, and I don't mean that in calling names. I'm just saying that this was a terrible situation where there's a lot of loss, things that can't be restored, and nobody knows that more than Jimmy McGrath's family and friends, as he will never be back, regardless of verdict here. I have no picture. We're waiting. We're waiting. We're looking at the seal right now. We're also hoping that the other people announce that there's a verdict as well, so that I don't feel alone in case I was wrong. Let's see. Here we go. We've got action. Waiting for audio. Still no audio. Love to hear what the defense attorney is saying to the judge right now.
Good afternoon, Your Honor. Mark Dorso for the State of Connecticut.
Good afternoon, Your Honor. Tatiana Messina for the State of Connecticut.
Good afternoon, Your Honor. Kevin Smith for the defendant, Raul Valle, is at my side.
All right. So, counsel, as you are aware, we have received a note from the jury, which indicates that the jury has reached a partial verdict. And when I say partial verdict, in summarizing the note, which does indicate to some extent the deliberative process, it appears that the jury has reached a verdict as to murder at count 1, manslaughter in the first degree intentional at count 1, assault in the first degree intentional at both counts 2 and 3, and assault in the second degree intentional at count 4. At this time, the court's intention would be to accept the partial verdict and declare a mistrial on any lesser included charges upon which the jury is unable to reach a verdict. I will note that the note additionally indicates that after lengthy deliberations,
videos off,
the jury is hopelessly deadlocked on the other charges. So I would give each counsel an opportunity to be heard at this time also.
Thank you, Your Honor. The state would be requesting that the court now at this moment give a Chip Smith charge to the jury. They've been out 2.5 days now, I guess.
The video's off.
A little over 11 or 12 hours. There were 25 witnesses that were called in this case. There's a mountain of evidence that needed to be reviewed. And we went from... The jury has indicated now on a number of occasions that they are rather hopelessly deadlocked as to those charges, which they still cannot come to any resolution on. My understanding of the note is simply that giving them another charge is not going to change that, and so we would object.
So in response to the request for the Chip Smith, which is basically another attempt at the court to ask the jury to continue its deliberations, the court is hereby denying that request on behalf of the state. In keeping with Feliciano, this court has not once, but on 2 occasions provided a chunkier or a wider Feliciano charge. On day 1 of the jury having this case, the court received a note that it was hopelessly deadlocked on the murder count. The court, upon agreement with counsel at that point in time, instructed the jury to continue deliberating. At that time, I instructed the jury to review the evidence, discuss and consider the opinions of other jurors, to explain the views and listen to the views of other jurors, including the majority, to listen to what the minority had to say, as well as the minority to listen to what the majority had to say. Subsequently, on day 2, after about 5 hours of continued deliberations having passed, the jury did send a second note indicating the following: that the jury was deadlocked on murder at count 1, indicating that the jury had reached a verdict at count 2 and count 3 as to assault in the first degree, deadlocked as to lesser included charges, and with respect to the last count, count 4, again indicating a possible verdict as to assault in the second degree, intentional, but deadlocked as to the first lesser included charge as well. Once again, that note was discussed with counsel. Once again, upon agreement by counsel, the court extended to the jury another Feliciano type of charge, which included more language than the standard go back and deliberate charge. The court once again looked at the jury and instructed the jury to continue deliberating, to review the evidence, see if any evidence was overlooked, make sure that no evidence was misunderstood, and to explain the views and listen to the views of all other jurors. The jurors did continue their deliberations, and they did review some evidence, which we came back on the record to produce for them. So at this point in time, the court is not going to go ahead and give them a third instruction to continue the deliberations. The court is going to accept the verdict.
Just one more thing, if I may put on the record, Your Honor, with regards to the court's intent on declaring a mistrial on the remaining charges that do exist, the state's intent would be, if that were the case, that we would be filing an amended information to include those charges.
All right. Well, I don't know when you would be filing that amended information, but we're going to accept the verdict before any amended information is filed.
Okay, so we get
we
a
have a
partial
verdict.
verdict.
We're going to take that verdict. Does anyone else have anything else to say?
This could still be guilty on the first
All right. At this point, we'll
charge
bring the jury in, please.
and hung on the others. Or it could be not guilty. This could be a win. This could be what Karen Reed should have gotten in her first trial with a partial verdict. Sounds like they're not guilty on the main counts, but hung on lesser included charges. Yes, I believe so on the lessers, but they have reached a verdict on the main, so he could be guilty or not guilty on the main.
Sir? The rest of the jury. Oh, you're alive.
Family's here. There we go.
All right. It appears as though all of our juror members are present. I would seek the counsel's stipulation as such before I begin.
State will stipulate to the presence of the jury, Your Honor. Defense stipulates, Your Honor.
So I first like to inquire as to the four-person, please just stand. Thank you. All right, so Mr. Four-person, I did receive the note that was signed by you, and it was time-stamped as well. The note indicates to the court that the jury, although unable to unanimously agree on some charges, has unanimously agreed as to a verdict on murder at count 1 and manslaughter in the first degree intentional at count 1. Also, as to counts 2 and 3, the jury has a verdict on assault in the first degree intentional. And then lastly, as to count 4, the jury has reached a verdict as to assault in the second degree intentional. Is that correct?
Yes, what a mixed verdict.
So at this point in time, I would ask you to be seated.
Let's hear what it is here.
All right, the court at this point in time is going to move forward with the verdict that you do have relative to the counts and the charges that you have relayed in the note and that you have just confirmed on the record. So Madam Clerk is going to be providing to you additional instruction as she accepts that partial verdict. Okay? Thank you.
Ladies and gentlemen of the jury, as your names are called, please indicate your presence by answering here, rise, and remain standing.
We have to mute the names. We do not want to hear the names of the jurors, so we have 12 jurors who are going to be called, and we'll remain standing. As soon as they are done reading the names, we'll bring audio back. Yeah, this is a very different process. We told you at the very beginning that there will be a lot of silence in this when the verdict's read. It's just the way they do it. We try to protect the anonymity of the jurors out of tradition and some court rules, but looks like that's all of them.
Identify himself for the record.
Yes, here. James Stone.
Thank you. All but the four-person may be seated.
I guess we know the four-person's name, sorry.
Mr. Foreperson, in the case of State of Connecticut versus Raul Valle, has the jury agreed upon a unanimous verdict as to murder at count 1, manslaughter in the first degree intentional at count 1, assault in the first degree intentional at counts 2 and 3, and assault in the second degree intentional at count 4?
Yes, we have.
Will the defendant, Raul Valle, please rise and face the jury?
Face the jury.
Do you find the defendant guilty or not guilty?
Not guilty.
Okay, hold on a moment. We have to go through the docket number 8.
Oh, it's not on here.
Whoa.
Sorry.
It's okay.
In docket number AAN CR 22-0189-418T, count 1 of the substitute information charges the defendant, Raul Valle, with the crime of murder in violation of section 53A-54A of the Connecticut General Statutes. Do you find the defendant guilty or not guilty?
Not guilty.
2 not guilties.
As to count 1
cannot be
of the
tried on those
substitute
again.
information charging the defendant with the lesser included offense of manslaughter in the first degree intentional in violation of section 53A-55(a)(1) of the Connecticut General Statutes, do you find the defendant guilty or not guilty?
Not guilty.
Okay, Madam Clerk, please pause. All right, I'm going to direct the court's inquiry to the foreperson at this time. Mr. Foreperson, your note indicated, and that's Exhibit 10, Court Exhibit 10, your note indicated that the jury, after lengthy deliberations, was hopelessly deadlocked on manslaughter in the first degree reckless in violation of Connecticut General Statutes 53A, 55A3 as a lesser included offense at count 1. Is that correct?
Yes, Your Honor.
All right, so you were unable to reach a unanimous verdict as to that particular charge, is that correct?
That's correct.
Madam Clerk, please continue on with count 2.
Count 2 of the substitute information charges the defendant with the crime of assault in the first degree intentional in violation of section 53A-59, paren A, paren 1 of the Connecticut General Statutes. Do you find the defendant guilty or not guilty?
Not guilty.
Madam Clerk, please pause. Mr. Foreperson, Court Exhibit 10, again, the note that was sent to the court, provided to the court and marked, indicates to the court that after lengthy deliberations, the jury is hopelessly deadlocked on the charge of assault in the first degree reckless in violation of 53A, 59A3 as a lesser included offense at count 2. Is that correct?
That's correct.
All right, so you were unable to reach a unanimous verdict regarding that particular charge as a lesser included offense. That is correct?
That's correct.
Thank you. Madam Clerk, please continue on to count 3.
Count 3 of the substitute information charges the defendant with the crime of assault in the first degree intentional in violation of section 53A-59, paren A, paren 1 of the Connecticut General Statutes. Do you find the defendant guilty or not guilty?
Not guilty.
Clerk, please pause. Again, Mr. Foreperson, Exhibit 10, Court Exhibit 10, your note to the court indicates that with respect to assault in the first degree reckless under count 3 after lengthy deliberations, the jury is hopelessly deadlocked on that charge of a lesser included offense. Is that correct?
Yes, it is.
So you were unable to reach a unanimous decision as to assault in the first degree reckless in violation of Connecticut General Statutes 53A, 59A3 as a lesser included offense under count 3. Is that correct?
Yes, Your Honor.
Thank you. Madam Clerk, please proceed to count 4.
Count 4 of the substitute information charges the defendant with the crime of assault in the second degree intentional in violation of section 53A-60, paren A, paren 2 of the Connecticut General Statutes. Do you find the defendant guilty or not guilty?
Not guilty.
Madam Clerk, please pause. Mr. Foreperson, Court Exhibit 10, the note that was forwarded to the court indicates that at count 4 as to assault in the second degree reckless after lengthy deliberations, the jury was hopelessly deadlocked on the above charge. Is that correct?
That's correct.
All right, so is it correct that the jury was unable to reach a unanimous decision as to assault the second degree reckless in violation of Connecticut General Statutes, section 53A-60A3 at count 4?
Yes, Your Honor.
Thank you. Madam Clerk, you may proceed.
Your Honor, may the verdict be accepted and recorded?
Yes, the verdict shall be accepted and recorded.
This is
Ladies
a big
and gentlemen
win for
of the
defense.
jury, listen to your verdict as it is accepted and recorded. As to the first count of the substitute information charging the defendant with the crime of murder in violation of section 53A-54A, paren A of the Connecticut General Statutes, you say the defendant is not guilty. Is that your verdict?
Yes.
As to count 1 of the substitute information charging the defendant with the lesser included offense of manslaughter in the first degree intentional in violation of section 53A-55, paren A, paren 1 of the Connecticut General Statutes, you say the defendant is not guilty. Is that your verdict?
Yes.
As to the second count of the substitute information charging the defendant with the crime of assault in the first degree intentional in violation of section 53A-59, paren A, paren 1 of the Connecticut General Statutes, you say the defendant is not guilty. Is that your verdict?
Yes.
As to the third count of the substitute information, charging the defendant with the crime of assault in the first degree intentional in violation of section 53A-59, paren A, paren 1 of the Connecticut General Statutes, you say the defendant is not guilty. Is that your verdict?
Yes.
As to the fourth count of the substitute information charging the defendant with the crime of assault in the second degree intentional in violation of section 53A-60, paren A, paren 2 of the Connecticut General Statutes, you say the defendant is not guilty. Is that your verdict?
Yes.
Ladies and gentlemen of the jury, please rise. You heard your verdict as it was accepted and recorded. You heard your verdict being read back as to each of the 4 counts. Is that your verdict? So say you all. Yes. Thank you. You may be seated.
They're polled. It's done. The judge is going to accept the verdict, and Raul Valle cannot be recharged on the charges that they found him not guilty on. He can be retried. He can be retried, and the state's already said, we're going to retry on the lessers.
No, Your Honor. No, Your Honor. They would be seated.
I'm sorry?
But
They would be seated.
Yes, you may be seated.
it doesn't mean that they will.
I, on no request by counsel, the court is not going to hold the jury. So I won't have the claim. All right, ladies and gentlemen of the jury, I'd like to address you. Take a moment. Your verdict has now been recorded. It's been accepted by the court. The court will deal with the outstanding remaining charges once I discharge you, but I want to say a few words to you before I do that. Your oath that you've been obligated to keep during this time, you've been obligated to stay silent, not discuss this case. I am now relieving you of the duty of your oath, so you are released from your oath. It is, of course, up to you to decide whether or not you wish to discuss this case with anyone or your role as a juror with anyone. You certainly have no obligation to do so. And please be aware that any comments that you shall make may become the cause for further proceedings concerning the verdict. I would like to take this time to recognize you and thank you for your very important service, serving as a juror, especially on a lengthy trial such as this. This takes you away from very important other aspects of your life. So I want to thank you for the time commitment that you gave to this case. I know that we originally asked you for a commitment through July 1st, and you have graciously given us your time for a rather extended period beyond that July 1st date. Inevitably, a decision by a jury will gratify one party and disappoint another. It's a very difficult job that you have. It's a difficult job for a juror to be asked to make a decision, such as important ones like this. And I understand, and so does everyone involved, that the decision that you made here today is not an easy one. These are decisions, however, that are extremely important to our society, as well as the individual defendant. We all recognize that it's not an easy one, and we thank you for taking the time to reach the decision that you did reach here today. We're very grateful to you for performing that very important assignment. I want to also thank you for your careful and diligent attention to these proceedings. I know that sometimes it's very difficult to get through evidence. It's not always as exciting as it's portrayed on TV or in the news. You as jurors have to stay alert and awake and dedicated to every moment of evidence that's presented before you. And I constantly remained vigilant of all of you and your attention. And I want to thank you for providing us the attention that you did. So at this point, I want to let you know that you are discharged again from your oath. You are allowed to leave. However, there are documents that we do need to provide to you, and I would also like an opportunity with you to give you those documents with the clerk. I would appreciate it if you would stay back here at the courthouse for a little bit. There are some matters I do need to tend to on the record, but if you would just give us a little bit more of your time just so that I can get you those documents, I would appreciate it, although you are under no obligation to do that. So that's an individual choice. You will be escorted out by the marshal. I will ask that you remain in the room for a little while so we can clear halls and I can clear the courtroom and then hopefully get a chance to speak with you. Thank you.
The jury returns not guilty verdicts hung on the reckless lesser includeds, but not guilty on any of the intentionals. This takes those off the table. It would be double jeopardy were he to be tried on these again. So he cannot be tried on those again. If the state wishes to charge him or to charge him again and try him again, the maximum they can go for is
Attorney Smith, reckless at the end manslaughter. of evidence, at the close of evidence, you moved for a judgment of acquittal on the 4 charged offenses, paying most attention to the murder charge at count 1. The defendant has since been acquitted as to all of those charged offenses in the substitute information. What is your position relative to the motion for judgment of acquittal on those 4 offenses?
Move to
Withdrawn, Your Honor.
So the court's moving that for the record. With respect to count 1, manslaughter in the first degree reckless, Connecticut General Statutes, Section 53A, 55A3, count 2 and 3, assault in the first degree reckless, Connecticut General Statutes, Section 53A, 59A3, and count 4, assault in the second degree reckless, Connecticut General Statutes, Section 60A3. After the jury's inability to reach a unanimous verdict, the court would like to memorialize on the record the following. On day 1 of the jury having the case, after about 2 hours of deliberations, the jury sent a note stating that it was hopelessly deadlocked on the murder at count 1. The court, upon agreement of counsel, instructed the jury to continue deliberating, instructing the jury to review the evidence, discuss and consider the opinions of other jurors, to explain views and listen to the views of others, including the majority, to listen to what the minority had to say, and the minority to listen to what the majority had to say.
She just likes to talk.
Subsequently, after a total of about 5 hours of deliberations having passed, the jury sent a second note to the court indicating that the jury was deadlocked on murder at count 1, not guilty of first degree assault intentional, deadlocked on first degree assault reckless at count 2, with the same indication for count 3 on the same charges, and not guilty second degree assault intentional, deadlocked second degree assault reckless at count 4. Once again, upon agreement of counsel, the note was disclosed to counsel. Obviously, it was reviewed, it was discussed, and I directed jurors to continue deliberating, instructing the jurors to review the evidence, see if any evidence was overlooked or misunderstood, to explain the views and listen to the views of all other jurors. The jury continued their deliberations into the 3rd day. And now, once again, on this 3rd day, after more than 11 and a half hours of deliberations, the court received a note from the jury, now Court Exhibit 10, indicating a partial verdict, and that as to the other charges, the lesser included offenses, that after lengthy deliberations, the jury was hopelessly deadlocked. Due to the jury's inability to reach a unanimous verdict, even after extended deliberations, as to manslaughter in the first degree reckless, Connecticut General Statutes 53A, 55A3 as a lesser included offense at count 1, assault in the first degree reckless, Connecticut General Statutes 53A, 59A3 as a lesser included offense at counts 2 and 3, and assault in the second degree reckless, Connecticut General Statutes Section 53A, 60A3. The court, in accordance with the Connecticut Practice Book, Section 4245, and with no objection by counsel. Counsel, do either of you want to object? I know before you indicated you didn't. Objecting to a mistrial?
No, Your Honor.
All right. Hereby finds it necessary to declare a mistrial as to those offenses and all other lesser included offenses charged to the jury under counts 2 and 3, to which a verdict was not returned. The court does not take the ordering of a mistrial lightly. The court is not ordering a mistrial simply for the sake of ordering a mistrial as a matter of convenience. Rather, the court, based on the history of deliberations as cited herein and the notes provided by the jury, finds that the circumstances make it impossible at this point to reach a verdict fairly as to all parties, and as such, with a finding of manifest necessity in accordance with our rules, does enter the order of the mistrial. I'd also like to take a moment to address everyone. I first would like to address counsel and thank them for their courtesies to the court and to each other during the course of this trial. Also to the family members, all of them, the spectators that have been present in this courtroom every single day. I want to thank you for heeding the court's expectations as to courtroom decorum. I know that this was an extremely emotional trial, and I appreciate the conduct that was displayed continuously throughout this process. Once again, I understand that a jury's verdict will never fully satisfy one side or the other. Not everyone will walk out of here satisfied today. And I apologize for that, but this is the process that we have, and the court believes it to be a fair process. I also want to indicate that my appreciation to courtroom decorum extends to every single member of the media. I think you've portrayed this matter as fairly as possible in the news, and I think that your courtroom decorum here, in following all the rules that were placed on the media by way of court order, have been met with professionalism in terms of your business and your duty to your job. So I want to thank you for that.
You're welcome.
At this time, I'd ask counsel if there are any other matters that the court should take up.
Nothing from the state at this time, Your Honor. Not from the defense, Your Honor.
Lastly, I would like to address Mr. Valle. Mr. Valle, you too have shown respect to the process in terms of your decorum and your behavior and conduct here in the courtroom. You have been acquitted of the 4 charges that were held against you and stated in the substitute information. So at this point in time, I wish you the best of luck moving forward.
Thank you.
Counsel, thank you. Thank you to everyone. Court stands adjourned.
All rise, court's adjourned.
Wow. And he turns around and sees the families, his family and the other families, their huge hug. And now the tears flow. There was a verdict. We got a verdict. This is a partial verdict. This is the sort of thing we should have seen in the Karen Reed trial. Had the judge questioned the jury as to where they stood, this jury understood the very complicated instructions and found areas of agreement after first being hung on the very first charge and saying, and even sending a note to the judge saying, we are hopelessly deadlocked on the first charge of murder in the first degree. That one charge, and they said in the first note that it was 11-1. We don't know if it was, well, we can anticipate now that it was most likely 11 not guilties to 1 guilty. And that they were stuck there. They went back, they deliberated, they spent the extra time.
He was charged with...
Yes, he was charged. They spent the extra time doing the deliberations and talking it through, and all 12 of them came to the agreement after a second note saying they were hung and a third note asking for more, for playback of some testimony. All 12 of them agreed that all of the counts that were intentional, where he was charged and said, you know, you did this on purpose, were not guilty. The facts had not, the state had not proven that case as to that. There was a holdout. Probably we can anticipate about the same level as the other one, because all the not guilties came through. They agreed on that. There was holdouts on the lowest of the charges, the reckless charge on the bottom. That's not intentional. That is, there's no intent there. There's just somebody who felt that there should be some responsibility, but it wasn't on Jimmy McGrath. It was on the 3 assaults. Well, it was on Jimmy McGrath as well. They got reckless manslaughter for that one, but no intentional on that. What I see from this is that the jury listened to all the testimony from the students who were there at Tyler Smith's house and didn't believe them because they testified that it was basically cold-blooded murder. But they did not believe them. All the I don't recalls, the plea deals that were given to the 2 people in the car with Raul. The jury said this doesn't smell right. It's not right. Something's wrong here. Just incredible. And now with this decision, Raul will not face those charges again. The worst the prosecutor can do is charge him again, because now the charges are gone. They're gone. It's out. Now all he can do is say, we're going to charge you with reckless manslaughter, and that would be the most extreme case. And in that situation, he has the same witnesses right? He has the same students that were there on the fight. He has the same medical professionals and police officers. And now, in defense, if that gets raised again, you now have all this testimony where you have all these students, and if they answer differently on the stand, it impeaches their credibility. They're 20-year-old kids now. If they do the round 2, and that happens, say, in the next 30, 60, 90, 120 days, I don't know what the deadline is, if they answer differently, they can be impeached by the defense attorney for how they answered in this trial. I don't think they're going to recharge this. I don't think they're going to try to retry him. This not guilty. He's a free man now. There's currently no charges over his head. The lesser includeds were not listed in the charging documents. They were just listed as for the verdict. So the state has said they are going to refile. They put the court on notice, but they say, well, before I accept that, we're going to release him. So he is released, and it's done. He'll take a plea on the lesser included. I don't think he will. I don't think he will. I think the prosecutor overplayed his hand, possibly overcharged, but definitely overplayed his hand when it comes to the plea deals that he gave out. The sweet deals to the 2 people who did nothing for 6 months and said nothing to help the police for 6 months. And then gave them a complete get out of jail free card. The attorney, it was quite effective. Brittany, I was saying this morning when we had a phone call that I think one of the most effective things that Mr. Smith did, the defense attorney, was when he stood up in front of the jury and said, "Look, self-defense is ugly. It's a mess. This is what self-defense looks like. It's not like, clean cut, just." It's not white and black. It's gray all over the place and question marks. But this is what self-defense looks like. And that must have resonated with this jury. If they recharge and the immunity deals have the kids testify, how does that help the charge? If the immunity deal kids have to testify, how does that help the charge? I don't know. The deal's over. They got their deal. Those kids cannot be charged. So the deal is still in place, but I don't think they have to testify again. Because they're done. This was the trial they had to testify in. So I don't know if they'd want to do this or not. I didn't hear a closing argument. Should I? Yes, you should. Just skip the jury instructions. They lasted for 2 days. A lot of you have made comments about the knife. He's like, but he brought a knife. He got out of the car with a knife. He showed up at the fight with a knife. He did. That is not disputed. Both sides agree to that. But the only question the jury has to ask or answer in this is when he was stabbing Jimmy McGrath and Faison Teal and Ryan Hines and who was the last one? Thomas Connery Jr. When he was stabbing them, the time he was stabbing, what was in his head? And had he met the requirements for self-defense? And they said yes. It wasn't a question of should he have the knife or not. It was he defending himself? And they said yes. These are his peers. These are a jury of his peers from his local area that look at that and say, that was self-defense. That's not guilty. We know they say that was self-defense because the defense stipulated to all the remaining facts, all the elements of that would have to be proved by the prosecution. The defense stipulated to, except they said it was self-defense. So that they had to have believed that was self-defense. There's no other conclusion that can be drawn from that. Do you think the state will go back and reevaluate? I think that what they said today is what they should say. I think they will file the paperwork and then they'll decide if they're going to drop it or not. Wow. If I was on this jury, this is the verdict I would have rendered, says Aaron. That's what the state gets when they rely on kids who all lied. I think we all saw it. I think we saw, and I'd say Raul did as well. Okay, I'm not going to hold him harmless in this one. Him describing the first fight where he jumped the kid and attacked him when he wasn't even the person who was supposed to be in the fight. He was off to the side or behind him, and he cold cocks him from behind and says, I pushed him, when we can see the arms swinging around and the kid go flying forward. Yeah, I'd say Raul lied about that. The jury had to judge credibility, and apparently they gave Raul more so credibility than they did the kids who were at the fight, the many, many kids that were at the fight at the other location. Wow. Stabbing the legs is also a contributing factor that helped defense. I think it did. I was firmly on self-defense for those 3 assault charges, the 2 first-degree assault and 1 second-degree assault. But I have questions. I'm not sure as a jury member I would be able to say not guilty or it was fully self-defense on the Jimmy McGrath. That's a tough one. But I guess if I have questions, I guess that's room for reasonable doubt. And that would be not guilty. It's the outcome I wanted for Apple River case, says Libby. Vivian, thank you very much. This was a tough one. I realize not everyone's happy with the outcome, obviously. I have to give just an enormous shout out to Jimmy McGrath's family, who through all of this, and even before the verdict, have come out and said, we need to heal. We need peace. We don't want anger. We don't want, we don't want retribution. We don't want, let's come together and make the community better at this point. And just amazing work. Let's see, mod chat. Let me look. Okay, thank you. Let's see. That takes us to 4 o'clock. Let me tell you that we started a new trial today with Judge Boyd, and it was this one right here. We've paused. Judge Boyd has her own channel on YouTube. She is phenomenal. I'd love it if one of the mods could get Judge Boyd's channel. I am going to be gone Thursday and Friday. I'm going to be and Saturday. I'm going to be up in Virginia filming an event up there, and it's going to be a lot of fun, hopefully, fingers crossed. It's going to be a ton of work, and hopefully my gear survives the trip. Taking like 7 cameras, including the drone, tripods, microphones, wireless mics, all the batteries, and I have to be off-grid and be self-sufficient for 3 days while we film all that. I've got $600 worth of memory cards I'm taking that are here somewhere. I don't know where they are. We've got a lot on the line, and that's where my brain is right now. I think we're going to give you the link to Judge Boyd and say, I'd love it if you were in her channel. Does she allow chat anymore? I hope she allows chat. Did she turn off chat? Bug Dugger, for Band-Aids and antibiotic ointment for your trip. Better to have it and not need it than need it and not have it. Thank you, Bug Dugger. I appreciate that. Got somebody calling in. 1 second.
Call from
AWOL.
AWOL, you are one of the favored people on this channel. How are you doing?
I'm doing pretty good. Got out of work early, and I'm here with chat. I'm here with you. Thank you for everything you do. Audio is the best. You're the tech master.
Thank you. We were dealing with issues where the court was not sending the audio, so it was a little frustrating. I would like to have heard what happened there initially, but we got the gist of it. So
I just this isn't even involved in it. It is involved in this case. I just want to say this.
Yeah.
We are a community here. We have our feelings, and I think we should just remember why we are all here as a community. We are true crime watchers, trial watchers. We have our opinions, but we have to remember that every defendant is innocent until proven guilty. We can't let the non-evidence sway us into believing that someone is guilty. Yeah. Because if you hold that train of thought on a jury panel, you're not doing your civil duty because you already decided a person is guilty. So in chat, when I see, oh, he's guilty or he's innocent or she's innocent or she's guilty, it's like, wait, you can't have that energy on a jury panel because you already failed your civil duty. Yeah. And as a community, I just want us to say, we've been here for a long time. Everybody take a breath, love each other, give yourself a hug, and everything's going to be okay. And count your blessings and be grateful that we're good.
It will. I think the thing that makes this situation be okay is Jimmy's parents and the family, what they're doing right now. Obviously, the hardest possible thing to do when somebody has wronged you or has taken something that they can't repay is to forgive. And it sounds like Jimmy McGrath's family is seeking the high road there for the community and asking everybody to, hey, well, I've got a spam call. You know what I have to do, right?
Go ahead.
Okay,
Take that call. Take that call.
All right,
Bye.
bye. Hello? 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 Are you there? I tried.
Hello?
Hello?
Arthur, good day. My name is Tony. We're calling you from your choice to getaway. How are you doing?
I'm good. It's a good week.
Good. Anyway, the reason why we're calling you here is that we noticed you had a purchase a package a few years ago, but you were not able to utilize your vacation package. Now, we're not going to charging you here for any kind of reinstatement fee. We're simply adding time and value to what you already have. So we're removing your expiration date, lifting all the blackout dates, and also we're giving you 2 complimentary airfare tickets.
How big is my package?
I'm pretty sure it's 1,500, sir.
I guess that's pretty big. Oh, he hung up on me. Sorry. I've got the 1,500 package, so hung up. Hey, well, I apologize for hanging up. You knew though that was coming. I apologize. We do interrupt everything to take spam calls. Somebody told me to ask that question last time. I probably shouldn't have, but I did. I went there. Let me say this. I'm so proud of the McGrath family for what they've done leading up to this, for how that is helping the community, how that helps everyone moving forward. I do hope that they find the peace that they're seeking, knowing that the hole will never be filled in their hearts. Some just thoughts and prayers for them and for everybody involved in this one, as a lot of people are disappointed with the outcome, and it's not a time to celebrate. This isn't, we're not throwing a party here if we did like the outcome either. So I think lessons learned would be the biggest thing we can do now, and make sure that we don't repeat the same mistake from before. Agony Goose, disagree with the verdict, but justice is justice. Jury has spoken. Enjoy the wilderness. Agony Goose, thank you very much. I appreciate that. I do actually love the wilderness, and I don't like ticks though. So I will be. That's the first thing I'm doing. I'm doing permethrin all over my clothes. Tell the caller you were just found not guilty of manslaughter. You do need a vacation. I was going to get to that. I was telling him I'm literally packing right now, and how soon can I go? But palate cleanser. Josh says, please, palate cleanser. Oh my goodness. Let's see. What's the time on this one, Josh? Hang on. Okay, let's pull this up just briefly, because Josh has never let us down before, right? We might have a palate cleanser for us to go to. Judge Collier, Gulf County Criminal Pretrial Docket. Let's try that again. Judge Collier's Gulf County Criminal Pretrial Docket. This is 14th Circuit. There we go. So we have This is from yesterday. Hang on.
Call from Selena.
Hey, Selena. This is RA. How are you doing?
Good. I just wanted to say about an experience that happened in my hometown that was like this. I've been going to call the whole time, but I haven't. So I had an adult friend that I went to high school with. He and his friends were out west to a party, and they were drinking. There was a fight there, and he ended up shooting his best friend and was charged with first-degree murder. The attorneys got him off for a technicality, which he was extremely lucky. But so my real quick point is, it doesn't really matter what age you are. If you get alcohol and weapons involved, and
they don't mix. There's never a good situation with
no, it could be a tragedy, and this was a tragedy, and this still will never be a not tragedy for my best friend's life and the life that he took. And so anyway, yeah, and I do vote not guilty sometimes, just letting you know. So have a good
Thank you very much.
Have a good vacation.
Thank you.
All right.
All right. We'll see you. Bye.
Bye.
All right. We're gonna go to this palate cleanser, which we'll do here. Let's see. We'll do it this way. Ready? Here we go. We have a little bit of a palate cleanser, which just happened yesterday, which I have to tell you, I've watched already.
We'll recall you, okay?
Which is really good.
DeMonte Haddix.
It's really, really good. I need to move out of the way, though, because he's in the corner where I am.
Mr. Haddix, how you doing, sir? Doing well.
Judge, this is a case that we had filed a motion to compel that the state stipulated and agreed to. And we brought him back today to kind of keep the court aware of where we're at. The case agent for the sheriff's office on this case is working with the authorities in Georgia to get the paperwork, but as of today, we've not actually received the documents. So all I can tell the court is it's a work in progress right now.
That's
and
the
as
defense
soon as
attorney
we
talking.
get those documents, obviously I'll meet with Mr. Haddix and we'll go over the substance of it at the time. So I think it'd be appropriate to put Mr. Haddix on the 8/12 pretrial docket, which is our next available pretrial docket, so we can keep the court abreast of where we're at.
All right.
Your Honor.
Yes, sir.
May I speak?
Sure.
So,
Mr. Haddix, you can certainly speak to the court, but I would caution you, as I have before, that everything in here is recorded, and I would advise you not to speak to the facts or the evidence related to your case.
I mean, but that's the most important part.
Okay.
So
we're recording this proceeding. The prosecutor sitting down right behind you.
I'm
I
fine
think
with that.
Mr. Hill is an experienced and talented trial lawyer. Probably don't want to talk about the facts of your case. If you want to address the discovery issues or any other issues, but
yeah, I want to discuss the discovery issue.
Okay.
So I had my full discovery with me. I done had it since August 24th, and it was submitted to the clerk of courts April. No, I had it since April 24th. It was submitted April 11th, and I have a lot of issues with my discovery due to the fact that it don't talk about me whatsoever, and a lot of the evidence in there has nothing to do with me. So I haven't been able to speak with Mr. Hill. He's supposed to come speak with me a couple of different times, but it ended up never happening. And this motion that he filed that's supposed to be with Georgia, I don't understand the relevance to it at all, because like he stated last time, he is correct. When they came and arrested me, GBI and DOC, they definitely searched my house, but they never came out of my house with anything. I requested the body cam footage in March when I first spoke with Mr. Hill, because a phone that was illegally searched and seized, I requested it. And then it came back up again in April, where I told Mr. Hill about it April 24th, why I wanted the body cam footage. But now, after going over my after going over my discovery, the body cam footage is irrelevant now because it's bigger than a legal search and seize. Now that's not what I'm after no more. Now it was evidence that was planted on me, falsified documents that was made against me with this phone And it proves it because it's in my paperwork. And me and Mr. Hill looked at this subpoena June 17th, 2 p.m. when he came to visit me, and we went over all my evidence. And the subpoena date for the phone where AT&T stated that I was a customer since November 11th, November 1st, 2024. Like I told Mr. Hill, that's impossible, Your Honor. I just sat in prison from December 13th, 2017 to November 7th, 2024. I could not have purchased a contract phone in my name.
This is
In
true.
December 2024?
And November, I went to prison December 13th, 2017, and I sat from December 13th, 2017 to November 7th, 2024. The subpoena results state that the phone was purchased November 1st, 2024. That's
7
impossible.
years.
I was still sitting in the correctional institution. Another thing that's wrong, the phone is in custody. It is in Gulf County custody. The phone is not through AT&T. It's through Boost Mobile. Boost Mobile is owned by Dish Network. So you cannot go to AT&T and get some subpoena results for a phone that they do not belong to. I know this for a fact. I brought all this up to Mr. Hill. I pointed all this out to Mr. Hill. And I wanted to talk about the proper motions that should be filed in my case, but we have not been able to talk about that.
What motion you think should be filed in your
I
case?
feel like I should have. I feel like after we went through this discovery, and it has yet to mention me. First thing we do is a motion for suppressive evidence. There is no evidence against me. I went through everything with him.
But if there's no evidence, there's nothing to suppress.
Right.
So then I wanted to file for a motion dismissal. I feel like, and the reason why I want to file for the motion dismissal, Florida Rule 3.190, because for one, no evidence. Two, illegal search and seize, which I can prove because the phone is not in my name. I told the officers when they arrested me who phone it belonged to. I told Sergeant White when he came who phone belonged to. I told Mr. Hill who phone it belonged to. And I gave them her name the whole step of the way. That is originally why I wanted the body cam footage, to prove that I was telling them that when they arrested me and when they said they had a search warrant for the phone. Come to find out, they never had a search warrant for the phone. They never were supposed to seize the phone and none of that. And that's why I was going for that illegal search and seize. But once I got my paperwork and it stated that Detective White got subpoena results from AT&T, I knew that was to be impossible because the phone does not belong to AT&T. The phone is not in my name. And I read the subpoena result with Mr. Hill, and he wrote to them, DMI Nazir Haddix is a customer, and they sent him results back. That could have never happened. Not only was I in prison.
What are you asking me to do?
I'm just trying to get some actual, I don't know what to do at this point in time. I went over my case. I'm ready to go to trial. I've been ready to go to trial since April 1st when I asked before I got my motion. I didn't need the motion. But now that I got it, I'm ready to go. If they want to go to trial, I'm ready to go to trial. But I know that for a fact, evidence was planted on me, and I can prove that. And I know that is illegal. I know that. And in this case, it shows it in black and white. Everything I'm going off, Your Honor, is just what's in here right here.
Do you think you should wait on the body cam footage?
It's useless. It doesn't show anything besides me getting arrested and telling them that's Veronica Tellez's phone. Oh, we have a search warrant to go through it. Ooh. That's it. It shows the search of the house where they found nothing. Nothing was found.
Mr. Haddix, what? You have the right to a trial, and we'll make sure you get that trial. What I don't want to happen is you show up to trial, and Mr. Patterson, as the prosecutor comes forward, and he has a few witnesses from Georgia, the Georgia Bureau of Investigation and others, and you don't know what they're going to say. You don't know evidence they have because you said you don't need it, and now they're taking a stand saying certain things that you're not prepared for, and then you object, or excuse me, Mr. Hill objects based on discovery violations. And I said, well, Mr. Haddix says he doesn't need that, didn't need that information, he didn't care about it. There's no evidence, so objection overruled, have a seat. I don't want that to happen to you. I want the trial to be fair. You should know all the witnesses that the state may call against you. You should know beforehand all the evidence the state may use against you. You're entitled to that.
I am very well entitled to that. But I figured once my discovery was submitted to the clerk of courts, that was a finished discovery. Now I see if he was requesting the body cam footage for some. That's what we didn't talk about. I don't know why he requesting the body cam footage. all I know is why I asked for it previously, to prove the illegal search and seize. That's why I asked for it. And it was never brought up until we had that conversation. And I was able to point out to him, this subpoena, hold on, wait. I was in prison during this time. That's when our conversation was cut short. He wrote the date down when I got out. He wrote that down. He said he'd get back to me. Never got back to me. Now we come back to court. He said, all right, we're gonna file the motion for the body cam footage. I don't understand why I need the body cam footage. I don't understand nothing that the officers could say against me, because they can't say nothing against me. All they did was arrest me, search my house, give a thumbs up, ask me, do I want to speak? I said no, and they took me to Bibb County Jail. That was it.
That's what you think they will testify to. If the state lists those officers as witnesses, Mr. Hill will have an opportunity to take their deposition. Then he will pin down exactly what they're going to say. I understand your position, Mr. Mattis, but what you do not want to happen is go to trial on some suppositions or beliefs of what you think police may say. And they come in here and take the stand and say something completely opposite of what you believe they're going to say, and you have no forewarning, and then you're jumping up and down in your seat. Crime foul. You don't want that to happen. Give Mr. Hill an opportunity to obtain whatever evidence Georgia has. If it's nothing, it's nothing. Whatever witnesses in Georgia, give them the opportunity to speak with those witnesses. If they don't have anything to say against you, fine. They don't have anything to say. At least when you come to trial, at that time, Mr. Hill, if they take the stand and say something different, Mr. Hill can say, Judge, I took their deposition, or he can impeach them with prior inconsistent statements, or if the state has evidence that they did not disclose and try to use against you at trial, that will be an issue. So allow Mr. Hill to do his job. He does it very well.
I know, I heard.
Yes, sir. Allow him an opportunity to do his job. The issue with the subpoena and the dates, if that's true, I promise you there'll be a jury of 6 to 8 people over there, and Mr. Hill will bring that out during trial.
Okay, and another thing, the last thing me and Mr. Hill spoke on was my right to obtain that speedy trial without a demand. My 175 days is August 17th.
Okay. Mr. Hill knows exactly what to file if there's been a violation of your speedy trial rights. But right now, you just simply let me know what frustrations you have. Correct?
Correct.
Are you asking me to do anything specific?
I just feel like at this point, I don't know, like, I don't really know who to talk to and what to talk to at this point in time. I just know what I'm going off in my paperwork.
You have any type of disagreement with Mr. Hill?
We don't talk.
Well, he told me he's come out to see you in June.
The
He
first time-
may not talk to you as much as you would like, but he's talked to you. One moment. Are you having some type of disagreement with Mr. Hill? Yes or no?
No.
Okay. So what's the next thing? Let Mr. Hill do his job. Mr. Patterson, have you talked to the law enforcement or probation officers in Georgia?
No, I have not spoken to officers in Georgia, but the sheriff's office investigator who worked this case has been in contact with GBI trying to get the copies that were requested by the defense.
Did they provide you with an estimated time they will receive them? That was that.
But I will follow up.
Looks like Mr. Mattis was arrested December 4th of 2024.
No, I was arrested February 3rd, 2025.
Okay, I have a professional offense date. Mr. Hill?
Judge, I can tell the court without divulging too much right now. I have obviously met with Mr. Haddix. We have gone over his discovery, and what I have learned so far is that there's quite a bit going on in this case. For one, what I know that's important right now is that a cell phone ended up in the custody of the Gulf County Sheriff's Office. The agent working this case has said that cell phone belonged to Mr. Haddix. It's Mr. Haddix's cell phone. It's my understanding that that cell phone was recovered by someone with either GBI or Georgia Department of Corrections probation office when they went in there and searched Mr. Haddix's house and arrested him on the warrant for Gulf County. How and where the phone was actually recovered from at the house, was it recovered from Mr. Haddix personally? Was it in the area where he was at? I don't have that information. I know that phone ended up in the custody of the Gulf County Sheriff's Office, and at that time, Sergeant White, the case agent, prepared and got a search warrant for that phone. I believe there are deficiencies with the search warrant for one, based on what I have read in the affidavit, and I have a tentative draft of a motion to suppress the search warrant for the phone. It's a tentative draft right now. There's a lot of different issues with the phone. The search warrant for the phone resulted in a Cellbrite report extraction report being provided, and Cellbrite data. I have reviewed that data, and on the data that we got off the Cellbrite, there is information there that I deem very incriminating in this case. Welcome. So, it's very important that I have this information as to how and where the cell phone come from, so that I can complete this search warrant, the motion to suppress, and get it filed, because, I feel like a motion to suppress is going to be critical in this case at the right time to at least eliminating some potentially incriminating evidence against Mr. Haddix. If I can, it's one of the things that when I file the motion to suppress, I want it to be complete, and I want to file it one time, Judge. I already know there's at least some issues there to be addressed. There may be more issues out there to be addressed as far as how the phone was actually recovered. I hadn't got that far yet. But like I said, I don't know that a motion to suppress the phone would be dispositive of the case, because there is some other evidence out there, but it was certainly it's certainly going to hinder the prosecution's efforts, in my opinion, if evidence related to the phone search is ultimately suppressed. But like I said, it's not one of those cases where I've just been sitting back doing nothing. I have met with Mr. Haddix. There's obviously multiple cases on the docket, so we have multiple allegations. They're similar, but they're multiple cases. All the discovery is pretty much in one case. But like I said, we have a lot of, when you get, obviously the judge has been a prosecutor before, what these Cellbrite extraction reports, there tends to be a lot of data on these cell phones. It's not like something you can just sit down and spend 5 minutes looking through the data. There's photographs, there's text messages, there's videos, and things of that nature on this cell phone that, as I said earlier, I deem it to be incriminating of Mr.
I think my client's
Mr. Haddix in this case. So it's going to be important to address that through a motion to suppress at a later time. Like I said, if we it's just, I can't I can only do so much with where we're at. And like I said, I've not scheduled depositions yet, because like I said, I may need to depose these people in Georgia when it gets down to it. But I don't want to schedule depositions until I know exactly who all the witnesses are.
Absolutely.
And I'm not trying to stall Mr. Haddix's case, but like I said, we've got all these cases and all these counts, and it's something that just takes a little bit of time to go through the nature of the evidence.
No, I agree.
We've got stuff, and it's not only the stuff on the phone, Judge. I have gone over with Mr. Haddix video evidence that was obtained in other areas, other states besides Florida, that show Mr.
You don't need to say.
So we've gone over the case, one of the discoveries.
Mr. Haddix, well, first, we're not doing a Nelson here, because you said there's no disagreement between you and Mr. Hill. You're not attempting to discharge him. It sounds like you just wanted some clarification about where things are. The cell phone in and of itself, you say it's not your cell phone, has nothing to do with you. With those Cellbrite reports, not only all the phone calls, the messages, but also the location data of the cell phone. I'm reading the complaint affidavit. The officer puts in here that the cell phone, well, he says is your cell phone, allegedly, places you in the location. It may not be right. It may not be your cell phone. It may not be true. But Mr. Hill, those Cellbrite reports, you can triangulate the towers to show exactly where that phone was. The individuals in Georgia are critical to that, whether it was your phone or not. If someone comes in this courtroom and said they took that phone out of your pocket and you want to take the stand and say it's not your phone, that's an issue. But if they found a phone in the basement in Georgia or in the backyard, and Mr. Hill takes their deposition and that's where they found it, then your defense may have some footing. Allow Mr. Hill to do his job. I promise you, not only have I been a defense attorney, a prosecutor, and sitting on the bench, Mr. Hill knows exactly what he's doing. He is very competent. Trust him.
We're going to cut right there because I have to wrap it up in the next couple minutes. And that's basically how it ends. It's like, trust your attorney. Oh, that's the wrong music. Sorry. Yes, we had a verdict. All right. I'm sorry. That's it. That's basically how it ends. Trust your attorney. Go to trial. If you've got a case, the jury will hear you out. All right. I have to wrap things up. I've got to pack. I've got to start installing the bike racks and everything else on the car and doing all the bug spray things. I'm so excited. All right, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again. It will be on Monday. Sorry, in the weird corner, I can't see where I'm at, so let's run back to A. There we go. There we go. I'm super excited. Thank you guys for giving me a little break where I can run off and do something fun that I love, other than true crime, which I also love. So thank you for that. It's going to be great. I'm super excited, and hopefully we'll have a good video at the end of it. I might show you some drone footage or stuff of the area. Obviously, I can't show you the participants. It's a private thing, but anyway. Kim R., thank you very much for the super chat. I appreciate that. All of you, thank you very much for sticking with us through this case. We got a verdict before I went on vacation. That was our goal. Thank you for that. Watch the weather reports. I don't want to. It's just going to rain. I've got a poncho, and that's it. So, should I call you every hour? No, my phone. I'll have my phone turned off because I'm using it to film as well. I've got like a whole big gyro stabilized gimbal for it and carriers things. Anyway, you guys have a great weekend. No podcast tomorrow. We'll see you on Monday. Be good. We'll see you. Bye bye.
Because he's the guy.